Well, thank you. Seems like we were just here.
It does.
I think you were. Sounded like a long day yesterday.
It went on. We have there's a Democratic House caucus going on, so I am hoping that a lot of my Senate colleagues and Republicans join us so we can get together our caucus. Thank you, Representative Moriarty, for leaving the good Congresswoman.
Yes. I was watching the time closely.
You're even early. It's impressive.
Aaron is still there.
Good morning, Jeffrey.
Hi, Tom.
Morning, everyone.
Morning.
Hey, Ann.
Morning.
Hi, Judge Walker. I'm Ann Carney. It's nice to meet you.
Good morning. Thank you. Nice to meet you.
It looks like it's 9:30, and I'm just going to check and see if we have a quorum, which we may not have a quorum yet.
I think we have 7.
Oh, yes, I didn't see Representative Newell available as well. Is everyone ready to begin?
Sure.
Yes.
All right. And we are live streaming. Good morning, everyone. I'm Ann Carney. I'm the Senate Chair of the Judiciary Committee. And this morning we are going to start with a judicial nomination hearing for the Honorable Eric Walker. Traditionally, we start our committee meetings with introductions of committee members. And so this morning we will start that way. We do have other committee members who will be joining us in a little bit. They're in other meetings and will come here as soon as they're available. And let's see, I am just going to call on committee members to introduce themselves, and we'll start with Senator Sanborn.
Good morning, Senator Carney. Good morning, the rest of the committee. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. And Representative Evangelos.
Good morning. Thank you, Senator Carney. Representative Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you. Representative Poirier.
Thank you, Madam Chair. Good morning, everybody. My name is Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. Representative Moriarty.
Good morning to all. I'm Steve Moriarty, representing Cumberland and part of Gray.
And Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I'm Rena Newell. I'm the Passamaquoddy Tribal Representative.
Thank you. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and some of Scarborough. And we also have our committee clerk, Supi Panett, and our committee analyst, Peggy Reinsch, and they will be with us throughout the day. And we are here. Oh, Representative Harnett, did you? Oh, I'm sorry. I
Okay.
feel so embarrassed. And I would especially like to call on Representative Harnett, my wonderful co-chair, to introduce himself.
Thank you, Madam Chair. My name is Tom Harnett. I represent House District 83, which is the city of Gardner where I live and the town of Farmingdale. Thank you for all being here today.
My apologies, Tom.
Not a problem.
And so, as I said, we'll begin with the confirmation hearing of Judge Walker. And we have a specific script that we follow in these hearings. And so I'm just going to proceed as planned. Good morning, everyone. This is the public hearing of the Joint Standing Committee on the Judiciary for the purpose of considering the nomination by the governor of the Honorable Eric J. Walker of Belmont for reappointment as a district court judge. Under the law and joint rules of the legislature, the committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons who are present who wish to testify, who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting in the electronic meeting can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and is available to view on the committee's YouTube channel soon after our meetings today have concluded. We'll start with a motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Evangelos for the purpose of making such a motion.
Thank you, Madam Chair. I move that the Joint Standing Committee on Judiciary recommend the confirmation of the Honorable Eric J. Walker of Belmont for the reappointment as a district court judge. Thank you.
And do we have a second, Representative Babbage?
We do. I second the motion of Eric J. Walker for
Thank you.
renomination to the district court.
Thank you. A copy of the statutory requirements for this position is available online and for anyone who would like to request it. The chair now recognizes Jerry Reed, Chief Legal Counsel of Governor Mills, for the purpose of making a statement concerning this nomination.
Good morning. Thank you, Senator Carney and Representative Harnett and distinguished members of the Judiciary Committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and it's my pleasure to be here this morning to speak in support of the nomination of the Honorable Eric J. Walker of Belmont for reappointment to the Maine District Court. Judge Walker is a graduate of Norwich University and holds a JD cum laude from the New England School of Law. He began his legal career in private practice in Lincoln County before becoming an assistant district attorney for 14 years in Waldo, Lincoln, Knox, and Saginaw counties. In 2008, he was promoted to deputy district attorney, supervising and advising 7 assistant DAs and staff. He was appointed to the Maine District Court in 2014 and has presided primarily in Augusta and Belfast district courts during his first term. Judge Walker's expertise in the criminal law has proven to be an outstanding asset to the district court and the unified criminal docket. He also has extensive experience with both the Family Recovery Court and Domestic Violence Court, and has been highly effective in using these programs to bring about lasting change in the lives of those appearing before him. Judge Walker has devoted his career to the administration of justice in Maine, and his hard work and dedication to the district court warrant his reappointment to a second term. On behalf of Governor Mills, it's my pleasure to ask you for your support for the nomination of the Honorable Eric J. Walker of Belmont for reappointment to the Main District Court. And I'd be pleased to answer any questions you may have.
Thank you very much, Mr. Reed. Committee members, are there any questions for Mr. Reed? Not seeing any. Thank you very much. The chair will now recognize John Hobson, who is the chair of Governor Mills Judicial Selection Committee. Mr. Hobson, you may proceed and welcome.
Thank you very much. Senator Carney, Representative Hartnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee. On behalf of the Judicial Selection Committee, I request that this committee act favorably on the renomination of Judge Walker. In analyzing Judge Walker's performance, one of the criteria that the committee uses in a judge is taking a look at what their experience had been prior to going on the court, and then what they've done in terms of filling in areas that had not been within their experience. And Judge Walker, no surprise, with an extensive background in criminal law, was natural in terms of criminal law and is able to do his jobs efficiently and well. But what really stood out to the Judicial Selection Committee was Mr. Walker's really almost attacking in terms of the knowledge of the family law area and really mastering it, and basically welding that and combining the knowledge that he gained in terms of family law with really an empathetic and sympathetic approach that he is known for becoming very, very good with both not only pro se litigants, but in the family law area, basically being a listener. As you've heard any number of judges say, one of the big qualities that comes with the job, and some people are surprised by this, is just being able to listen. And candidly, that can try one's patience at times, but Judge Walker has apparently a large reservoir of patience, and he's able to work with families and be very effective. You heard Mr. Reed talk about his work with the Family Recovery Court. He was involved with that court in Augusta, and now he is not in Augusta. He's in Waldo County. But as a testament to Judge Walker's kind of commitment to the family law area, he continues to work with the Family Recovery Court in Augusta. Mr. Walker has really been a credit to the Maine bench. He's certainly an asset for the Maine people, particularly in the difficult issues that arise in family law court. And his really is not only warrants renomination, support for his renomination, but this committee would be doing the people of the state of Maine a great service by returning Judge Walker for another term as a district court judge in the state of Maine. And therefore, on behalf of the committee, I request this committee act favorably on the nomination of Judge Walker. And of course, I'm happy to answer any questions the committee may have.
Thank you very much, Mr. Hobson. Committee members, does anyone have questions for Mr. Hobson? I'm not seeing any. Thank you very much. The chair now recognizes the Honorable Eric J. Walker for the purpose of making a statement concerning his nomination. Welcome to the committee, Mr. Walker, Justice Walker. Judge Walker, excuse me.
That's all right. Thank you. Thank you, Senator Carney and Representative Hartnett and other esteemed members of this committee. My name is Eric Walker and I live in Belmont. I am honored to be here today to have you consider my renomination as a district court judge for the state of Maine. I want to begin by thanking a few people who have helped make this day happen for me and my family. I would first like to thank Governor Mills for placing her trust in me and renominating me for this position. I would also like to thank Governor's Counsel Jerry Reed, who has worked with me through this process and has been so helpful. I would also like to thank John Hobson and the members of the Judicial Selection Committee for their consideration and their support of my application. I would also like to thank all the hardworking clerks, marshals, court reporters, judges and justices, and other members of the judicial branch family for their friendship and support. We have some amazing people working in the courts all over Maine, and we are blessed to have them. But most importantly, I want to thank the many members of my large family and groups of friends for their love and support over these years. Yes, I am a judge, but that is my job. It is not who I am. I am a husband of 22 years to my amazing and supportive wife, Susan. I am a dad to my 3 great kids, Allison, who is 22 and is recently started working as a full-time teacher in Saco. My middle child, Christina, is 20 years old. She is a junior at Colby College, majoring in neurobiology, which is something I can't even comprehend. And I also have my youngest son, Tommy, who is a senior at Belfast High School and just made a decision this week to begin studying as a freshman at St. Anselm College in Manchester, New Hampshire this fall. I am also an adopted dad to 5 previous exchange students that we have had, 2 from Italy, 1 from Germany, 1 from Brazil, and 1 from Poland. I am also a son to my mother, Kathy Walker, and my late father, Charles Thomas Walker, Jr. I grew up in Jefferson, and I come from a large extended family. I am one of 5 Walker children. My wife is one of 8 Johnstone children. And my family has been by my side throughout this sometimes wonderful, sometimes stressful, sometimes joyful, sometimes exhausting career up to this point. The life of having a dad or a husband or a son who is a defense attorney or a prosecutor or a judge is not an easy one. There are several sacrifices that come with this job or these jobs, but my family has been with me every step of the way, and I love them very much for that. I have learned a great deal in the last 7 years since my first appointment to the district court. I truly never knew just how much work district court judges did in the courtroom and behind the scenes. As a trial attorney, I only saw a small portion of a judge's caseload. As a new judge, the variety of cases we handle every day was very surprising to me. One day, you may be scheduled to have a docket of criminal cases or all-day divorce or a DHS case, but in that same day, you are likely to deal with requests for arrest warrants, search warrants, blue papers, which are involuntary committals, protection from abuse, protection from harassment cases, to just name a few. The work never stops, and the variety and amount of knowledge needed was very intimidating and overwhelming at first. As a judge, you are expected to be knowledgeable in so many areas, and people are counting on you to get it right every time. I have tried to remain calm and respectful to all the people in the courtroom, even when they haven't been as respectful or understanding to me. We count on our judges to be polite and composed and, above all else, fair. I have done that to the best of my ability in the last 7 years. My first 6 years as a judge were spent in Augusta District Court. I was the regional scheduling judge for Region 4 for 5 of those 6 years. This job required coordination with another Superior Court justice, that was Michaela Murphy, in Augusta mainly, and arranging various judges' schedules and dockets in not only Augusta, but also in Waterville and Skowhegan. Now that I'm assigned to Belfast, I am also the regional scheduling judge here in Region 6, working with Justice Dan Billings, in charge of scheduling dockets and schedules for judges in Belfast, Rockland, Wiscasset, and West Bath. And I will just add that Justice Billings and I coordinate and talk and text and email and every day. And we've done that for the last 9 months that I have been here in Belfast. A lot of it revolves around numbers, around COVID numbers, and how they're going to affect our courts. But that is an everyday process that we are working on, trying to get a handle on the way things need to be run in this new world with COVID. During my time in Augusta, I handled all types of dockets and took on some very challenging and high-profile cases. I presided over about 16 criminal jury trials. That was more than most of the district court judges in that region. I also presided over the Augusta Domestic Violence Court. This was a court that handled about 30 or 40 domestic violence offenders for about a half-day session of court every month. The goal was holding offenders accountable and making sure that they were meeting their treatment goals. I've also been on the State Federal Judicial Council for the 2 of the last 3 years. This is a group of state and federal judges and magistrates that meets periodically to discuss various issues and to exchange ideas on making improvements in our various courts. I've also been a member of the New England Regional Judicial Opiate Initiative. It's also called the New England RJOI since March of 2019. I have also been a co-chair of the Evidence-Based Programming Committee for New England for the past 2 years. This group meets monthly to discuss various strategies in dealing with the opiate epidemic throughout New England's courts. But undoubtedly, my proudest accomplishment in the last 7 years has been my role in presiding over the Family Treatment Drug Court, which is now called the Family Recovery Court in Augusta. When I relocated to Belfast in July of last year, I made it clear to the chief judges that I wanted to remain with that court. Quite frankly, I love presiding over that court. This court helps parents and indirectly their children after the Department of Human Services has removed children because of various concerns. These parents are usually dealing with many other issues other than just addiction to drugs or alcohol. These issues include homelessness, domestic violence, mental health issues, job training and job placement, education, and many, many more issues. For these parents, a silent clock is ticking for them to get their issues straightened away, or they can face the possible loss of their children through the courts. The consequences of failure are enormous. This court doesn't help every parent or every child, but it is a huge help to many. Simply put, this court helps save lives, and I mean that literally. We have had 2 overdose deaths in people that have joined my court in the last 7 years, and I think about those all the time. One was a graduate from our court. The other had left the court voluntarily and passed away after an overdose. Those deaths stick with me, and I think about them quite a bit. I will just say this is the one thing that I have done as a judge that I am most proud of. It is the one part of my job where I feel I can truly make a positive difference in people's lives. This court is nothing like an adult criminal drug court. Participation is completely voluntary. There are no sanctions. This court is about offering help, advice, and encouragement to parents in need. Many of these parents have never had much help or encouragement before in their lives. Reuniting children with their parents in a loving and safe home is my greatest reward. I have presided over many court sessions now where the department dismisses their case because the parents have changed their lives for the better after many, many months of hard work. It is amazing to see and to experience as a judge, and anyone else in the courtroom can testify to. Finally, I have been blessed over the years to have worked with many talented district court judges, superior court justices. These men and women have treated me with respect and taught me well, and now I am proud to call them my colleagues. I am currently training and mentoring some new judges and giving back from what I have learned. Having good judges in courts around Maine only helps give Mainers confidence that justice is being done efficiently and fairly. This can only be a positive thing for society as a whole, in my view. And I am confident that I have grown as a district court judge, and I have learned a lot in the last 7 years. I'm equally confident that I will learn much more in the next 7 years, and I respectfully ask for your vote of approval, and I would be happy to answer any questions that you might have of me at this time. Thank you very much.
Thank you very much, Judge Walker, for your comments this morning. Committee members, are there questions for Judge Walker? Representative Harnett?
Thank you, Madam Chair. Thank you very much, Judge Walker. I truly appreciated your comments, particularly as they related to the Family Treatment Drug Court and your desire to stay with that even after you were relocated to another geographic court. Is that something you knew you were going to take to? I'm just curious as to how that developed to be seemingly the most important thing, or that you've done as a judge and that you're most proud of.
Honestly, when I was assigned after our training in 2014, I had never really heard of a family treatment drug court, let alone seen one. These are confidential, so these are not open to the public. And so I could never have seen one as a prosecutor. And my first impression when I watched it, I took over for Judge Dobson in Augusta. And it was like nothing I had ever seen before. There was a candy bowl in the courtroom by the podium where the participants would come. And these people would come up and they would talk about their lives in great detail. And they would talk about the things that are going well and the things that are going not so well in their lives. They would open up about lots of things. And there was a lot of positive reinforcement. And these people would be sometimes celebrating 30 days of sobriety or 60, 90. I mean, some people even months of sobriety. They were being drug tested routinely. And there was a lot of applause. There was a lot of patting on the back. And at first I called it, my first impression was it's cheerleader court. It's very positive. And so I didn't quite know what to make out of it initially. And but the more I watched it, I was a little skeptical at first. I will just tell you that. But the more I watched and the more I became involved, and I don't think they knew what to make out of me. I'll just be honest with you. When I came there as a former prosecutor for 20 years, I think they were very skeptical about me. But I watched it and I learned and I listened and I started to understand it was working. And I had been dealing as a prosecutor for 20 years with the frustrations of drug addiction and watching that and watching people come back to court over and over and over again, and nothing seemed to be working. And then when I saw this, and I saw this actually having an effect and working and helping people, I started to realize that this was important. And that's why I've really come to love it. I will also just add one thing. We have 3 courts like this in Maine. We have one in Lewiston, one in Bangor, and one in Augusta. I think some of the other judges, not every judge is appropriate for this court, and not every judge presides over their court the same way. But I am very open with all these people in my courtroom about myself and my life. I talked about my father's alcoholism and growing up in a house with that issue. I talk about my sister-in-law, who is a graduate of Judge Mitchell's drug court in Machias. She was an opiate addict for about 15 years. And my family was convinced that we were going to get a call some night that she had overdosed and died. And so she has been sober now for about 3 years. She's doing fantastic. So I'm very open with them. I talk about my wife and her career. I talk about my kids. I open up about my life. And I don't think there's a lot of judges that would be comfortable doing that. But I think it's important that we build that relationship with these clients. For them to trust me and to take my advice seriously, they need to understand that I get it, that I'm in there with them, that I can relate to them somehow. And for them to share all this information with me, I think I need to share something with them. And if I can get that buy-in, then I can get them to want to change and not disappoint me personally. And so I found it very effective. And I think we've done some great things with that court in the last 7 years.
Well, thank you very much, Judge Walker. Your dedication and commitment to this it's a wonderful thing to witness. I appreciate your answer and thoughtfulness. Thank you.
Representative Evangelos?
Thank you, Madam Chair. Good morning, Judge Walker. Along the lines of Representative Harnett, I have attended a couple of the graduations at Kennebec County, and that type of work is extremely rewarding, and you're doing a great job. I just had a quick question of clarification. I think I know the answer, but I just want this out on the public record because people have written me. To be clear, you are not Judge Lance Walker, correct?
No. And we're not related in any way.
He's a federal judge, right?
He is. He was a district court judge, and he and I were a group of 5 district court judges that were sworn in back in 2014. But then he quickly became a Superior Court justice and then went to the federal bench.
That's
So
what I wrote the people back and I said, I think you got the wrong person. So thank you for that clarification. And that's all I have, Madam Chair.
all right, thank you.
Thank you. Representative Moriarty?
Judge Walker, I am in a position where you may have been at the start of your career and not knowing a great deal about the Family Treatment Court. And so I'm wondering, are those who participate doing so voluntarily, or is it a special condition of a criminal offense and part of constructive punishment or something of that nature?
Yeah, it is not a criminal court in any way. It's totally different. These are parents that have been referred to the court many times by either their attorney or their DHS caseworker or guardian ad litem, something like that. And so they come to the court voluntarily. They are not imposed on this court. And so some of them do have criminal charges pending, but many do not. They are in my court because they were at risk of losing their children to the court through the court system with DHS. And so, like I said, they have that ticking clock. It's about a year time frame where they have things to get straightened away. And there's so many issues that they have many times. And we have a caseworker who works with them, who drug tests them. And beyond that, they work with them very closely and trying to get them employment, try to get them housing, try to get them help with the counseling, not only substance abuse counseling, but also other types of counseling as well. And so it is strictly voluntary. And there's really no downside to going into the court. The worst that happens is you just simply, you can't make much progress, and you can always leave if you want to. So I don't think there's a downside, but it's meant to be a positive in these people's lives, not a negative.
Okay. So if it's voluntary, then it really doesn't resemble a traditional court in that respect, at least.
No, you're right. It's nothing like any other court I've ever seen.
So I have to follow up. If that's the case, what is your role as a judge in such a court?
That's a good question. I am there to try to encourage and nudge and push and try to make any type of progress to get these people to do well in as far as staying sober or getting housing or education or whatever. And I could do my best. I mean, to push them and to try to make them not disappoint me. And so sometimes that black robe can make a difference. People will sit up and take notice and take you more seriously and not want to disappoint you. And so I think that's a big part of it. And so, I do sit on the bench and people, before COVID, we had people in the courtroom and they would come up before me and we would have just a face-to-face conversation. But a lot of times I think it's just they don't want to disappoint. But a lot of these folks have never had any encouragement or any positive feedback. And so when I'm complimenting them, when we're clapping for them, or we're encouraging them, a lot of times they don't know how to deal with that. They've never had that kind of thing happen before. And so just that it sometimes is enough to get them going and to get them started. And so you start building sobriety days and start doing well. And we give these people certificates many times. We give them other rewards such as gift cards for maybe some clothing or some food or maybe even just taking the kids to McDonald's for a Happy Meal. And so, they respond to it and they do really, really well a lot of times. Not everyone is going to be saved by this court, but a lot, I think, can make some real progress because of it.
Well, that's very informative. Thanks very much.
Thank you.
Representative Babbage?
Thank you, Madam Chair. And Judge Walker, I very much appreciate the detail of your story and the evolution and education that you've experienced and your commitment to a wonderful and inspiring job that you have been doing. I wanted to ask you about, you mentioned the 3 family recovery courts. And I was interested in the population being served and the geographic reach of that. Can you comment on that?
Yeah, it's interesting because transportation is a big issue for a lot of these folks to get to the courthouse. And so many of the people in Augusta that I have are coming on KV CAP or some other public transportation. So we do serve the greater Kennebec area, but we generally don't go too much beyond that. I have had some people who have moved outside of Kennebec County, say to Rumford. And I would sometimes ask, that's a long way from Rumford to Augusta for this court. Maybe you should be better served by going to Lewiston. And they would say, no, I want to come to Augusta. That's where I started. That's where my resources and family are. I want to go there. So there's only 3 courts. My hope is at some point in the future that there will be many more throughout Maine, and we can serve a bigger population. But I think what's been holding that off is just there hasn't been a lot of data statewide about the effects of these courts. I mean, I can tell you that I'm encouraged by them. I think they're doing really well, but we don't have a lot of data here in Maine. I think nationally they've started gathering data about family recovery courts or family treatment drug courts nationally, and I think they are showing that they are a positive, and they really do help a lot of people. But I don't think Maine has a lot of data specifically with our courts here.
So an adult drug court, I know that proximity, because there's monitoring that goes on, and the proximity to the court is important as far as housing and things of that sort.
Right.
That doesn't hold true with family recovery in the same way.
No.
And my last question really would be, what about where I am, constituents down here in York County? Do they have different resources to cover the same services?
I'm afraid I don't know. I mean, the closest court would be Lewiston for the family recovery court, but that's a long way to travel from York County up to Lewiston to participate. I do wish that there were more of these courts around the state. I think they would help a lot more people. And
well, thank you very much, and I'm very much impressed by your story. Thank you.
Thank you.
Committee members, are there any additional questions for the nominee? I'm not seeing any hands raised. Judge Walker, I just wanted to say that we hear a lot from the nominees that they like their roles as in the judicial branch because they learn something new every day. And we have learned a lot from you. And I just wanted to express appreciation for how much you've taught us this morning. Thank you.
Thank you. I will say that last year I did address a group of guardian ad litems by Zoom. And I'm doing that again on Tuesday to try to educate as many people and encourage them. And many of these guardian ad litems are attorneys that represent parents in other matters as well. And to try to educate them and encourage them and let them know about these courts so that they can refer more of their clients to them. So, I'll be doing that Tuesday next week during our admin week.
Thank you. Thanks for letting us know and for letting the public know, those who are watching on YouTube. We appreciate that.
All right, thank you.
And I'm not seeing any additional questions for the nominee, so we will move to statements from the floor. The chair will now take comments from persons who are attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have the opportunity to respond to the written comments. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by me, at which time they will be promoted to panelist status in our electronic meeting and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position shall be considered in order. All other comments will be considered out of order. And after you are done speaking and there are no more questions from members of the committee, you will be returned to attendee status and the next person will be called. And at this point, I will recognize the first person who would like to speak in support of this nomination, and that is Courtney Allen. And Ms. Allen, you may proceed when you're ready.
Thank you, Senator Carney. Good morning, everybody. Good morning, Senator Carney, Representative Harnett, and other esteemed members of this committee. My name is Courtney Allen, and I am the Policy Director for the Maine Recovery Advocacy Project, a grassroots movement of people working across the state of Maine to redefine and reimagine justice, access, connection, and recovery. I'm also a graduate student at the Muskie School of Public Service and serve on the Augusta City Council as an at-large councilwoman. All of these roles bring great joy to my life, but my favorite is being the mother of my two sons. Today, I'm here to testify in favor of the reappointment of Judge Eric Walker as the District Court Judge, and in particular as the judge who oversees the Kennebec County Family Recovery Court. I first met Judge Walker on February 28th of 2015. I remember the exact date because it was my youngest son's 3rd birthday, and I was not allowed to see him. My children had recently been removed from my custody by the state due to the active nature of my substance use disorder and other related behaviors. They would not let me see him because I was not maintaining abstinence. At that time, I did not have the necessary tools to do so: safe housing, transportation, recovery support services, case management, or treatment. Walking into Judge Walker's courtroom on that day, I could not fathom how this was going to help me. At this point in my life, I'd had a lot of interactions with courtrooms, being in and out of state custody as a child myself, and later interactions as an adult. There was one thing I knew for certain about courtrooms: nothing good happens in them. But on this day, in this courtroom, Judge Walker greeted me with a soft smile. He spoke with a sense of understanding and wondered aloud about my children. What were their names? How old are they? Are you getting to visit them? My hands were unsteady and my voice shook. And he responded with his famous line: "This is your chance to brag them up, Courtney. I know you want to." This gave me a sense of ease, and I poured my heart out. I told him about Wyatt. He's quiet and highly intelligent. Eamon is loud and thoroughly a redhead with a temper to match. I missed them. I wanted them to come home, and I had been trying so hard. He nods. I tell him about my job waiting tables at the local ice cream parlor. I've been there for 6 years. My boss is supportive of me, but I just don't make much money. I can't afford anything else, and I worry about resuming use. I'm scared of my neighborhood, but I can't move. I worry about resuming use. I don't want to use drugs. I just don't know how to stop, and I don't have access to the things that I need to do so. He reassures me that the team will be there to support me if it happens, and they are. Over the course of the next year, Judge Walker and the Family Recovery Court forged a blend of compassion, patience, and a bit of tough love, with an unshakable belief that my shattered self could become whole, giving me the space to do just that. January 28th, 2016. Judge Walker steps down from the bench, giving us all a hug. His soft smile reminds me of our first day in court. This time, though, the smile is one of pride, and he grants me full custody of my children. It's been over 6 years since I first met Judge Walker, and in that time, I've gone from a 7th grade dropout to halfway through a master's degree, from having trouble paying my own rent to thinking about buying my own house, and from low-end jobs to the policy director making a livable wage. I've served as an intern in Senator King's DC office, opened and closed recovery residents, run for local office and won, and helped to build out new systemic responses to drug use. But the most important thing that I do every day is I show up being the mother that I was always meant to be. It would be really easy for me to come before your committee and tell you that all of those things could be accredited to the fact that Judge Walker and the Family Recovery Court saved my life, but it's not true. Recovery from substance use disorder and the other things that happen after are just not that simple. Entering and sustaining long-term recovery requires a full response from every single system of government and from every person who touches the lives of somebody with a substance use disorder. It would be unfair to me to say that one particular program or one particular person was the cause of my recovery. It has taken many hands. Judge Walker was a critical set of those hands in my journey. And that is why, with great pride, I testify before your committee today and ask you to reappoint him as a district judge and to allow him to continue his work to play an important role in addressing the opiate crisis. I'm happy to answer any questions. Thank you.
Thank you, Ms. Allen. We are really grateful for your statement here this morning. And the next step is for committee members who have questions to ask you questions. So I'll turn to the committee. Are there any questions on the part of committee members for Ms. Allen? Representative Harnett?
It's not so much a question, Madam Chair, as just a word of thanks for coming here and sharing your story today and your interaction with Judge Walker. Very much appreciated.
Do other committee members have questions for Ms. Allen? I'm not seeing any, and I just wanted Ms. Allen to also join in Representative Harnett's thanks. We appreciate all you've done and that you shared it with us this morning. Thank you.
Thank you to the committee members. Have a good day.
Thank you, Courtney.
I'm just gonna check. Oh, okay, we have our next speaker. Pamela Ames has joined us to speak in favor of this nomination. Ms. Ames, welcome very much to the Judiciary Committee. And when you're ready, you can activate your camera and you have already done so. You're a pro. You were before us yesterday. You can proceed.
Thank you very much. Yes, I finally learned which buttons to push, so that was good to do it yesterday, and then I can be back. My name is Pamela Ames, and I live in Sydney, Maine. And as I said yesterday, I won't go into a long introduction, as most have probably heard it, and I know Judge Walker knows it. But I recently retired from the practice of law after 40 years. I was blessed with 13 years as a prosecutor in the district attorney's office and the attorney general's office, and then the next 27 years in private trial practice, predominantly in Kennebec and Somerset counties. My main practice as a solo practitioner was in criminal defense law, as well as civilly, as domestic relations, child protective matters, also as a parent's attorney and as a guardian ad litem. I am very proud to say that I walked or was participating with Courtney Allen throughout her superb process through the Family Recovery Court. She is a star, and she worked very, very hard, and everybody did. And I'll address that with Family Recovery Court with Judge Walker's just exemplary leadership in that role. As a trial attorney, I think there are two main concerns that we have when a career prosecutor gets nominated and appointed to the bench, whether that be district court or superior court, but particularly in district court. I think the two concerns are, first, can the district court new nominee and judge transfer the knowledge of criminal statutes, criminal procedures, rules of evidence, which are absolutely ingrained in prosecutors? Can that be transferred to the civil arena? And can they address especially domestic relations and child protective matters? Can they listen to that new aspect of family life, addiction, and apply the new standards of child protection or domestic relations to that whole new world? The second is, can a former prosecutor be as a criminal judge without bias or prejudice, either for or against prosecutors or defendants? I'd like to take the first. Can a former prosecutor transfer that knowledge, intimate knowledge of trial work into the civil arena, not only in trial work, but in kind of extracurricular trial work? Judge Walker is superb at that. He lets people know what his family life is like and how he can identify with the issues that are in front of him. And that makes all the difference in the world to the clients and to the participants, the witnesses, everyone, that this judge listens to them and has an understanding of what they are saying to him. The family treatment drug court is what I knew it as, now family recovery court. It does save families, and the stakes can't be higher in that court. The department oftentimes is taking children away, and that's just traumatic to anyone. But in Judge Walker's court, it is a lifesaver. And I know we have lost a couple of members, but there was everything that could be done to save. And he does save lives. He saves families, but more, he saves lives. Most of these people have never had a positive experience with an authority figure. Like Courtney Allen said, nothing good happens in court. That's how a lot of these parents view the court system. Nothing good has ever happened to them with a judge. Nothing. They've always been on the losing end. And they go to family treatment court with a lot of skepticism. And I think there was a lot of skepticism of Judge Walker, as it would be with any judge. But he quickly overcomes that. He talks to them like real people. And I've actually seen people get a candy bar, and the members of the committee and the public may think that's stupid. You could go out and buy it for 25 cents. You know, I mean, it's got Halloween candy and Easter candy everywhere around now. But the fact that they get to pick a candy bar out of a candy bowl because of something that they did that week is momentous. It's like winning the lottery. And the first time they get to pick a candy bar, you can just feel it in court of how proud they are of the candy bar. But that translates into big decisions in their lives, and they use that experience. His impact on the recovery court has just been tremendous, and I am so happy that he is still there. It isn't for every judge. It simply isn't. There are just some that do not have that ability to open up and have the constant ups and downs of that court, because it is usually very hard. I was there when Courtney Allen got full custody of her 2 boys back. There wasn't a dry eye in the place. We were all in tears, but it was happy tears. It was one of the few times when people cried that was because of positive, not negative. The second part of it is, can a former prosecutor be in criminal court? Can they use that experience? And I talked with a number of prosecutors in Kennebec County, and they were scared to death that Judge Walker was going to be anti-prosecution, that he was going to go the other way and he was going to bend over backwards to be pro-defendant. And I talked with defense attorneys who said, oh my God, he's been a prosecutor for 20 years over in Waldo County and that whole district. And he's never going to give a defendant a fair shot. He's going to be way too much of a prosecutor. He's going to fall back on that. And I will tell you that neither the prosecution nor the defense attorneys were correct. They were not. They were dead wrong. Judge Walker is not pro-prosecution. He certainly holds them to a standard, which they need to be held to a standard. You can't just rubber stamp what the state, is asking for, both in felony guilty pleas or sentencings or trials. He is an excellent trial judge. He sits there, he treats everyone fairly. There was one experience that I had, was a very, very difficult sentencing. And as the committee probably knows, the sentencing guidelines are all over the place. You've got nature and seriousness of the crime, not to diminish that, to have restitution, victim impact. Then on the defense side, you have the acknowledgement that incarceration only promotes more criminology, and the goal to rehabilitate defendants so that there's not repeated behavior. And that's hard. There's no straight guidelines for that. It's not like a rule of evidence. It's not like a criminal statute. It's you've got to rely on a judge's integrity to balance those competing factors. The case that I had was an hour-long hearing that we had on an aggravated assault where the individual had pled guilty, and we went directly into sentencing. After the sentencing, I listened because the courtroom was packed. It was a dispositional day. There were probably 20 attorneys. There must have been 50 people in the courtroom. That's when we had people in the courtroom. So you could tell how long that was ago. But I listened about what did people think about what happened in this courtroom for the last hour. And the comments that I heard, and I remember them to this day. The first one was, what a smart judge. And I'm like, oh, okay, I knew that, but I didn't know, other people did. The second one was, what a great listener he was. The third one was, what a compassionate judge. He cares. And the final one that we had was, what a fair judge. It's ironic that in like our school system, if you got a fair grade, that's really kind of not very good. Oh, gee, you did fair on the test. You did fair in your grade. But getting a grade of a fair judge is the very best grade I think you can give a judge. The people respected the questions that he asked, the comments that he had, the comments that he applied, his decision-making that he gave right from the bench. That impressed everyone, attorneys, spectators. I think everybody that walked out of that courtroom that day learned something from Judge Walker. They learned they could go to court and be treated fairly. And I don't think that there is any better way to educate anyone in the state of Maine, but to have them attend Judge Walker's court in those types of contested matters. He is a fair judge, and he certainly should be able to continue to contribute that fairness. And I would strongly ask that this committee recommend the nomination for the reappointment of Judge Walker.
Thank you very much, Ms. Ames. Committee members, are there any questions? Not seeing any. We appreciate you being with us this morning and sharing your comments.
Thank you very much to the members.
And the next presenter we have is Chris Lewis, and he has just joined our panel. Mr. Lewis, you can activate your camera and your video your video and your audio and proceed when you're ready. Mr. Lewis, are you able to, oh, there we go. Sometimes the transition takes a few minutes.
Sorry about that, Senator Carney.
That's okay. Welcome to the committee. We appreciate your being here today, and you can proceed with your comments.
Thank you very much. Just to introduce myself, my name is Chris Lewis. I'm the immediate past president of the Maine Trial Lawyers Association. I'm here on behalf of the organization to support the reappointment of the Honorable Eric Walker to the Maine District Court.
Mr. Lewis, I'm sorry to interrupt you. Could you please also provide us with your town of residence? That's one of the requirements. Thank you.
Absolutely. Thank you, Senator Carney. My town of residence is Cumberland. I am a constituent of Representative Moriarty, and I'm here to, again, to support the reappointment of the Honorable Judge Walker. Senator Carney, Representative Harnett, and members of the Judiciary Committee. I would like to offer a quick description of our process. Our organization represents over 600 trial attorneys in the state of Maine. We submit a survey to our membership and ask for them to provide both numerical answers and on a highly favorable to unfavorable rating, and also written answers, written comments if they wish. Our executive committee then reviews those results and add any experiences we may have personally or amongst our board. And this testimony today is meant to reflect the consensus of that process. Our association's survey members overwhelmingly rated Judge Walker highly for his experience, temperament, skill, and judicial demeanor. Respondents called Judge Walker a very good judge and lauded his efforts to help those fighting addiction. In assessing these surveys, our executive committee noted Judge Walker's more than 20 years of practice, including 18 years of public service as a prosecutor for the state of Maine. Based upon the high evaluations of our members and his extensive experience, I'm proud to endorse Judge Walker to the Maine District Court on behalf of the Maine Trial Lawyers Association. We believe his continued service will bring honor to the bench and the people of Maine. I'm happy to answer any questions the committee may have.
Thank you very much, Mr. Lewis. Committee members, are there any questions for Mr. Lewis? I'm not seeing any. Thank you for presenting your statement to the committee this morning.
You're quite welcome. Thank you for allowing me to be here.
You're welcome. And that brings us to Kelly McDonald, who is here, I believe, on behalf of the Bar Association. And Mr. McDonald, you can up there. You have appeared on our panel, and you may proceed when you're ready.
Thank you so much, Senator Carney, Representative Harnett, and members of the Judiciary Committee. Thank you for letting me be here with you today. My name is Kelly McDonald. I'm a resident of Portland. I'm a lawyer at Murray, Plum, and Murray in Portland, and I am the current president of the Maine State Bar Association. As this committee is aware, the Maine State Bar Association surveys its members, much as the Attorney Lewis's organization does, whenever a judge is up for renomination. I am here to report to you that our members overwhelmingly like Judge Walker, and that we are supporting his renomination to the bench. A summary of some of the comments that we received about Judge Walker are: attorneys describe him as an excellent jurist who conducts himself with a judicial temperament that befit the dignity of the court. He's known to be understanding of the human element of the matters that are before him, but he's still firm and he holds litigants and attorneys accountable. Our members also describe him as being intelligent, helpful, good-natured, patient, and fair. He is commended for his knowledge of the law, especially in family-related cases. All of these traits have earned Judge Walker the support and respect of the Maine State Bar Association's members. We believe that Maine citizens will benefit from his continued service on the Maine District Court, and we ask that this committee give its unanimous support to his nomination of Judge Walker to the Maine District Court. Thank you so much for taking the time to hear me today. I'm happy to answer any questions that the committee might have.
Thank you very much, Mr. McDonald. Committee members, are there any questions for Mr. McDonald? I'm not seeing any. Thank you very much for providing your statement this morning.
Thank you all very much.
And with that, I think we've heard from everyone who signed up in advance. I just need to check the attendee part of the meeting to make sure that nobody else has arrived to testify. And I'm speaking to those who are part of the attendee section of the electronic meeting. If you are here to speak in support of or in opposition to the nomination of Judge Walker, please raise your electronic hand. I'm not seeing any electronic hands. That brings us to the next part of the hearing this morning. All public comments having been taken, the committee will now proceed as follows. We'll review any additional written comments on the nomination that have been received by the committee. And our committee clerk has joined us. Ms. Panett, are there any additional written comments that have been submitted?
There are none, Madam Chair.
Thank you very much. We will now move on to vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are still within that time frame. The hearing by the Joint Standing Committee on the Judiciary for the Honorable Eric J. Walker of Belmont for reappointment to the Main District Court is now closed. Taking the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, I'll inquire whether any member present objects to proceeding to take the vote immediately. Committee members, does anyone have an objection to moving immediately to the vote? Okay, I've looked at all of the committee members in attendance. I don't see any objection. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that nomination of the Honorable Eric J. Walker of Belmont for reappointment to the Maine District Court be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend nomination. Is the committee ready for the question? The committee clerk will call the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Lois, we're not able to hear you.
Yeah, sorry, I was on muted. God knows always. My answer is yes.
Thank you. Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Thorne. Representative Thorne is absent. I have 9 members voting in the affirmative, 0 in the negative. 5 members are absent.
Thank you very much. 9 members of the committee having voted in the affirmative and 0 in the negative. It is the vote of the Joint Standing Committee on the Judiciary that the nomination of the Honorable Eric J. Walker for reappointment to the Maine District Court be confirmed. And Judge Walker, we typically would all come out from behind the horseshoe and congratulate you in person and shake your hand. We have a new tradition, which is a virtual round of applause. And at this point, the committee would like to offer our congratulations with a round of applause for you. We really appreciate your service to our state.
All right, thank you very much.
Thank you for all that you have done and for all that you've taught us about the Family Recovery Court.
Yeah. If anyone has any questions about it beyond today, please don't hesitate to reach out to me. I'd be happy to talk more about it. I talk about it all the time, everywhere I go. And so I really appreciate the faith that you folks have in my work in the last 7 years, and I will do my best to make you proud of me and to do justice for the next 7 years as well.
Thank you. We're sure of that. Take care.
All right, thank you.
Committee members, that brings us to the conclusion of the nomination hearing. We do have a number of hearings on bills, and I'm just going to check our schedule. Yeah, and those don't start until 11, so we'll take a brief break. Peggy, did you have some information for us? Okay, we'll take a break, and I would just ask committee members to make sure that you mute and turn off your cameras because the live stream will continue. And please return just a couple of minutes before 11 for our bill hearings. Thank you very much. And again, thank you, Judge Walker.
Thank you very much.
Hi, Steve. Hi, Aaron.
Hey, Ann.
Hi, Chris. Once everybody joins us, we'll do another round of committee introductions because a lot of folks were in other meetings this morning when we started.
You know, after today and our earlier several nomination approval sessions, I just got to say how impressed I am with the quality of the bench in the state. It's really superlative.
So inspiring.
Mhm.
Yeah.
Hi, Rena.
Good morning, Madam Chair.
You're here, Steve, on that.
Yeah, we're going to do another round of introductions once everybody joins us because so many of us were in other meetings earlier when we started at 9:30.
Relating to the prior nomination of Judge Walker and his program, Family Recovery Court, where it's only in effect in 3 courts at this time. I wonder how that came about and how it's funded, and it sounds as though it's successful. And I wonder if there's plans to expand it. Certainly those stories that we heard today were definitely inspirational, especially the one by Courtney Allen.
Yeah. We should check on that, Rena, but my sense is that each of the 3 courts covers perhaps a broader range of territory than they would otherwise for typical criminal civil violations and that sort of thing. But still, there's a lot of room left to cover.
Yeah, it seems as though it's working. And
yeah,
the question of limited data, it was interesting.
Yeah, I thought so too. And I wonder if you can get data from other states that have implemented similar programs to support expanding the program here. Something we should look into for sure. I agree.
Yeah, absolutely. I think it warrants an additional conversation.
I agree.
Committee members, if you are on the panel, it's 11 and we're about ready to start with our morning hearings. If you could please activate your cameras. We're going to do another round of introductions before we start with our first hearing. It's nice to see everyone. All right. Let's start with committee introductions again. We'll do it now, and then we won't do introductions when we reconvene at 1 this afternoon. And Representative Hagan, we are going to start with you.
I thank you, Madam Chair. Appreciate it. I am David Hagan. I represent House District 101, Hamden and Newburgh.
Thank you. Representative Libby.
Thank you, Madam Chair. Good morning, everyone. I'm Laura Libby. I live in Auburn, and I represent District 64, which is part of Auburn and all of Minot. And I do apologize for being absent this morning. I was at a press conference regarding the Democrat majority budget.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. Representative Thorne.
I am Representative Jim Thorne. I represent District 103.
Carmel, Herman, and a small portion of Etna.
Thank you. Representative Evangelos, have you been able to rejoin the meeting yet? Okay, we'll catch back up with him. Representative Newell?
Yes, thank you, Madam Chair. Good morning, everyone. I am Rena Newell, the tribal representative for the Passamaquoddy tribe.
Thank you. Representative Sheehan?
Thanks, Madam Chair. And good morning, everyone. My name is Erin Sheehan, and I'm proud to represent my neighbors in Biddeford's House District 12.
Thank you. Representative Moriarty?
Thank you, Madam Chair. Good morning to those of you joining us for our public hearings. I'm Steve Moriarty, representing Cumberland and part of Gray.
Thanks. Representative Evangelos?
Thank you, Madam Chair. Good morning, everyone. Again, Representative Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thanks. Representative Reckitt? She may be joining us in just a moment. Representative Babbage?
Yes, good morning, Madam Chair, and everyone that's joining Judiciary this morning. My name is Christopher Babbage. I represent House District 8, which is a small part of the coast and all of the hinterland of the town of Kennebunk.
If I could interrupt, I'm here, but the host has disabled my video, so, but
Oh,
I'm
no.
I'm Lois Reckitt from the ocean end of South Portland, District 31.
Thanks, Representative Reckitt, and we will fix
Oh,
that.
there I am. Okay, thank you.
Thanks. Senator Keim? I don't think your audio is working, Senator Keim. Can you?
All right, can you hear me now? Okay, so good morning, everyone. Lisa Keim, proud to represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Thank you. And Co-Chair Harnett?
Thank you, Madam Chair, and good morning all. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside. Thank you for being here today.
We are also joined by our committee clerk, Supi Panett, and our legislative analyst, Peggy Reinsch. And I am Senator Ann Carney. I represent Senate District 29, South Portland, Cape Elizabeth, and a little bit of Scarborough. And welcome everyone to our hearings this morning. We are going to start with LD 683, an act to allow Maine nonprofit corporations to hold meetings electronically. And the bill sponsor is Senator Trey Stewart, and we'll be moving him into the panel momentarily. As we're doing that, I wanted to let the members of the public know that, excuse me, this morning and this afternoon we'll be doing public hearings on bills. It's really the opportunity for the public to have its voice and weigh in on the bills that we're considering. The bill sponsor will have unlimited time to present the bill. And after that, the committee members will ask questions. Then anyone who is here to speak in favor of, in opposition to, and then neither for nor against the particular bill will be called upon to speak. Members of the public have a 3-minute limit on presentations and then unlimited time to respond to committee questions. And with that, we will start our hearing with Senator Stewart. Senator Stewart, welcome to the Judiciary Committee, and you can proceed when you're ready.
Thank you very much, Madam Chair. Appreciate it. Senator Carney, Representative Harnett, and members of the Judiciary Committee, I'm State Senator Trey Stewart. I have the distinction of representing 51 communities in Aroostook and Penobscot counties, and I'm here today to present LD 683, an act to allow Maine nonprofit corporations to hold meetings electronically. If there is one thing that we have learned from the COVID-19 pandemic, it's that much can be accomplished electronically online, and much cannot due to the way that our laws are currently written. After conversations with a few different nonprofits, it became abundantly clear to me that part of the way Title 13B is written, where were prohibitive to those organizations conducting meetings and voting electronically. The bill before you aims to rectify this problem by amending Title 13B, specifically in sections 602 and 604, as it lays out where membership-based meetings may be held and the process for which individuals may have their vote recorded during such meetings. With additions to section 602, subsection 1, the board of directors may adopt guidelines that authorize a member on their proxy to take part in a meeting remotely and electronically. If guidelines are adopted, they may allow for a member or their proxy to have their vote recorded while participating electronically. The issue that some nonprofits were having was that their bylaws did not state that the board of directors had the power to make changes as to where and how members participated and voted. With this in place, they will have the ability to adopt new guidelines should a situation arise where they need to allow members to meet or vote electronically. This small change to current law will make it easier for Maine nonprofit corporations to continue business as usual, especially at a time when technological advancements are happening daily and a greater number of people are working remotely. Thank you very much for your time and consideration this morning. I'm happy to answer any questions that the committee may have.
Thank you very much, Senator Stewart. Committee members, are there any questions for the bill sponsor? Yes, Representative Thorne.
Thank you, Madam Chair. Senator Stewart. Good morning.
Good morning.
I was curious as to, does this apply or would it apply to all 501Cs? And would it have to be a nonprofit in order to qualify for this bill?
I believe that Title 13B and specifically the sections that are amended in this bill apply to those organizations that would be chartered under 501 status. That being said, I'm not an attorney. I go to school to be one, so would definitely want to confirm that.
Okay, thank you.
Are there other committee members with questions? I'm not seeing one, but I actually have one for you, Senator Stewart. I was just curious whether you think that the current language in the statute would allow a committee, a 501c3 to amend its bylaws to allow for remote meetings and remote votes. It does say that board members can meet at such place within or without the state as may be provided in the bylaws. So currently, could bylaws be amended to allow remote meetings?
So it's an interesting question because I'm on a number of local boards of different organizations. Some of them have adapted very well to the changes that we've had to make over the last year. Others not so much. And so I think that, and you'll hear from others too, I think today, who are here to testify about what some of the challenges have been with regard to interpreting that statute that has made it more problematic for some than others to do just that.
Thank you. Yeah, I think it's interesting too. I'm not sure what the answer is, so it'll be great to hear the additional people speaking on the bill. I see that Representative Evangelos had his hand up next.
Thank you, Madam Chair, and hello, Representative Senator Stewart. Sorry, we've handled these bills before in judiciary, and I just wanted to flag a concern for you, so you can consider it for the work session. I know we've got a lot of experimental evidence now on how remote participation is working. But the main concern I would have for any organization, public or private, is executive sessions. If a organization is in an executive session and they're operating remotely, by definition, executive sessions have to be confidential. So the concern in the past has been what controls are in place to make sure unauthorized people are not in the room with the authorized committee members. that would be a violation of executive session. So I want you to think about that and see if we can talk about it in the work session. Thank you.
Sure. That's great feedback, Representative, and I appreciate that. And I think that, certainly technology has its limits, right? And so we need to be practical with regard to how we, apply what we have available to us for technology presently. I know that particularly when Zoom was first becoming a big deal, there was instances that you'd hear about of Zoom bombing, things of that nature that could be really problematic, particularly if you're operating, in an executive session, or, if the legislature, for instance, is hosting a committee meeting over Zoom, we want to make sure that those precautionary measures are in place to prevent instances like that from occurring, certainly.
Sure. I think, for instance, if it's an executive session personnel matter, for instance, and it's adversarial, you don't want any of the parties to possibly have an attorney not on camera, but feeding one of the participants, questions or notions. That would be a violation of. That was the main idea.
I will note for the committee that at this point it has been.
You're still there. I'm done.
Yes.
Thank you, Representative Evangelos. I think the next hand raised was Representative Babbage.
Hey, thank you, Madam Chair. Good morning. Yes, still good morning. This is my fourth meeting this morning, but good morning, Senator Stewart. Excuse me. Yeah, to piggyback on Representative Evangelos's comment, it's interesting. I just had a conversation.
Representative Babbage, I just wanted to remind you that this is for questions of the sponsor, because we'll have opportunity to kind of discuss the merits of the legislation in the work session.
Thank you, Madam Chair. Absolutely. So with regard to the executive session referred to by Representative Evangelos, that isn't included in the bill, but I do think that's a consideration. There are many remote bills before us, or will be before us, and I would ask your reaction to the fact that in the past we've been reluctant to go to remote in protection of accountability to the public. I think if there's a default position now, it's sympathy for remote participation, having had the COVID experience, but that accountability is still an important issue. With regard to the nonprofits, is there an accountability issue that needs to be considered? And Senator, I was wondering if you had a preference as to whether the permission as to how to go about remote should be a state standard or left to the individual bylaws of the individual nonprofit. Thanks.
Sure. I think, the lawyerly answer is it depends. And I think that it depends on exactly what the nonprofit is that you're talking about, and what level of accountability they have to provide to the public in general would possibly dictate what amount of accountability they may need to, or what type of accommodations they might need to make in order to allow for greater public participation. Some of the boards that I serve on are we have closed door meetings where it's just our membership that are there. That said, I don't think that we would, in most cases, object to having members of the public, if they had a particular concern they wanted to raise to the board, or they wanted to, determine how the board was coming down on certain issues that aren't protected explicitly in executive session, then I think we'd probably be accommodating to those in general. But the reality is you don't see many instances of those to begin with from the public. And additionally, too, we do keep minutes that are available for folks. And if there's ever a review for compliance reasons or otherwise, those minutes would be available as well upon request.
And whether or not it should be a state standard as to how to go about remoteness, so to speak, or should every nonprofit have very different rules regarding that?
Well, I think, and it's important to the fact that this is still poised to be the exception to the rule, right? That in instances where remote participation may be necessary going forward, in a world post-COVID, that participation would be possible, but not necessarily the default position of the organization. So in theory, you would still have organizations that are actually meeting in person and would allow for remote participation in instances where it's necessary. So I don't want to present the idea today that we should have all nonprofits meeting remotely all the time. I don't think that that's good government. I don't think that that's good, oversight necessarily. And it's certainly more challenging to build relationships with your colleagues. And so I guess I want to make that clear that this is meant to be a remedy to some problems that some folks have experienced across the state, rather than instituting a new general rule going forward.
Thank you.
Representative Moriarty, I believe you were next. We're not able to hear you.
Sorry. Thank you, Madam Chair. Good morning, Senator Stewart. What I like about your bill is the fact that the decision to go remote rests with the discretion of the board members, and it's not a mandate. So I think that takes care of some of the concerns. I did have a question. Based on what you've heard over the past year, is it more of a problem that board members are not getting together, or that the broader membership is not getting together?
Well, again, I think it depends. I mean, so for instance, I serve on the board of a CAP agency. Our membership is really just our CAP organization, right? And they are still together because they work together. We just provide oversight of that agency and primarily some of the funds that go into that agency. So our role in that regard is more an oversight one, as opposed to a day-to-day interactive one. That said, we still have things like an annual meeting where we do have opportunities to interact with staff. And those, events have still taken place, albeit remotely. So, on the other hand, you could have a board that, I think that there's the point I'm getting at, I guess, is that there's two different levels, right? Like what you're talking about, the membership, that, is a decision that needs to be made by that particular organization, how
Right.
frequently where they should locate or where they should meet. And then there's the board meetings. And oftentimes there's very little or no overlap between those two segments. Maybe there's an executive director, or maybe there's a de facto board member, but typically what I've seen is that there's not a lot of overlap between those groups unless it's on a deliberate basis because of a planned function or event.
Okay, thank you.
Representative Poirier.
Thank you, Madam Chair. Let me lower my hand so I don't forget to do so. And Senator Stewart, thank you for coming to see us today. And my concern basically is not just this bill, but any bill that is in regard to the remote participation, is that it may exclude a population of people that don't necessarily have access to technology or even the know-how to use the technology. And a lot of that population is the older generation that, like I said, may not have access to or know how to use it. Has there been any thought given to how we would allow those people to participate in this sort of thing if they're not able to, access that sort of technology? Do you see it as an exclusion?
Thanks for the question, Representative. So I think, again, when we're talking about nonprofits, I still serve on, let's see, 1, 2, 3, 4, 5 different nonprofit boards for various things. We typically meet once a month, and I can honestly tell you that I've yet to be in a meeting where we've had a member of the public want to participate. Occasionally you'll get the news that'll say, hey, what's the board going to decide on this? And then we'll have an interview with like the executive director or the chair of the board. But you really don't run into that problem when it comes to nonprofit organizations for the most part. I don't want to speak, about all nonprofits because I'm not an expert in this, but what we're talking about here is largely community-based nonprofits. That said, I actually think that, technology allows for greater participation, so long as you know how to use it, right? To your point, if you don't know how to use it, that's going to be a problem. But, again, I just don't see this being an instance where you'll get people that will be frustrated because they can't attend a meeting nonprofit board because nobody attends them anyway. Like I said, I've never experienced that in my time serving on a number of boards. That's not saying that can't happen or that doesn't happen, but I have yet to experience that.
Thank you.
Representative Libby?
Thank you, Madam Chair, and thank you for being here today, Senator Stewart. My question goes back to what Representative Evangelos had brought up about executive session. So I just want to clarify, this bill, correct me if I'm wrong, it gives the organization the discretion to make provisions regarding meeting electronically. Included in that, could these boards then make provisions for what can and cannot be included in executive session in electronic means versus in person? Does this give enough bandwidth for that?
Yes, from a high level, that's correct. That essentially all this bill is trying to do is make it clear that if a board decided that they wanted to incorporate some sort of electronic participation provision within their bylaws, that they absolutely could do that, but it would be up to the board to determine how and what manner and way they would actually institute that.
Thank you for the clarification.
Thank you.
Thank you very much. Committee members, are there additional questions for the bill sponsor? Go ahead, Representative Babbage.
Thank you very much, Madam Chair. Yes, Senator Stewart, I guess the last question I have, and you have a lot more experience actually than I do, so I would appreciate your perspective. When I think of a nonprofit, I actually think of the board of directors. So I'm not sure if I understand if there is accountability to a membership in the normal runnings of the board. When we talk about remote participation to elected bodies, we're particularly, I'm particularly concerned that the constituency served approve of how the board operates. So in your bill, you talk about in the sole discretion of the board of directors, they may adopt guidelines. And I wondered if there is a situation in which you think it would be appropriate for the guidelines to be proposed and adopted by any membership beyond the board. Do you understand my question?
Well, I think I do. I just don't see, as a practical matter, I don't see a, who is the question of who is the membership, right? So let's say we'll take the United Way, for instance, right?
Right.
Okay. So if the United Way has 1.5 staff members, is that the membership?
Yeah, that's.
Or is the membership the folks that are served by the United Way, which could encompass thousands of people within a community? or is the membership the makeup of the actual board of directors who are nominated and then approved and go through a vetting process and that sort of thing. So I guess practically, I don't know if that would be the best way to do it. I would say though that if folks are, unsatisfied at the way that a board is operating, there's a number of different avenues you could pursue, not the least of which is to replace the board members, and have a different, go through the vetting process that way. There's usually a selection process. Sometimes that's done internally. Sometimes that's done externally. For instance, the ACAP board has a vetting process that involves, some elected officials, county sheriff, county commissioner. I serve on it. President Jackson serves on it. There's one member that's actually an employee. But then I think about other boards. So then I think about like the University of Maine Alumni Association board. And that board is an entirely internal process where we have an executive director who, thinks about different people that might make sense. First of all, they have to be an alumni, right? So, and then sort of runs those names by the board, gets their feedback, thinks about it for a while. We have a nominating committee. They take a vote. They bring up the panel for, total, voting and whatnot by the actual board itself. So there's different processes, I guess, is the long and the short of it.
Thank you for that. Appreciate it.
Not seeing any other questions on the part of committee members. So thank you very much, Senator Stewart. You can stay on the panel during the remainder of the hearing on your legislation. And we'll turn now to our first proponent, Nick McKee. And Mr. McKee, you may activate your audio and your video and proceed when you are ready.
Hi, thank you for having me here today. I appreciate your time. I just wanted to let you know who I was. I'm Nick McGee. I own a small business here in South Portland, live in Scarborough, Summit Property Management. We manage residential condominium associations, do some apartment rentals and things like that. Member of the Community Associations Institute, which is an international organization that really I would say it's dedicated to building better communities, representing homeowner associations, condominium associations, just in general, all community associations. They have 64 chapters worldwide. I'm a member of the Maine Legislative Action Committee chapter, which is we kind of just keep an eye on bills that might impact community associations throughout the state. As you may know, Maine has lots of communities, HOAs, and condominium associations, and they're continuing to be built at a very rapid pace down here in southern Maine. So with that, I just want to let you know we are generally supportive of LD 683. We did have some suggested language changes perhaps that we think could be impactful, especially as it relates to how we operate with our community associations. I did submit that in writing, so you could all see some of that language, but I'll quickly just give you a brief overview of some of the quick concerns. And one of the concerns is that it appears the language at the start of the LD 683 actually states that you have an option. It seems like an either or, which is you have to meet in person or you have to do it remotely. And I can tell you from experience that hybrid models have actually been working not only with the community associations we manage, but I'm actually also happen to be chair of the Scarborough Planning Board, and we've held hybrid meetings where a couple of members remain in chambers, and then we have a couple members participating via Zoom. So I think our first suggestion would be to change it from an either or statement to a more inclusive hybrid model is allowable as well, based on any direction from the board. The second thing, I'm sorry, the second thing that we would probably recommend is just some clarifying language about what being present in person means, and more or less going over it for the quorum purposes. and then how also we deal with the in-person vote or a proxy vote. And we would want language in there kind of indicating that it would count towards quorum requirements. The third suggestion we had was that we feel like remote participation it's described but not kind of clearly defined in the bill, and thought that it might help to define what that meant. Again, language has been provided in writing, so you can kind of review it and discuss if you think it's necessary. And then the last item that we kind of had a suggestion on was there seems to be language saying that the meeting shall or must be held at the registered office of the corporation of the state. So with many of our community associations,
Mr. McGee, we have a 3-minute time limit, and if you could just wrap up your testimony, please.
Absolutely, thank you.
Thank
Sorry,
you.
so yeah, the last point being many of our community associations either have a professional management company or they have to do theirs on site. So we would just suggest language that allows the board of directors the flexibility with proper notice to host that meeting at an alternate location. Some of our associations have over 200 members, and hosting them at my small offices is not going to work. So
thank you.
We appreciate your time and your efforts here. Thank you.
Thank you. And there may be some questions for you. And I see actually that Representative Moriarty has one. Go ahead, Representative Moriarty.
Thank you, Madam Chair. Mr. McGee, is a condo association considered to be a nonprofit?
It is a nonprofit. And yes, we have the Maine Condo Act, which helps govern what we do, and we have the bylaws and declarations, but it is technically a nonprofit.
Okay, thanks for informing me. I didn't know. Thank you.
Representative Babbage?
Yes, thank you. Nice to meet you, Mr. McGee. I was actually going to ask, would this need to also be amending the Maine Condominium Act?
That's a great question for somebody with a law degree.
And perhaps another bill.
Yeah, I could. I mean, I think for where we stand, I think, as I said, our organization is supportive of this effort. We just wanted some clarifying language. Most of the bylaws that we work with and declarations do have language that allow the board of directors to appoint the place and time of a meeting if properly noticed. However, there are some very small associations with some very outdated condo rules that may not have the means to pay for a brand new set of rules that can kind of bring them up to date. And I think that would be a concern.
Yeah. Thank you for that. I mean, the reason I ask is if there is contrasting language, then it would come to us probably under errors and omissions anyway. So thank you, Madam Chair.
Yeah, thank you, Representative Babbage. Are there any other questions for Mr. McGee? Not seeing any. Thank you, Mr. McGee, very much for joining us today. You'll be returned to attendee status. And at this point, we'll hear from the next person here to speak in support of this measure, and that is Chris Pinkham. And you may activate your account. You've already done so. You may proceed.
Good morning, Senator Carney, Representative Harnett, members of the committee. My name is Chris Pinkham, a resident of Freeport. I work for the Maine Bankers Association and its 28 members. I am here before you today to talk about the association piece. Thanks, Senator Stewart, for sponsoring this bill. I think at one point I was going to tell you that this is a really simple bill and we can, put this in the easy category, but I think a lot of people have raised some interesting questions. Let me be very simple because I think you've gone over a lot of the important points. We ran into this issue last June. We have 28 members, all of which serve on the board of directors. 11 of them serve on an executive committee. And we realized that we had the ability to have our executive committee meet, but in our definition of our language, the board really didn't have authorizing language to take its votes on a remote basis. So we went to council, and the folks at Eaton Peabody helped us draft some of this language. It was not intended to be a state decision in terms of how each organization would operate. Instead, it was allowed to have each organization work within their bylaws. to make sure that it represented their organization. The two parts of the bill, the two sections that are in the printed version, really simply that first section allows individuals to participate remotely, which would be in our case, our annual meeting, and actually to vote remotely. I know some of the issues that have been raised would apply to a lot of different organizations. We are a nonprofit association that files under 501c6. I know there are many threes, the nonprofits statewide, so they may have a different set of bylaws. I'm glad to have this discussion with you and hear a lot of your questions, and I'm happy to go back to council and check in on some of these issues. I do believe this section of the law narrowly applies to nonprofit associations filing with the state as nonprofit corporations. I think I would want to check further to see whether or not the type of organizations that Senator Stewart mentioned would be all covered by this section of the law. So having said that and started the discussion, I'm happy to answer any questions, but I think this would be very helpful given the conditions that we have gone through over the last 12 months to make organizations following their governance in a way that allows them to accommodate those times when they need to have a remote session. So I thank you for your patience and your interest in this bill.
Thank you very much, Mr. Pinkham, and thank you for outlining the issues that we'll look into as we move on to a work session on this bill. Committee members may have some questions for you. Committee members, are there any questions for Mr. Pinkham? I'm not seeing any. Thank you very much.
Thank you
for participating, and you'll be moved back to the attendee status. And our final person here as a proponent for this legislation is John Raymond. And Mr. Raymond, you have joined our meeting and you may proceed when you're ready.
Thank you, Senator Carey and the esteemed Judiciary Committee members. I'm John Raymond and I live at 236 Highland Avenue in Millinocket, Maine. And I am the president of Northern Timber Cruisers, Snowmobile and ATV Club, and also ATV Maine vice president. We have been looking at this bill, and I think that because of all the changes that we've had over this past year, that any way that we can make it easier for us to manage our clubs and to be able to move forward in the day that where who would have thought a year ago that we'd be wearing masks all the time and everything. So I think that there's been a lot of good questions raised here that I didn't even think of before, but anything that I think that will come out of this committee, that you'll work out most of the bugs, and that we'll be anxious to support this. So thank you. And if any questions that you might have, I can answer them. Thank you.
Thank you very much, Mr. Raymond. Committee members, are there any questions for Mr. Raymond? Representative Thorne, go ahead.
Thank you, Madam Chair. Mr. Raymond, how many people would typically attend one of your meetings?
Probably usually around 25 to 30. We usually have monthly.
All right, and are these paid membership meeting members?
Yes.
Okay. How many would you say that are paid memberships that do not attend?
Probably, I think our snowmobile membership last year was a little over 200.
Wow. Okay. And Madam Chair, I'm sorry for the decorum of procedure, but should I ask for follow-up questions as I go?
That would be helpful. And yes, you may ask a follow-up.
Thank you, Madam Chair. Mr. Raymond, do you anticipate that this would affect your membership positively if you were able to do this on a remote that would encourage other members to attend that maybe don't have an opportunity now, but would maybe feel better participating if they could join and view remotely?
I believe it would, because just like today, I live in Millinocket, and this Zoom meeting has allowed me to present my testimony and to watch this committee meeting and not have to travel. I've testified with the legislature before, and it always seemed like when we had to come from Millinocket, we had the 8 o'clock meeting to testify at. So this really is a good, tool for us. And I think that it would help with people that could be, homebound a little bit and might not be feeling well, will still attend the meeting. So I don't think it would hurt us at all. I think it would definitely help.
Great, thank you. I appreciate that.
Thank you. And thank you, Mr. Raymond. I don't see any other committee members with questions for you. We appreciate you being here today and also sharing with us some of the factual information that will be helpful for the work session on this bill. Thank you.
Welcome.
At this point, I'm speaking to those who are attendees to this meeting. Is there anyone else who is here who would like to speak in favor of LD 683, Senator Stewart's bill? If so, please raise your electronic hand. I'm not seeing anyone in favor. Is there anyone who would like to speak in opposition to this legislation? And finally, is there anyone who would like to speak neither for nor against? And again, I'm not seeing anyone who wishes to do so. And with that, we'll close the public hearing on LD 683 and move on to our next bill. Our next bill this morning is LD 725, an act to improve transparency in state code and license violations by making public the names of complainants. The bill's sponsor is Representative Dillingham, and she's just joined our panel. And Representative Dillingham, welcome to the Judiciary Committee, and you can proceed.
Thank you very much. Good morning still to everyone. Senator Carney, Representative Hartnett, and members of the Judiciary Committee. I am Representative Kathleen Dillingham. I represent House District 72, which is comprised of the towns of Oxford, Otisfield, and Mechanic Falls, and Western Maine. I'm here to present LD 725, an act to improve transparency in state code and license violations by making public the names of complainants. A tenet of just society is that we get to face our accusers. Unfortunately, we have seen during the pandemic a rise in anonymous accusations against businesses and individuals alleging violations of emergency executive orders. This bill simply seeks to ensure that those being accused know who the complainants are. In my area, at one point, I had some competing businesses that unfortunately took part in filing complaints against each other. And there was no way to prove that that was what was happening other than from folks involved in the businesses because the reports of the violations were anonymous. Facing accusation from a disgruntled neighbor, employee, or competitor with ulterior motives should be part of any investigation into code and license violations so that the accused is able to aptly defend themselves. I ask you to support my bill adding transparency to this process to make the system fair, and I'm happy to answer any questions that you may have.
Thank you very much for your presentation of the bill. And I see that we have committee member, at least one committee member with a question. Representative Moriarty.
Thank you, Madam Chair. Good morning, Representative Dillingham. Good to see you again. I have a question. There seems to be a slight discrepancy between the language of the bill and the summary. The last two words of the summary indicate that the disclosure is available upon request, whereas the bill itself seems to make disclosure mandatory or automatic. Can you reconcile those two for me?
I'm sorry, I didn't notice that between the language and the summary. My intent was that it's upon request.
Okay, then I would just respectfully suggest that the text has to be revised to correspond.
Yes, and
Okay.
so I would say that if the committee felt this was something that they could support and wanted to move forward with, that yes, the committee would need to amend that portion of language.
Okay, it's good to just to clarify your intent. Thanks very much.
Representative Thorne?
Thank you, Madam Chair. Good morning, Representative Dillingham. My question to you is, under this bill, would this provide that only I guess it would be the defendant in this case, would be able to access this, or that any person, whether not involved or not, could obtain the name of the complainant?
So that's a very good question, and I did not contemplate that instance in bringing this forward. My thought process was around the conversation with my constituents, and definitely focused on the defendant and those that the complaint was filed against. I think that, again, that's something that I will leave to this committee, which is more experienced around those issues and the possibilities of what road you might head down if it were to open to everyone and anyone. But my intent certainly was just for the defendant. And I can expand on that a little bit. I referenced it in my testimony, but it really was, during this past year, as we saw businesses that when they were finally able to open, and these were restaurants, and they had limited capacity, and they were situated probably, the three of them involved, maybe 10 miles amongst each one. So very close with each other, similar to what they were providing, and ended up being a slew of complaints that would come in, and constant, you have to shut down until we have, investigation, check your compliance, and even workers that wanted to be not named were aware that business owners were doing this, because these individuals would never normally do anything like this. All great people, wonderful folks that volunteer in our communities, but so concerned and driven to trying to make sure that their businesses could survive, that there was an opportunity to try to slow down business at another place and shift business. I'm sure that those individuals are ashamed, basically of what transpired. But I think that we all know that, the times that we found ourselves in probably drove people to do things that they normally would never have done before. So that I'm just seeking to hopefully be able to address that and never find ourselves in that position, knowing that if an individual wanted to, that had been accused of a violation, could find out where the violation came from. Maybe this would temper some of that a bit.
Okay, thank you. And Madam Chair, may I ask a follow-up question?
Yes, thank you.
And my mind gets racing in terms of how this or any bill could be abused down the road for an unforeseen, and we'll save this perhaps for a work session, but I'm thinking about members of the press, for example, how they could go in and extract information before it's made public in order to out someone, where you as the business owner perhaps may not want to out them, but in the instance that it's of malicious intent or sensationalize, that somebody could obtain that and make it more public than what you had intended to make it, just to have a conversation.
Yes, certainly. I think that's a very insightful comment, and definitely worth the further conversation with the committee during your work session.
Great. Thank you, Representative Dillingham.
Representative Harnett?
Thank you, Madam Chair, and good morning, Representative Dillingham. Thank you for bringing this bill forward. I have an observation and a question. The observation is, once you say something is a public record, it's a public record. So the statute as currently, the LD is currently drafted, it's available to anybody who wants to ask for it. That's what a public record means. My other question, and it may be addressed by somebody who testifies later, is why are these not public records right now? What exception to the public records law applies that makes these confidential and not subject to disclosure?
Yeah, that is a question I think that Commissioner Head is going to be coming to testify against, so that's something that you might be able to ask her, and she would be able to speak to that. I do not have the answer. I did not receive the answer when I asked last summer about this.
Okay, thank you.
Thank you.
Representative Babbage.
Thank you, Madam Chair. Good morning, Representative Dillingham. Good to see you. Short bill, but powerful as far as generating discussion and so forth. I wanted to ask you. I mean, looking at human nature as to what this bill proposes, we know that anonymity emboldens people for good and bad. You know, jurors who, you know, were blind jurors act differently than those that are publicly accountable and all of that. We understand that. But at the same time, I'm sympathetic about the weaponization of accusations. I mean, but I think, do you agree that current law asks for an evaluation of the merit of the accusation rather than the accuser? I guess I'm asking you, there are occasions when it's just not a business against a business or whatever, but it might be an internal thing where a person fears retribution of their own employment. And do you see this as an anti-whistleblower statute that you're proposing?
I could see the concern. That's certainly not my intent. You know, just trying to figure out how we could amend what's in front of us to try and stop those who would use this ability to be shielded from public knowledge for harm. You know, this was my first foray at it, and I knew that this committee would do its due diligence and really take it apart and see if it is something that can be amended. I am sensitive to the fact, though, that if somebody is working for a business and felt that they knew that there were, again, talking about just the executive kind of order violations happening, that they wouldn't want to, fear for their job by bringing that forward. So I am hopeful that you folks on committee would be able to find a balance between, the intent and the practicality of is there something here that we could address to try to temper the abuse, but still provide the protections for those who are not using this as a way in a negative manner.
Thank you for that.
I'm not seeing any other questions on the part of committee members. Representative Dillingham, thank you for presenting your bill. You can remain part of the panel while we hear any additional testimony on the bill.
Thank you so much. All of you have a lovely day.
You too. And I, at this point, am turning to those in the attendee space to see if there's anyone else who would like to testify in support of this legislation. And not seeing any supporting, and in opposition, I believe that we have Ann Head, who has joined the panel. And Ms. Head, are you here to testify in opposition?
Yes, I am,
You may.
Senator. Yes, thank you very much, Senator Carney, Representative Burnett, and members of the Judiciary Committee. My name is Ann Head. I serve as Commissioner for the Department of Professional and Financial Regulation, and also as Director of the Department's Office of Professional and Occupational Regulation. I'm here today on behalf of the administration to testify in opposition to LD 725. I do appreciate the sponsor's comments in clarification of the bill itself. However, the bill as drafted does have broad implications for departments throughout state government and the citizens who come to them seeking recourse. It is a very broad bill, and it has broad implications. The bill would define public record to include the name or identity of any person who files a complaint alleging a violation of an order, code, license provision, or any other requirement placed on a person by a government official. Although the sponsor's intent is clearly more focused than the bill would imply, it could include an array of interactions and persons, including corporate persons, as opposed to just individuals, since it does not define complaint or person and includes any and all orders, codes, license provisions, and other requirements. The bill would make the names of persons who allege misconduct on part of persons holding Maine issued professional and occupational licenses in Maine a public record, whether the person holding the license is an individual residing in California but licensed in Maine, or a Wall Street corporation. Importantly, the language of the bill would require such disclosure even if existing law makes the identity confidential, or even in cases where entire investigations are legally required to be kept confidential. The impact on both Maine citizens who believe they have been wronged, as well as the subject of the complaint, is significant. In the case of those who believe they've been victimized, the bill would have a serious chilling effect on the reporting of alleged violations. A citizen may fear retaliation from the person or company they believe to be engaged in misconduct, or even retaliation from those in their own community. With more vulnerable victims who may be the subject of financial frauds and scams perpetrated by a licensed person or entity, the victim may be too embarrassed to come forward if their identity is public. The impact on the licensed or regulated person is also of concern. For many agencies, information regarding complaints remains confidential until a violation is substantiated. The disclosure of the identity of a person making the complaint may draw attention to the subject of the complaint before any violation has been substantiated, thereby tarnishing the reputation of the person alleged to have engaged. I am obviously speaking for many state agencies here, and the additional comments raised by those agencies are included as an attachment to my testimony here. I respectfully ask that this committee consider these additional comments as you deliberate on this bill. And I do appreciate the opportunity to comment here. I will be available for the work session. And I just want to say that our concerns are for both the confidentiality of the complainant and the defendant. And our state systems under Maine law provide for confidentiality of both until the investigation is concluded. So this bill would have a chilling effect on our investigation process. I'd be happy to answer any questions if I can.
Thank you very much. Committee members, are there any questions? I'm not seeing any, but I actually have a question for you. Oh, there's a couple of questions. I'll defer to my committee members. And I think Representative Thorne, why don't you go ahead with your question?
Thank you, Madam Chair. Quick on the draw. And I apologize, I didn't write your name down. Miss
My name
Head.
is Ann Head, yes.
Ann. You had mentioned a precedent, and I'm just curious if there are any precedents. And as I'm reading in this again, it seems like it's very short wording in the bill as it's drafted, and it may be a workshop item, but it doesn't disclose at what point the name would be potentially released. It implies, I suppose, that it says to make public the names of the complaints versus at the point that the charge has been substantiated, then the name becomes available. Is there any precedents that you're aware of that would stipulate at what point the name would become public if this were to pass?
I'm not exactly sure what you're asking me. I think every state agency that issues a license or a permit has a complaint mechanism that is in some way under their enabling statute will make that process confidential. But I can't speak for every single agency that has that. I can, however, speak to you about the complaint process that the Office of Professional and Occupational Regulation has adopted and has been in place for many, many years. That could be, a precedent. In that case, when a complaint is filed by an individual against a licensee, every detail of that complaint remains confidential until the case is closed, either by a board decision or a consent agreement signed by the parties. But not all information. So in other words, the complainant's name and the respondent's name would be available to the public when the case is closed, but not before, so as to safeguard the integrity of the investigation. I would be shocked if other state departments did not have a similar complaint process that had those safeguards in state law.
Thank you.
Representative Libby?
Thank you, Madam Chair. Good morning, Ms. Head. Good afternoon, I suppose now. My question was in part answered by what Representative Thorne had asked. So I'll follow up then with, you discussed current practice with when the information would be disclosed regarding the complainant and the business or organization involved. So I just am wondering about the typical timeline. For example, in Representative Dillingham's testimony, she referenced the 3 businesses that had a plethora of complaints filed against them sometime in the last year. How long would a case like that typically take? And so then when would those details be made public? And might those businesses already have those details public?
To respond to your question, I would say if those agencies, if those businesses were regulated and licensed by any agency within the Department of Professional and Financial Regulation, the same confidentiality would apply. But in some of our agencies, that investigation, for example, the Office of Securities, the details of an investigation are never open to the public by state law that authorizes that office to maintain confidentiality. So I'm not sure I can answer the specific question about businesses and what they know. I know you're referring I'm assuming you are, to the complaints registered with the DECD portal that Maine citizens can use to report what they consider violations of an executive order or a CDC recommendation. I don't know what the confidentiality requirements are for DECD. I can tell you that if there were an allegation against one of our licensees in OPOR, and it's simply one reference, one complaint, that would not be entered into our formal complaint process. That business or individual would have been sent an educational letter explaining that something had been reported against that individual or business. And we were giving them educational information to show the reason for the executive order or the CDC guidance and encourage them to comply. That would not have entered our complaint process. As far as I know, those details could have been obtained by a member of the public or a business from DECD.
Okay, Madam Chair, may I ask a follow-up, please?
Yes.
I apologize, Ms. Head. I'm not familiar with the DECD portal. I have not visited that website. So can you clarify for me? So from what you said, it sounds to me as though the complainants on that have the potential to be completely anonymous. Is that correct? Throughout the entire process, so those names would not be disclosed as you described regarding the end of an investigation? I'm just looking for clarification.
Thank you. I understand there's a bit of confusion here. When a private citizen registered a complaint at that portal, the agency that may have jurisdiction over that business or individual would be notified of that, and then the matter would enter that agency's complaint process. So that opens up the area of questioning to every state agency that licensed an individual or business that was subject to a citizen complaint for reasons related to the COVID-19 pandemic. So I can't answer for every state agency. I have given you the information that would be relevant to the office of the department generally, because there were some complaints that came to one of our agencies. The educational letter was sent, communications were back and forth to see if compliance was possible, and it was. So those complaints were handled unofficially because compliance was generated. So I don't think that our agencies were handling the kind of report that Senator Dillingham, Representative Dillingham, I'm so sorry, that escapes me at the moment, but we don't deal with those kinds of agencies and businesses. It would depend on the agency that would handle licensees of that type.
Thank you. I may have follow-up, Madam Chair, but I need to think and let others have a turn.
Okay, yeah, and I just want to interject here with a question for Ms. Head. So is your point that this exception, this legislation would have a sweeping effect that impacted organizations and types of complaint processes outside of the scope of what Representative Dillingham was focused on?
I think the sponsor's bill is so broad to have affected agencies and their internal complaint processes and investigation processes that have nothing to do with complaints by the public about COVID matters. But the bill is so broad, we had to come forward with concerns that that if passed, it would disrupt substantially the current processes that we engage in to resolve conflict in our agencies, to handle investigations in the best way possible. All of these agencies have processes that are set in state law. So if this bill went forward as drafted, it would upset all of those state laws. It would supersede every confidentiality provision in all of our agency statutes across state government. So, that's my answer to that question.
Thank you. That was a clear explanation, at least in my mind. I think Representative Moriarty was next.
Thank you, Madam Chair. Actually, I think you've just asked the question that I had intended to, so I'll withdraw.
All right. I think Senator Keim was next.
Madam Chair, can I be heard now? Perfect.
Yes.
I had an issue with my headset. Commissioner Head, it's very nice to see you.
As you as well.
So I think it's maybe possible that you aren't the right commissioner to be talking about the anonymous complaint box, because as I listen to you speak, is it that only one of these complaints came to your agency?
More than one report came to one of our internal or affiliated boards. They were handled in ways specific to those agencies. I can tell you that the Office of Professional and Occupational Regulation did receive more than a handful. And they were handled professionally in a way that did not implicate our complaint process as I've described it. The person against whom the complaint was reported received the education that I described, an educational letter, making sure they had all the information they needed. And that was our purpose, was to educate. I think all agencies that handled these, in other words, you've got a portal in the middle. These complaints went to different agencies for resolution. Each agency had a different way of handling them. But it was a unique situation. And hopefully we never see this kind of pandemic necessity in the future. But we did our best to educate and not put these reports into a formal complaint process. Now, I'm not speaking for every single agency, even within the department, because it depends on the kind of complaint that was reported through the portal. Some were egregious, others were not. Some were investigated, most were not, because there was only one report against an individual or business. So I'm not sure what information I could give you to show all this. It's just too broad a bill for this special situation.
Yeah, understood. And I guess where my question was going is that, so each different department and each agency in the department then has a different process of dealing with complaints. And so some will become public and others will not. Is that, am I understanding you correctly when you said that?
Yes, that is the case. I think generally the public would be given access to information that becomes public at the close of a case or an investigation. That is handled by an agency with specific legal authority to handle their complaints that way. I do know of one agency where the investigation is not made public, and that is authorized by state law.
So would they still become public if they were this sort of educational process, as you mentioned? Do they all become public, or is it only if an investigation is done that they become public? How do we know that sort of process?
Senator Keim, I just want to interrupt for just a minute and ask you if you could narrow your question a little bit, because I think Ms. Head has been telling us that this bill would impact a sweeping array of state statutes, lots of different entities and departments within state government. And if you can kind of focus on one that is maybe within the scope of her jurisdiction, she might be able to answer.
So for the one or the handful that came through your department, will those become public? And are they currently public?
Where yes, those records are public information. They did not enter the complaint process. So I've had the experience of getting a question from someone who wanted to know who complained against them. And I referred that back to DECD. I could have provided that information. And in some cases, we did provide that. But it was simply to tell the reporter, the person who filed the complaint, that we had given information, compliance information to the reporter. And that seemed to satisfy the person. But we're not talking about an instance where 3 restaurants were the subject of many complaints. I don't think the names of a reporter through the portal, I don't think those names are confidential. No, there's nothing in state law that I know of that makes those reporters' names public. I mean, I'm sorry, just the opposite, confidential. On the other hand, if I thought that one of the reports contained verified, investigated information, that would have been sent to one of our licensing boards for consideration and action. So far, no board has taken any action to limit a license or any other action that would be considered discipline.
In your department, you're saying?
In my department, yes.
Thank you, Commissioner Head.
Representative Harnett.
Thank you, Madam Chair, and thank you, Commissioner Head. And I don't mean to belabor this point, but I want to make sure I'm understanding your concern about the breadth of this proposal. Your Department of Professional and Financial, well, let me back up. Public records are defined incredibly broadly under the Freedom of Access laws in Maine. One of the largest exceptions, the first exceptions, are records made confidential by statute. The entities in your department each have their own statutory framework relating to investigations, correct?
That's correct.
And some of those statutes make certain records confidential for either certain periods of time or forever. Is that correct?
That's correct.
And your concern here is because of the notwithstanding language in this proposal, all of those confidentiality statutes are written off the books.
Absolutely. And that's absolutely true.
Okay. Thank you.
And that's our concern.
Okay. Thank you.
I believe Representative Libby, you are next.
Thank you, Madam Chair. Following up then on Representative Harnet's questions, I guess my question would be, Commissioner Head, I've pulled up the complaint portals, the Division of Environmental and Community Health portal, and then the Economic and Community Development portal. And so I understand that the language is very broad, but I also understand that that was not the intent of the sponsor. So from what you've said, then if this were to be amended such that it only includes those complaints that came as a result of the executive order and that were filed through these two websites, would that be acceptable then, as that was the true intent of the sponsor of the bill?
I can't answer that question. I would have to see an amended version of the bill. It would have to be reviewed, and I think it would have been a better option to start there and not necessarily cover areas that weren't the focus of the bill.
Thank you.
Representative Moriarty? We're not able to hear you.
That's right. I was muted earlier. There was some background noise. Commissioner Head, I get your point about the breadth and scope of the bill as drafted. It begins with a phrase, notwithstanding any provisions of law to the contrary, and then continues on. My question may be one for work session and for further consideration than we have time for today, but it simply is, what if the language began by saying, unless precluded by any other provision of law? That, again, may be a topic for more thought, but
I'm going to interrupt here because I do think that it's the perfect topic for a work session. And I know that Ms. Head said that she would be present for the work session.
I understand. I just wanted to sort of tip her off as to what we might be asking at that session.
Right.
You can respond if you're able to, Ms. Head.
I thank Representative Moriarty for that question. It is a good one. And I would be happy to confer with our legal counsel for the department and bring information back if there is any.
Okay, thank you.
Committee members, are there any other questions? Not seeing any. Thank you for providing your insight into this bill, Ms. Head.
Thank you very much for your questions. They were excellent.
And at this point, I'm just checking with the attendee list to see if there's anybody else here who wishes to speak either in opposition, neither for nor against, or in support of LD 725. Please raise your electronic hand. Not seeing any. And so with that, we will close the public hearing on LD 725. Representative Dillingham, thank you very much for bringing this measure forward. And committee members will begin our afternoon public hearings at 1 o'clock, half hour from now. And please, if you are not logging off, mute and turn off your video during the break because the live stream will continue. Thank you very much.
Thanks.
Good afternoon, committee members. If you are have returned to the electronic meeting, please activate your cameras. And once we have a critical mass here, we'll resume. All right, I think we can get started. We had a quorum when we began this morning, and we don't technically need one when we resume, but it looks like we have one anyway. I have goofed today and told two different bill sponsors that they could go first. Senator Nate Libby and Representative Lori Gramlich both have time difficulties today, and I both promised them that they could go first. And I know that they're in our meeting already as attendees. And because we had told Representative Gramlich first that she could go first, we are going to start with her bill presentation. And I will move her into the panel. And as that's happening, I also would just remind committee members that the bill hearings are an opportunity for us to ask questions of the bill sponsor and others who appear to testify with regard to the bill. And particularly for these first two, if we can really focus on asking questions rather than discussions among ourselves, I think that that'll help both of these legislators with their scheduling crunch today. Again, lots of appreciation for that. And Representative Gramlich, you may begin.
Okay, yes, there I am. Thank you, Senator Carney. Let me just pull my screen up. Here we go. Appreciate your indulgence a great deal. I know how busy all the committees are at this time of year. So I'll get right to it.
Thanks.
I'm Senator Carney, Representative Harnett, and my esteemed colleagues of the Joint Standing Committee on Judiciary. My name is Lori Gramlich, and I do represent House District 13, which is the community of Old Orchard Beach. I am here today to present LD 642, an act to ensure that children receive behavioral health services. Mental health, an essential part of children's overall health, has a complex interactive relationship with their physical health and their ability to succeed in school, work, and in society. Both physical and mental health affect how we think, feel, and act both internally and externally. All children and youth, in fact, all of us, have the right to a happy, healthy life and deserve access to timely, effective care to prevent or treat any mental health problems as they develop. However, there is a tremendous amount of unmet need and health disparities, which are particularly pronounced for children and youth living in low-income communities, ethnic minority youth, or those with special needs. These needs are often compounded when a child cannot receive timely mental health treatment due to the opposition of a parent or legal caregiver. Divorce or dissolution of a relationship often creates emotional turmoil for the entire family, but for children, the situation can be quite scary, confusing, and frustrating. Divorce may increase the risk for mental health problems in children and adolescents. Regardless of age, gender, and culture, children of divorced parents experience increased psychological problems. Studies have also found depression and anxiety rates are higher in children from divorced parents. Additionally, these children may experience more externalizing problems such as conduct disorders, delinquency, and impulsive behavior than other kids from two-parent families. In addition to increased behavior problems, children may also experience more conflict with peers. My intent for submitting LD 642 is to assure that children, all children, regardless of if they are experiencing trauma of divorce or dissolution of their parents' relationship, or if they are experiencing trauma of domestic violence or any other events that warrants behavioral health care, that they receive the care they need most. Let me be abundantly clear. My number one priority is that children receive timely behavioral health care, period. This bill is crafted is referenced under Title 19A, which is a statute concerning parental rights and responsibilities. I've included Title 19A in my testimony. It's also referenced in the bill, which I know you've all had an opportunity to review. So I'm not going to read that to you. So what I would like to identify is that we amend the bill by changing the statutes regarding behavioral health care for minor children under Title 19A, which would require that parents engage in mediation to reach a conclusion regarding care. Mediation, which will take precious time to resolve, time that a child in need simply cannot afford. Additionally, including this legislation under Title 19A will do nothing to protect clinicians. For example, if a custodial parent seeks behavioral health care for their minor child and a therapist begins treatment without the informed consent of the non-custodial parent, the clinician would be in jeopardizing their license. I will refer you to Andrews v. the Board of Social Work Licensure, which was a case that was determined in 2005 for additional information regarding these implications, but it had to do with a custodial parent, mom seeking treatment and therapy for her two sons from a licensed clinical social worker. And dad was opposed to the treatment and brought a suit that ended up in the process of potentially revoking this practitioner's license. The Maine Supreme Court upheld the decision of the defendant. Given both the intent of LD 642, which is to assure that children receive timely behavioral health care, as well as to protect clinicians when engaging in said treatment, I would like to introduce and recommend an amendment to this bill. Specifically, rather than amending the statute under Title 19A, I would recommend amending Title 32. Section 1, Title 32 MRSA, subsection 7008 is enacted to read: services to minors with consent of a parent or guardian. Any person licensed under this chapter who renders treatment under this chapter to a minor with the consent of one minor's parents or the minor's guardian is under no obligation to obtain the consent of any other parent or guardian of the minor. Nothing in this section may be construed so as to prohibit the licensed person rendering this treatment from informing another parent or guardian. I have consulted with colleagues who are both licensed clinical social workers, family law and guardian ad litem attorneys, and advocates from both Family Law Advisory Commission, as well as the Maine Coalition to End Domestic Violence, all of whom expressed preliminary support of this recommended amendment. I've also spoken with your apt analyst, Peggy Wrench, who assisted me with this change. I sincerely appreciate your time and consideration of this critically important issue. I'm happy to work with the committee and other vested parties regarding this policy, and I urge you to vote ought to pass as amended. And just not embedded into my testimony, I will share with the committee that I do have lived experience with my own child who experienced quite a bit of trauma after her father and I divorced. And being a social worker, I was well aware of the signs and the symptoms. And I did attempt to get her into therapy, and her father was well aware of that. And after a couple of treatments, regardless of who the therapist was, I engaged with licensed clinical social workers, LCPCs, and clinical psychologists. My ex-husband would say no, and my daughter would no longer get treatment. And unfortunately, as a young adult, she had to be hospitalized. And this was 100% preventable. So my intent with this bill is that one parent's parental rights don't necessarily get to trump another one's if it's in the best interest of the child. And I don't want to have this held up in mediation, which we know takes a lot of time and money while the child sits anguishing, which is why I'm recommending that we explore this under Title 32. And again, I'd be happy to answer any questions.
Thank you very much, Representative Gramlich. I actually have a preliminary question, which is, thank you for being proactive and presenting us with a sponsor's amendment. Do you have that available as a document that we could look at?
I don't yet, Senator. I do have the reference embedded into my testimony. I did speak with Peggy last night, and she thought this potentially could be enough to get us started. And I knew ultimately that this would end up in her bucket list of things to do. So I wanted to be proactive in giving her that heads up. And the reference that I include in my testimony has to do specifically with licensed social workers, because as you know, there are many different classifications of licensure under the behavioral health heading. But I guess I'm a little bit partial to social workers, so that's where I started.
Thank you. Can you just review for us again what the proposed amendment is briefly? Because I think we're all following you, but it would be nice to have a refresher.
Yeah, and Peggy just put in the chat, it is at the bottom of my testimony that I did read. But yeah, I'd be happy to read it again. It basically has to do, Senator, with the section of the law under treatment of minors. And in this case, minors are considered children under, well, technically 16, but age 18. Now, as I know this committee is well aware, minors who are age 14 and older do have the opportunity to give consent for both behavioral health as well as reproductive health care without either parent or guardian's consent. But this has to do moreover with children who are younger than that, who would not be in the position to give their informed consent. And this would allow for the child to indeed receive treatment, as well as, quite frankly, protecting the licensed provider. Again, I referenced a case, Andrews versus the Social Work Licensing Board. You can pull that up, and I'm happy to forward the link to that final judgment if the committee's interested in seeing that. But it was a situation very similar to mine, and the licensing board was in a position to begin revocation of the clinician's license, and she appealed that to the Supreme Court, who upheld her decision, the practitioner's decision. I don't know if that quite answered your question, Senator.
No, I think it did. Thank you very much. And I jumped ahead of my fellow committee members, for which I apologize. Representative Moriarty, would you like to proceed?
Well, thank you, Madam Chair. Representative Gramlich, I'm trying just to wrap my brain around your amendment. You're taking this out of Title 19A and going to Title 32. So does this apply to children whose parents are not divorced or divorcing or separating?
Yes. It would be, I referenced in my testimony, Representative Moriarty, divorce, but I also did reference dissolution of relationship. So it's the biological parents or the legal guardian or any caregiver that has legal authority over that child.
Well, I guess what I'm asking is, suppose there is a child who needs treatment, but there's nothing going on with the parent's marriage, and there's no one else who has custodial or oversight responsibility over that child other than the parents. So is that child affected by the amendment?
That's a great question. And I'm not a lawyer, and I don't play one on TV. So I'm not, I honestly, that's an interesting proposition. If I follow the line of reasoning that's outlined under Title 32 in terms of licensing for providers, I would, again, I'm going to leave this to the attorneys to really try to sort out, but I would make an assumption that that would include those children as well. I'm just imagining if I had an intact marriage and I, as a social worker, knew that my daughter needed treatment and care, and my husband was saying no, we could battle that out internally, but at the end of the day, my child would still get treatment.
Okay, I'll look forward to seeing the language. I have another follow-up question. In the draft that we have before us, it requires participation in mediation. But there's nothing in here that empowers anybody to order treatment. And there's no indication as to what happens if the parties don't agree at mediation.
Well,
so
Representative, what I'm suggesting is that we do not go down the mediation path. That's why my suggestion is moving this from Title 19A, which would require mediation, to Title 32, which would not.
Well, under Title 32, who has the authority to order anything?
I'm not sure if I understand the question. I apologize.
Well, who has the authority to order treatment under Title 32 if there's no proceeding pending in court?
Well, I would imagine as the in my case, as the mom, I'm getting care for my child, and the therapist is providing that care. So there's no order. I don't believe there'd be an order involved.
Okay, I'll stop at this point. Thank you.
Thank you. Representative Harnett?
Thank you, Madam Chair, and good afternoon, Representative Gramlich. Just so I'm clear, I want to make sure I'm understanding what's going on. You proposed a new section in Title 19A in your original LD. That's gone now, correct? All you're doing now is amending Title 32.
That is correct, Representative. When I received my second opportunity through the revisor's office to assure that the intent of my proposed legislation was what I wanted, I didn't have an opportunity to do anything further with it. I did not propose to have mediation as an avenue for children in need of care and treatment. So when I started consulting with various advocates and had continued conversation with colleagues of mine who work in family court and family law and guardian ad litem, I learned that a better place for this to be would be living under Title 32.
Right, and all you're doing, I think, is you're simplifying it. We're not talking about mediation. We're not talking about a court order. You're just making it clear that one parent can make this decision and absolve the clinician from liability.
That is correct. And so essentially what this would mean is that we would add an additional subsection under Title 32.
Okay, thank you.
You're welcome. Thank you.
And Representative Thorne, you may proceed with your question.
Thank you, Madam Chair. Representative Gramlich, when you submitted this to the revisor's office, and they typically research other bills and laws that may come close to it, I do find it difficult to understand that up until now, nothing's been submitted or proposed or on the books that would allow something similar to this. Did you encounter anything?
No, and I'm not entirely certain if I understand your question, Representative.
Well, I guess my question is when I read this, it says a parent identifies that a child needs therapy, and the other parent says, no, she doesn't need any therapy. She's fine. This requires a third-party intervention. And I'm surprised that this is the first time in husband, wife, child relationships that this has been brought up. I guess, and I'm thinking that there must be some precedence before this one that was attempted or tried or similar.
Thank you for that clarification, Representative. Not that I'm aware of. And again, I can tell you with my own lived experience, which was probably about 16 years ago or more, I had to go back to court and amend and make an effort to amend our settlement agreement in order for my daughter, in order for the family court to determine that my daughter could receive therapy. And so you can imagine it was a very disheartening and frustrating experience, because in these matters, when there's a tie, the court will decide with the no vote. And I was, left trying to do what I could for my daughter without professional intervention and support.
If I might ask a follow-up question, Madam Chair.
You may.
Is there anything in law right now that prevents you as the mother? Do you need both parents' consent in order to do behavioral therapy? Is that what I'm understanding?
That's my understanding, Representative. And that was certainly my lived experience, as I've mentioned.
But is there anything that prevents that, a mother, you, from taking your child to get some type of behavior counseling or therapy without the other parent's consent presently?
Not that I'm aware of. And the problem is the opposing parent who says no is the prevailing voice. So I didn't have any other recourse in as far as solutions were concerned in terms of getting my daughter the care she needs. And furthermore, which is why I think a more appropriate place for this particular piece of legislation would be under Title 32. Clinicians, certainly licensed clinical social workers, are at jeopardy of losing their license if they opt to treat without the other parent's consent. So in my case, you know, it was that experience where my ex-husband said no, and my daughter did not receive treatment.
Thank you. That answers my question.
Thank you.
Thank you very much. And I am not seeing any additional committee member questions for Representative Gramlich. Does anyone have a question before we move on? No, Representative Gramlich, you can stay on the panel during the rest of the hearing on your bill. And Representative Gramlich, do you know if any of the bill co-sponsors are here to testify today? I did not see anybody.
I don't believe so, Senator Carney. I know that there
Okay.
and testimony submitted from some of our advocates in the community. And again, I did have an opportunity to speak with both representatives from the Family Law Advisory Commission as well as the Maine Center to End Domestic Violence, and I believe their testimony is in response to the bill as crafted in reference under Title 19A. They were very receptive to exploring opportunities to have this advance under Title 32.
Okay, so we could check in with some of them during the work session regarding the amended version.
Indeed. Thank you.
Thank you. At this point, I am turning to the attendee list. Is there anyone on the attendee list who would like to speak in support of LD 642? Please raise your electronic hand if that is the case. I'm not seeing any. Is there anyone who is an attendee who would like to speak in opposition to this measure? Again, please raise your electronic hand. And we did have Ms. Gerwin who wished to speak in opposition. Ms. Gerwin, you can proceed, and we have a 3-minute limit, which I'll indicate to you as you get close to it. You go ahead.
So thank you so much for having me here today. I'm Dr. Rosalind Gerwin, Senator Carney, Representative Hartnett, and members of the committee. I am a child and adolescent psychiatrist employed by Maine Medical Center, and I'm here to testify.
Could you please move a little closer to your microphone? We can't really hear you.
Absolutely.
Thank you.
Absolutely. Is that better?
Yes.
Okay. My apologies for being a little persnickety. I'm actually here. I didn't get word of the amendment until quite last minute, and so I'm here to speak about in opposition of the bill as drafted, though would certainly support amendments. I just haven't had time to review it, so my apologies. I work for Maine Health, which is our largest integrated nonprofit healthcare system. We provide a full continuum of healthcare services to the residents of 11 counties in Maine, and we've actually expanded to 1 in northern New Hampshire. And as part of that mission of working together so that our communities are the healthiest in America, we also include Maine Behavioral Health to provide seamless system of behavioral health care across Maine. So quite a large organization. We coordinate hospital psychiatric care as well as community-based treatment services, and always strive to have the best access to behavioral health care through our integration with primary care services. I work specifically at Barbara Bush Children's Hospital, which is our inpatient pediatrics hospital. And in speaking with in hearing from the sponsor, I certainly strongly share the goal of not delaying care to patients regardless of their medical diagnosis or age, and absolutely support increasing access to behavioral health services, and feel that it should be a paramount concern for our current legislature. which is why, as it's drafted, it's difficult for me to support this bill. I see various ways in which it can ultimately delay care, such as sort of putting conflicts of parents ahead of the health and well-being of children, or additionally relying on a dissenting parent to either be physically accessible or even having the capacity to participate in a mediation process for various reasons. I have this concern because of the rising epidemic of both mental health care concerns and suicide in our pediatric population, both in Maine and across the nation. In 2019, there was a JAMA Pediatrics article that identified the state of Maine as having the highest prevalence of children with at least one mental health disorder in the country. And moreover, suicide has become a second leading cause of death among our adolescent and young adult Mainers, and the fourth leading cause of death among Maine youth as young as 10 years old. As an inpatient pediatric psychiatrist, I have personally cared for an alarming rise in medically admitted suicide attempts in our pediatric population, including, unfortunately, this year, a 7-year-old child. Delays in accessing appropriate behavioral health services will only serve to further enable this healthcare crisis, not only within specialty care, but also because we integrate our behavioral health into primary care, having a widespread effect in a number of offices. Oh, thank you. I also just want to point out that from a stigma perspective, singling out mental health care as something that requires more consent than sort of insulin or asthma medications is not probably our best ideal goal, and urge you to vote against this bill as it's drafted. I want to be really clear about that. And thank you, and I'm happy to answer any questions.
Thank you very much, Ms. Gerwin. Committee members, are there any questions for Ms. Gerwin? Seeing none, we appreciate you appearing before the committee this afternoon.
Very much. I appreciate your time.
I'm looking to the attendee list. Is there anyone who is an attendee who wishes to speak in opposition to this legislation? I'm not seeing anyone. And next we'll move on to those speaking neither for nor against, but Representative Moriarty, did you want to raise a concern?
I'll wait until the neither for nor against have had a chance to speak, and then I'd be glad to.
Okay. We have Julia Finn, who has just joined the panel, speaking neither for nor against. You can proceed.
Good afternoon. Thank you, Senator Carney, Representative Harnett, members of the Judiciary Committee. I have been listening to the public hearing and to Representative Gramlich's testimony about the amendment. So her amendment, it sounds like, will probably take care of the concerns that I was about to raise in my testimony. Because I haven't had a chance to review that amendment or even look at Title 32, I guess I'd like to briefly present my comments, but they are, of course, directed toward the original bill, the original version of LD 642. And as has been discussed, that bill provides for requirement of mediation when the parties can't agree about providing behavioral health services. And as Representative Gramlich mentioned, it's in Title 19A on domestic relations and parental rights and responsibilities. So in order for the court to apply the domestic relations statutes, there must be a matter pending in court, either a complaint for divorce or a complaint to determine parental rights and responsibilities. And when any matter is pending that does include a dispute involving children, it is automatically and required to be referred to mediation. That is part of the court process. So if parents are litigating a divorce or a parental rights action, the issue would be identified during a case management conference and the matter would ultimately be referred to mediation. If they're parents that already have a parental rights and responsibility order, and that grants them, for example, shared rights with decisions with respect to the children about healthcare, and perhaps they reach an impasse over behavioral health services, then those parties could file a motion in court to either enforce or amend an order. And that again would be handled with a case management conference by a family law magistrate and would also be referred to mediation. We weren't sure in the original bill if mediation might be required prior to the filing of a matter in the courts. That has been found by the law court not to be permissible in a family law matter. So I just wanted to raise that. So under our current family law division rules and procedures, disagreements around the provision of behavioral health services are already referred to mediation. We weren't entirely sure what problem the proposed statute was designed to address. So again, after seeing, once I see the amendment and I have some time to review it, it's possible that none of this will be relevant anymore. So, but I haven't seen it as of now. I don't know if you have any questions.
Thank you very much for your testimony. And committee members, are there any questions of Ms. Finn? And just to confirm, Representative Moriarty, you're waiting till, okay.
Until you're otherwise done.
Okay, Representative Hagan, go ahead.
Thank you, Madam Chair. I'm trying to understand things. I think I'm understanding this less and less as I learn more and more. Does this bill address only with court findings, or does this bill address any situation? Yes, courts or not courts?
Well,
I don't even know how to ask the question. I apologize.
No, I think I understand what you're asking. And I think the original bill was really only talking about court proceedings involving parties that were litigating parental rights and responsibilities, or parties with children who were getting divorced. As I understand Representative Gramlich's amendment, that would no longer be the case. So it would not have to involve a court proceeding. It would be a matter between the parents and the clinician.
Are there other questions on the part of committee members for Ms. Finn? Not seeing any. Thank you for providing your statement to the committee and for also reacting to the amendment.
Thank you.
And the next person who is signed up in advance to speak neither for nor against is Stephen Bailey, and we'll move him over to the panel. Welcome, Mr. Bailey. You can activate your video and audio when you are able and begin your remarks. Welcome to the committee.
Thank you very much. Senator Carney, Representative Harnett, and members of the Judiciary Committee. I'm Stephen Bailey, Executive Director of the Maine School Management Association, testifying today on behalf of the legislative committees of the Maine School Boards Association and the Maine School Superintendents Association, neither for nor against LD 642. And before I do, a special shout out to Representative Hagan. How are you today, sir? Good to see you.
Great to see you. He's my old 8th grade basketball coach.
Great to be here today. I wasn't privy for the amendment, so I'm not sure that I could either speak to that or know the content of that. So my address today really is in regards to the overall bill itself. We appreciate the intent of the bill, which is to try to assure that a child having behavioral health issues, which can include hyperactivity, anxiety, and depression, gets the help they need. The bill focuses on what can be a very difficult issue when custody of the child is not legally clear, or in the case where separated parents or families going through a divorce disagree about the best course of action. We certainly are familiar with these issues and do attempt to do our own mediation when possible with both parents. Our concern with the bill is it seems to be requiring an official mediator to get involved, but that term is not defined. We do need some clarity around the process, and if the amendment did address some of those last points, then perhaps I would need greater clarity on that as well. But I appreciate being here and being able to offer this, and if there are questions that I could help with, I certainly would be willing to take them.
Thank you very much, Mr. Bailey. Committee members, are there any questions for Mr. Bailey? I would just invite the bill sponsor to briefly outline for Mr. Bailey the amendment proposal so that he could participate in the work session if he feels that would be helpful. So
Thank you.
Mr. Bailey, the bill sponsor is just going to speak briefly to you about the amendment.
Thank you.
Thank you, Madam Chair, and thank you, Mr. Bailey, for coming. I did speak with someone affiliated with your organization. I don't know what role or where he lands, John Suddy, who contacted me about this bill a couple of weeks ago.
Yes.
And I did share with Mr. Suddy that it was my intent to work on reconciling this vis-a-vis an amendment. My amendment proposes to take the statute which it currently resides in, which is Title 19A, and move it to Title 32, which would completely kind of erase the whole court perspective and the mediation component of the bill. So in other words, if a custodial parent wished to get treatment for her child, the therapist could go ahead and begin treatment. And if the non-custodial parent in this example decided that he did not want that child to receive treatment, the burden of proof would be on him to petition the court for the no order.
Okay, that's very helpful. Thank you.
You're welcome.
I was muted. Are there any other questions on the part of committee members for Mr. Bailey? Mr. Bailey will let you know when the work session is on this bill.
Appreciate it. Thank you very much.
And looking now at the attendee list, is there anyone else present who would like to speak neither for nor against this legislation? Please raise your electronic hand. We have Andrea Mancuso, who we'll bring over to the panel.
Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Andrea Mancuso. I live and work in Westbrook, and I'm here today on behalf of the Maine Coalition to End Domestic Violence, neither for nor against LD 642, and would note the only reason I'm speaking neither for nor against is because of the original bill language. To the original language, we concur with the analysis of the Family Law Advisory Commission that was submitted to you in their report dated March 22nd. That said, we very much support the intended purpose of the bill to provide a clear and timely path to getting children needed behavioral services when parents who share parental rights disagree. This is a very real issue that tends to disproportionately impact survivors of domestic abuse and violence and their children. In particular, a parent who uses abuse and violence against the other parent when the child witnesses it, or if the child is in fact subject to it themselves, that parent tends to become very disinclined to support behavioral health services for the child. This contributes to the number of children who unnecessarily struggle for years with the impact of domestic abuse and violence, as well as to generational impacts. I would note that while Title 19A currently provides fairly clear authority for the family courts to address this issue, once litigants get there and can go through the process, our courts have the ability to allocate any or all final decision-making to one parent, even if both parents are to be participatory in the decision-making process. They can say, share parental rights, but if you disagree about behavioral health issues, mom gets to make the final decision. That authority exists under Section 1653D1. However, that method of resolution is rarely going to be timely enough to address a child's short-term needs. The family courts are demonstrably under-resourced. Parents seeking a modification like that to their family court orders are often very frustrated that it takes several months, and I think that's a generous minimum, to get to the point from filing to achieving a resolution. And meanwhile, there might be a child in crisis, losing ground in school, suffering in peer-to-peer relationships, overall mental and emotional health. And while parents and service providers all benefit from clear court orders around parental rights, there really is a problem here in need of solution. And that's how to get children into behavioral health services in a way that timely addresses their needs when there's a legitimate and identified need for these services, maybe even while the family court petition is making its way through the courts. And I think what Representative Gramlich is trying to do, to my understanding, is to flip the requirement. So instead of requiring the protective parent to get a yes from the court in this lengthy process in order to proceed with treatment, it would allow the clinician to provide the services, and then an objecting parent could then go to court to stop it. So I would submit to the committee that this is a much more trauma-informed approach to getting children the services they need when they need it, and would emphasize, lastly, that an effective process for achieving timely behavioral health services for children when a need for these services is identified will contribute both to the intervention in and the prevention of domestic violence in Maine. So I thank you for giving us this opportunity to be heard on the bill. We, of course, would welcome the opportunity to continue to work with Representative Gramlich and interested parties to help get this to where it needs to go, as well as to be a resource for you going forward.
Thank you very much. And thanks for the quick pivot to addressing the amended version of the bill. Committee members, are there any questions for Ms. Mancuso? I'm not seeing any questions. Did your updated testimony, is that included in your written submission?
Much of what I said today is included in my written submission. I ad-libbed a little to try and be responsive to the questions that Representative Thorne and Moriarty had for Representative Gramlich.
Great, thank you very much.
Thanks.
And again, seeing no questions from the committee, we'll move on to see if there's anyone else in the attendee space who wishes to speak in any, with regard to any position on LD 642. If so, please raise your electronic hand. I'm not seeing any. Representative Moriarty, did you wish to be heard in connection with 642, or should we close the hearing and then have you speak?
Well, I think the hearing can be closed, but I would like the chance to speak about the procedural posture of this whole matter.
Okay, we'll close the hearing on LD 642, and then go ahead, Representative Moriarty.
Thank you, Madam Chair. I fully realize that you may determine that my comments are out of order, and I will take that risk. Clearly, what's happened here this afternoon is that by oral amendment, the entire text of the bill has been deleted, and the intent is to substitute entirely different language, which has not yet been drafted or made available to anybody. I understand that part of the purpose of the new language is to immunize therapists, with which I certainly agree, but I'm totally unclear as to how a parent goes about obtaining therapy, both within a marriage and while a marriage may be in a process of dissolution. This is a long way of saying that the amendment, to me, is so completely different from the LD itself that I think it deserves its own public hearing. And I don't think we can really proceed to a work session based upon entirely different language we haven't even reviewed yet. So I won't make a motion to table because that cuts off debate, and that's not fair. But I do, in fact, think this should be tabled, and that a new public hearing should be scheduled for what in effect is an entirely new LD.
You raise a really excellent point, Representative Moriarty, and I think what we'll do is wait until we see the language on the new bill, and then we can decide how to proceed. Although I see Senator Sanborn waving her hand, and maybe she's been in the situation previously. Senator Sanborn, go ahead.
Thanks. I want to point the committee to the second page of the sponsor's testimony. Her amendment is there in black and white. It's only 4 or 5 lines long. It is drafted. It says which section of the statute it goes into, and it's pretty straightforward. So With all due respect to my colleague, I think this is very typical that a different solution to the same problem is arrived at after the sponsor has a chance to talk with folks prior to the public hearing. It's not unusual at all. It is the same problem that's being solved by the amendment, and she has provided the text for it. I think if we were in person, we would have all had a printed copy of it, but it is available. I don't know if you can mute Senator Keim. There you go. So it is available through our digital system where the testimony is filed. So I just encourage our members to go look at it and read it before we have this conversation, because it's pretty straightforward.
Yeah, and I would just like to add, I mean, we can continue talking about this. We do have a bill sponsor for our next bill who's on a very tight time frame this afternoon, and it would be great if we could get to his bill and the remainder of our bills. And we will have time to address again, Representative Moriarty, I appreciate your suggestion, and Senator Sanborn, your points as well. I don't think we need to resolve it at this exact moment, but we will look into it, and perhaps either at the end of the day today or in conjunction with our work sessions tomorrow, decide where we're going to head with this bill. Thanks for all of your contributions on that issue. And also thanks for your consideration of Senator Libby and his tight time frame. Representative Babbage, did you have something you wanted to add?
Yeah, just very quickly. Thank you, Madam Chair. No, I understand both of the comments that have been made. I'm sympathetic with Representative Moriarty's concern, and I think that if we did have a separate hearing, that would be fine. But the alternative course is we need to know what the advocates feel with regard to this. So I think we just have to be sure to reach out to the stakeholders and make sure that they have input on that specific language for the work session. They're the ones that, or at least some of them are the ones that may not have been aware of the amendment, as Ms. Finn wasn't, for instance. So I think it can be remedied in either fashion. One puts a little more work on our staff, but to reach out. But I think that's how we should go forward. Thank you, and I appreciate the senator's comments as well.
Thank you. And now we're moving on to the public hearing on LD 681, and we have Senator Nate Libby here to present his bill. And welcome, Senator Libby, and you may proceed.
Thank you, Senator Carney and Representative Harnett, honorable members of the Judiciary Committee. My name is Nate Libby. I proudly represent all of Lewiston in the Maine State Senate, and I'm here today to present LD 681. The problem this bill seeks to address was brought to my attention by the owners of local rooming houses in my community. Rooming houses, as you probably know, were very common in the 19th and early 20th centuries in the United States. They were very common because they were fairly affordable living spaces for a variety of people in different life circumstances. Over time, though, they've become a key part of our, I would say, transitional housing infrastructure, providing safe spaces for individuals in challenging life circumstances who are attempting to rebuild their lives in many cases. Shelters, residential treatment programs, and the state's correction systems are often referring clients to rooming houses as affordable, accessible, and relatively low barrier rentals. Low barrier, in my view, and in this situation, really has to do with not having a lot of income to spend on housing, perhaps not having the credit history, the cash deposits required, or the references to be able to successfully secure an apartment in many cases. A key part of keeping these properties that I'm talking to you about, a key part of keeping these properties safe for all residents is allowing the operators to ensure that in instances where a guest engages in dangerous or unlawful behavior, that activity does not jeopardize the health and safety of other guests. And part of being able to ensure that safety for the other guests involves utilizing the guest removal process that is available to other short-term rental situations like hotels and motels. There are a number of rooming house owners who are here today to testify, here today virtually, of course. And they'll be following me, but they basically have argued that given the nature of the properties and the clientele they serve, often on a short-term basis, that they are subject to the guest removal process that's used by other short-term rental properties like hotels and motels. I just basically said that twice. My apologies. So what brings me here today is that some ambiguity has been created by recent law change proposals and directives from the Mills administration, not in the form of rule, but in the form of standard operating procedure, that has caused confusion in the last year and concern among rooming house owners about which process to follow, the short-term process for removing a guest or the long, complex, expensive process of eviction used by rental property owners with tenants. My bill seeks to clarify that it's the intent of the legislature that these facilities' guest removal process is governed the same way as hotels and motels, that these arrangements are closer to an innkeeper-guest arrangement than they are a landlord-tenant arrangement, and that the complex and time-consuming process of eviction does not apply in these cases. Now, briefly, some additional background. This issue was brought to me last summer by these interested parties, these operators of rooming houses. They talked about the 183-day limit, and that once a guest stays past 183 days, the entire facility converts to being operated under the landlord-tenant eviction process, the longer extended process, and that creates some serious complications when you're operating a facility like this. It also, I think, creates complications for motels that are serving guests on a longer term basis, that under the new SOP provided by DHHS health inspection program, that even if they have one guest who stayed past 183 days, the entire facility is now governed by that more extended eviction process. So I did not first react when I was presented this problem. I did not first react by saying we need to file a bill. My first reaction is let's talk to the department and try to figure this out. So I reached out to the department last summer. I gave sort of a detailed explanation of why I was seeking to have a meeting, and to my surprise and chagrin, I was told that the department did not feel a meeting was necessary. And you all as committee members can appreciate that sort of feeling when you're told by the department that what you're requesting is not worth talking about. So that was a little bit frustrating. In that reply that the department gave, they described the process they'd gone through with this committee and LD 2063 in early 2020. They indicated that the department and this committee, along with two major stakeholders, Greg Dougal from Hospitality Maine and Kathy Dyer from Maine Campground Association, had hashed out this issue, come up with a unanimous report. The administration and the department liked the unanimous report. They were going to proceed. Unfortunately, we adjourned early, so LD 2063 died and was not enacted. But from what I understand, the department proceeded as if LD 2063 had become law and issued a standard operating procedure that was disseminated to the operators of rooming houses, lodging houses, hotels, motels. And that certainly that action outside of the legislature taking a formal action triggered some changes out in this market. My concern with the process last winter is that if the stakeholders from the community affected only include Hospitality Maine and the Maine Campground Owners Association, that the owners of rooming houses were not at the table for that conversation to talk about how their piece fits into this puzzle. I know several of the lower end motels that provide safe living space for low-income folks on a longer-term basis. I know for sure they are not dues-paying members of Hospitality Maine. So I am concerned that a key voice in this conversation was not part of that conversation last year. And so part of why we're having this discussion is to make sure their voice is heard. I want to close by just sharing on a personal note. In 2020, as part of my consulting work, I was asked to stand up 3 temporary homeless shelters in Lewiston in response to the difficulties caused by the pandemic and the existing shelters not being able to accommodate the same number of folks that they otherwise would have. And in the experience of managing these 3 shelter programs, I got to see very up close the challenging life circumstances that many of our shelter guests found themselves in, and the difficulty that we encountered working with them to try to find them a better place to live, given the lack of transitional housing available in Lewiston, in southern Maine, even in rural Maine. Rooming houses in Lewiston were a place where we were successfully able to place a number of our shelter guests, and they were almost to a person thrilled to be able to have a private space, have a dry, warm, clean space, a place where they can start to get a little bit more stable and begin that long, difficult process with some support to get back up to a better place. And I am concerned that if we don't clarify these issues around the removal process and the ambiguity that's created and really the impossible position these operators are going to be finding themselves in, that the operators will have to make difficult decisions and may need to get out of this business, try to convert their facilities into traditional style apartments because they're not going to be able to operate under the same ambiguity. And if that's the choice that we are going to be forcing upon them, the already low supply of transitional housing, I'm afraid, is going to decline drastically. And that's going to make the challenge of helping folks in difficult life circumstances get to a better, more stable place in my community and the surrounding communities in rural Maine, just about everywhere. So appreciate your indulgence today, hearing me out. I'm happy to attempt to answer any questions you may have. Although if we get into the weeds, I may respectfully defer to some of the folks who may testify after me. Thank you very much.
Thank you. Excuse me. Thank you very much, Senator Libby. And I already see that there are some committee members with questions for you. So we'll start with Representative Harnett. I think your hand was up first.
Thank you, Madam Chair, and thank you, Senator Libby. And I'm not sure if you can answer this question, and if you touched on it and I missed it, I apologize. But part of your premise on this bill is that people that stay in these rooming houses are much more like hotel guests than tenants. Did I get that part right?
Yes, Representative Harnett. I mean, these rooms that we're talking about do not have a private bathroom, don't have a private kitchen. They look more like a hotel room than they do an apartment.
Okay. The reason I ask is, do you have any data on what is the average length of stay in these facilities? Is it like 2 to 3 nights like a hotel, or is it 2 to 3 weeks, 2 to 3 months? I'm just curious.
Yeah, I do not have any data on that. I think perhaps the folks following me could comment from their experience to give you a sense of that.
Okay, thank you.
Representative Moriarty.
Thank you, Madam Chair. Good afternoon, Senator Libby. I note that your bill refers in subparagraph 3 to what's termed a guest and lodging facility relationship, and you clearly distinguish that from a traditional landlord-tenant relationship. So a couple of questions. Is the term a guest and lodging facility relationship defined elsewhere in statute? And then secondly, are there procedures for terminating that relationship which are not the typical forcible entry and detainer procedures or eviction procedures, but are much quicker, easily implemented, and do not involve the court?
Yeah, thank you for the questions, Representative Moriarty. I'm not sure if we've when I'm looking at the text, we cross-reference to a definition, and I'm not seeing any there. So if we need to provide additional definition, I think we're open to that through amendment. But I think part of the goal here is to be very explicit so that the department understands where we're going, but particularly in litigation, when a judge is reviewing the details of the case. Right now, I've heard that the statute's not clear, and our intent is to really spell it out for a judge who's trying to mediate a dispute. As to your second question, I think I'll defer to folks who will follow me.
Okay.
Representative Harnett, is your hand up anew or? Okay. Representative Moriarty, did you have a follow-up?
No, I just, I'm anxious to hear perhaps from another witness as to what the removal procedures are for rooming houses and hotels and motels.
Okay, thanks. Committee members, are there any additional questions for the bill sponsor? I am not seeing any. Senator Libby, you can stay on the panel during the remainder of the public hearing on your bill, and we'll begin to call in those who have, and I don't think anybody signed up in advance to testify in support of this bill, so I don't have a list that I'm going by at this point. I'm turning to people in the attendee space and asking anybody who wishes to testify in support of this legislation, please raise your electronic hand and then keep it raised until after you've been moved into the panel. Okay, so I'm going to start moving folks over. Oh, Erica Veazey, are you here to testify in support of the legislation?
No, against.
Okay, I'm going to move you back out.
Thank you.
Senator Carney, are you not seeing anyone with their hand raised?
No, I am. I was just, it's taking me a little while to get people through cyberspace. But one of them is here. Mitchell Roberge, welcome to the Judiciary Committee, and you may begin your testimony. Please start by telling us your name and where you reside. And I also wanted to let you know there's a 3-minute limit, and you may be asked questions afterwards. So go ahead.
The first thing I'd like to address is procedurally. I'm here in person with one of the operators, Ricky LaChapelle. So I will raise my hand again for his sake after this, but he is also planning on testifying here, but just also from the same laptop that I'm on.
We'll take him right after you.
Okay, thank you. Distinguished Chair and members of the committee, my name is Attorney Mitch Roberge. I work with Peters & Associates in Lewiston, Maine. We have represented in the past a number of landlords and tenants under Title 14, as well as innkeepers under Title 30A, including Ricky LaChapelle, who is here with me today. I'd like to address first the two first subsections of the section 3803. If you've spent any time in Title 30A, it's frankly a mess. Definitions are kind of all over the place. You'll see that we've struck from two different sections these kind of sister clauses that say an innkeeper is not a landlord and a guest is not a tenant. That's already the law. That is how the law has operated, but they're sprinkled in these weird other places in the title. So the first two will combine those and make it clear that all of these Title 38 facilities, it's not a landlord-tenant relationship. So it just kind of combines those. The third subsection is where this gets kind of confusing. These lodging houses are governed by two different titles. Title 30A delegates authority to municipalities to license these facilities. Title 30A governs all of the operation of these houses, including that they have to keep registers on property, they have to post room rates inside, and it also dictates a removal procedure, which is that guests are immediately removed when problems arise as any other hotel or motel. In fact, 30A requires that lodging houses remove people when they cause disorderly conduct or threaten other people. This is meant to keep the other lodgers safe. The other title which governs lodging houses is Title 22. Title 22 delegates authority to the Department of Health and Human Services to issue licenses for sanitation, health, and safety. In the past year, the department has been issuing, as you heard from Senator Libby, standard operating procedures, and in this legislature, LD 1069, which would change their definition of what a lodging house is for inspection purposes. This includes language such as 183-day duration. This length of stay requirement is not mentioned anywhere in Title 30A as a requirement for these facilities. Whether or not the Department of Health and Human Services considers someplace a lodging house does not mean that Title 30A municipalities and the operation of these houses have to be the same. It is simply a license to require inspection. Whether that inspection under the department's opinion is necessary or not is not a matter of operation of these facilities. But as you can see, this presents some confusion and some ambiguity. What is a lodging house? If the Department of Health and Human Services is sending letters to these facilities saying you're no longer a lodging house and we won't issue you a license, that leaves these operators in a state of what am I supposed to do? How am I supposed to operate this facility? This confusion will be used to sue these facilities under Title 30A and require them to use Title 14 removal procedures. This does not change the law. We are not changing the law. We are making it clear so that these operators in the future know what procedures they have to use. Thank you.
Thank you very much, Mr. Roberge. Committee members, does anyone have a question for Mr. Roberge? Go ahead, Representative Moriarty.
Thank you, Madam Chair. So, Mr. Roberge, is a guest and lodging facility relationship defined in either 30A or Title 22?
No, Mr. Representative, and that gets to my point that this whole title is kind of a mess and we're trying to fix that. It is strictly, thank you.
Well, and then so you're the operator of a rooming house or a motel. How do you get someone else who's causing a problem?
Right. So there are exactly two different procedures for removing people from places where they're staying in the state of Maine. One of them is Title 14 for apartments, the eviction, forcible entry, and detainer, and the other one is
the standard landlord-tenant relationship, right?
Right. Correct.
Okay. So we're not in that territory.
Right. We're staying. The only other one is in Title 30A, which has its own statute for how you remove people out of these facilities. And so we're just trying to make clear that the 30A facilities use 30A removal procedure, and we're not getting confused with Title 14.
So, and what is that procedure?
That procedure is just they're subject to removal from the facility in the case that an event comes up. When we don't have to, there's no judicial intervention. They're simply removed from the premises.
So the owner tosses them out?
In a sense, yes.
Okay, I understand. Thank you.
Representative Harnett.
Thank you, Madam Chair, and thank you, Mr. Roberge. I'm a little confused, but that happens a lot. You're saying this doesn't change the law, but I'm looking at the definition section in section 3801 of Title 30A, and I see a reference to innkeeper, and I see a reference to lodging house, but am I missing something? Are there references or definitions for boarding housekeeper, rooming housekeeper, et cetera?
Yeah, yes, Mr. Representative. As I don't have the entire Title 30A with me, but in drafting the language for this, as you'll see, there's two definitions in the definition section, but elsewhere in the title, it'll reference boarding housekeepers, rooming housekeepers, restaurant owners. None of those are defined. This title is very ambiguous, which again leads to the problems like we're having here. So every term that you see referenced in those first two definitions is a term that was pulled straight out of somewhere else in this chapter of Title 30A.
But is not defined.
Correct.
And then maybe you can help me with the question that I asked earlier to the bill sponsor. What information can you give me on the length of time that people stay in these various, I mean, innkeepers I understand, but lodging house, boarding house, rooming house, are these 2 to 3 days, 2 to 3 weeks, 2 to 3 months, all of the above?
It varies from facility to facility. From the ones I've seen, it's kind of all over the place. You have people come for a day or two. You have people stay for a number of months, up to a year. It is like all over the place. And the concern with forcing them to use these length of stay requirements is it's not that they would convert to Title 14, it's they would start kicking people out onto the street to ensure that the length of time requirement is not met in their facility.
Would your bill allow somebody who's been in a rooming house for 2 years to be summarily removed without any court oversight?
Yeah, and that is how that would work, yes. And the same as any other hotel, or if you stay at a long-term hotel, you can be removed at any point regardless of how long you've stayed there. So this would be the same process.
Thank you.
Committee members, are there any other questions for Mr. Roberge? I'm not seeing any. Thank you, Mr. Roberge, for testifying today. And could you please give the device to Mr. LaChapelle? I think you said that he would also like to testify. And if you could change the name on the screen to his name, that's required to properly identify anyone whose image is appearing in our meeting. And then please ask him to introduce himself with his name and his town of residence.
Yep, absolutely, will do.
Thank you.
Good afternoon, members of the.
Welcome, Mr. LaChapelle. Please introduce yourself and tell us your town of residence.
My name is Rick LaChapelle. I'm one of the owners of these boarding houses, rooming houses. I reside in Lewiston. Thank you, members of the Judiciary Committee, for hearing this case. I currently own or operate about 200 rooms, lodging rooms in Lewiston. Now that you've heard the legal aspects of the proposal, I hope to shed some light on the effects that it has on us on a day-to-day operation. A few facts. The natural progression of a person living in a lodging house or rooming house is they usually start, frankly, homeless, living under a bridge or something to that effect. They move into a shelter like Senator Libby mentioned, and then they move into a rooming house, into an efficiency apartment, and then to a full apartment. The rooming house is a great springboard for that person because 80% of the lodges get no general assistance. That is my experience right now. Most of the lodges could not get an apartment due to bad credit or problems that they've had in other buildings. There are no credit checks, no large security deposits. The rooms are totally furnished. This is a shared bathroom situation with the lodges, so you don't have your own restroom. This allows us, because we have lowered the standard to get into a rooming house rather than a full-blown apartment. This is one of the tools that allows us to keep our risk to a lower level, whereas you're taking chances on people that would not normally have an opportunity to get an apartment. Interesting fact, 70 to 80% of the people removed are for the safety and health of other tenants, other lodgers, excuse me, not tenants. Some of the reasons for removal of somebody is drug dealing, assaults, vandalism, prostitution, smoking, a lot of the same issues that Senator Libby experienced with the larger shelters. Mental illness is a vicious problem here in the state of Maine, and we're dealing with a lot of people that have mental illnesses. In removing some of the people, we have encountered, using the correct titles, we've encountered some of them that try to litigate and sue us because we're not following Title 14. This becomes extremely expensive. The last time I encountered one of it, I spent about $8,000 to fight this. Recently, I had one of the lodgers that has a mental illness situation threaten and pull a knife on myself and the manager. We had to call the police. That individual was arrested and is still in jail. And we're still trying to work on that process. We just cannot afford the litigation that's here, that's entailed with removing people. We need to keep this very important tool, which allows us to provide a safe environment for all the lodges. Again, this is not a new law. It already exists. We just need to clarify it. Thank you, and I'd love to answer any questions you might have.
Thank you very much, Mr. LaChapelle. Committee members, are there any questions? I'm not seeing any questions for you. Thanks again for providing your testimony this afternoon.
Thank you.
And next we'll be joined by Lee Clement, who is moving into the panel. And Mr. Clement, you may proceed when you're ready.
Okay. Thank you, Senator Carney, Representative Carney, members of the committee. Good afternoon. I'm what remains of Lee Clement, Ward 6 City Councilor in Lewiston. I speak in favor of passage of LD 681, not representing the council as a whole, but as an individual councilor, resident of Lewiston, and a retired law enforcement officer with over 45 years behind a badge, including a significant period as commander and chief deputy of a sheriff's office that was tasked with all types of landlord-tenant and rooming boarding house issues involving civil process and court orders. Lewiston's mayor would have testified in the affirmative today, but he was unavailable, and knowing that we agreed on this issue, he asked if I could speak. The Lewiston City Council workshopped this and related issues concerning licensing in July of last year. My recollection of that workshop was that while no official council action was taken, there was a consensus among the majority of the council that this clarification would be helpful. I can also approach this issue as a two-state, twice-retired law enforcement officer, a part of whose career involved command of the civil division of a sheriff's office in neighboring New Hampshire as a captain and finally chief deputy. New Hampshire law made it clear that persons inhabiting these types of premises did not enjoy the status of tenancy at will, but could be ejected without having to resort to the formal eviction process in the courts, resulting in forcible entry and detainer. Rooming, boarding, lodging houses, inns, hotels, motels, restaurants, campgrounds, and facilities of this nature, however defined, serve a very definite need in the city, as they afford temporary lodging, refuge, and shelter on a short-term basis. Someone afforded such shelter in this type of facility who becomes unruly, disruptive, or destructive should not be thought of as a tenant at will, and should be subject to removal by, and should not rather be subject to removal by forcible entry and detainer, as some of our courts may have mistakenly held. They should be ejected as provided for in section 3837. I respectfully request an ought to pass recommendation on this bill so as to give these owners a clearly defined and much needed tool. And if I could anticipate an answer to a question, the section 3837 does delineate the ejection process, which basically says that the keeper of these facilities can order the party removed. If they fail to leave, then police can be called and police will remove the individual. I thank you for your time.
Thank you, Mr. Clement. I think you didn't hear me at the beginning of your testimony. Could you please activate your video?
I'm sorry, I thought it was activated. That's why I said this is what remains of me, so.
Thank you, welcome. Committee members, are there any questions for Mr. Clement? Representative Harnett, you may proceed.
Thank you very much, Madam Chair. Thank you very much, Mr. Clement. I don't know if you've been on the hearing the entire time, but I've been asking questions about length of stay. And you mentioned in New Hampshire that when you were serving there as a law enforcement officer, you could simply eject people from these types of facilities. In New Hampshire, does it make a difference how long the person has been there?
I don't recall specifically any standard for length of stay. Usually the ejection was based on unruly, disruptive behavior, violation of rules in the rooming house, whatever. If there was a time limit, I don't recall. I retired from that position, sir, in 2009. So, and I sometimes don't remember what I had for breakfast on a daily basis. So if you'll forgive me for not recalling any time limits.
Understood. But in your experience, were there people that did stay in those facilities for lengthy periods of time?
Oh, absolutely. The county that I served in encompassed the cities of Dover, Rochester, Somersworth. We had several rooming houses, and those rooming houses did have long-term tenants. Some of the less fortunate members of society, that's basically where they could seek refuge.
But those long-term tenants could be just tossed out onto the street without any process. Is that correct?
Well, I don't know, as I say, without any process, they would have to demonstrate some type of behavior that was disruptive, unruly, endangering the welfare of other persons on the premises, that sort of thing.
Okay.
It was a lower standard granted than the eviction process. The eviction process in New Hampshire could take you about 28 days if you had a quick course of action for the eviction, such as non-payment of rent or endangering the welfare of other tenants, that sort of thing.
Okay.
Otherwise, it could take quite a bit longer. I'm not familiar with the Maine process. I've never done civil process in Maine on forcible entry and detainer. But my understanding from talking to landlords and so forth and so on, that it can be considerably more detailed and a lengthy process.
Thank you. Appreciate
Thank you,
it.
sir.
Committee members, are there any additional questions for Mr. Clement? Not seeing any. Thank you, Mr. Clement.
Thank you, ma'am.
And we're joined by the next person here to speak on behalf of this legislation, and that's Cammie Morrison. And Ms. Morrison, you can go ahead and activate your video and your audio, and please introduce yourself by sharing your name and your town of residence. Ms. Morrison, are you able to activate your camera and your audio? Okay, we're going to switch to Paul Rancourt. Bring him onto the panel.
Hello, ma'am.
Oh, welcome, Ms. Morrison. Could you please activate your camera?
I just did. For some reason, it's not wanting to turn on. Hang on one second.
I can.
Here we go.
Oh, okay, great. Thank you very much. Welcome to the Committee on the Judiciary. Please
Thank you,
share
Madam.
your name and your town of residence. And then we do have a 3-minute limit, and I'll be the timekeeper.
Okay.
And Mr. Court, I'll ask you to turn off your video until it's your turn to present. We appreciate that very much. Go ahead, Ms. Morrison.
I appreciate being able to speak today. Thank you for that. I've been a property manager for 22 years in Boston, Albuquerque, New Mexico, and Bangor. And I've been in Bangor for the last 15 years. So I think what they're kind of asking is what type of people stay and the length of time and what the two differences are that we need to go through. And so we have a few facilities that are daily, weekly, and monthly rates. And that can have anyone from someone truly in need in the area, or it can be a traveling nurse. It can have a construction worker, and they can be there anywhere from 1 day to months, possibly even a year, depending on how long they're there. The boarding house in situation is one that it depends on our levels of what we expect to be able to have them let into one of our facilities. And so we've had situations where we've called the police, and if it's a residential situation, if it's in a longer term place, then it can take, the police will tell us we're not involved, it's a civil matter. It can take up to 4 months to be able to go through the eviction process. And we usually only use that when we have difficulties, either with law or smoking, or people who have tried to hurt other tenants in some way, people with mental illness, other people who have broken into the building and then want to then state that they're going to stay there. So more or less what this does is we would have to raise the standards of allowing someone to come in order to justify having to go through a 4-month eviction process. So with these smaller inns, then we have the ability to take someone who maybe doesn't meet the credit criteria, or they don't, they have felonies or misdemeanors, they have prior evictions, or they don't make enough money. We want to be able to help them. Having said that, we've had many, many situations. So we have everyone fill out and sign a rule sheet. And I can send all of that to you, and I'm happy to do that. Okay. But just so that you know what the rule sheet is. So if somebody goes against those rules that they've signed, at that point, we should be able to say, and we have to prove this. It's not just somebody saying, get out. We literally have to prove this. And so if they go against the rules and endangers everyone else, we should be able to do that. If they take that ability away, then the standards will go way up and the people who need it the most won't be able to get in. And that's just to protect ourselves. So.
Thank you very much, Ms. Morrison, for your testimony today. We're going to see if any committee members have questions for you. Okay. Members of the committee, does anybody have a question for Ms. Morrison? Representative Harnett?
Thank you, Madam Chair, and thank you, Ms. Morrison.
Thank you, sir.
You just stated at the end of your comments that you have this rule sheet and you have to prove it if there's a violation.
That's correct.
Who do you have to prove it to?
Well, we just don't. So we have to prove it to ourselves and pretty much to the police. So if the police come, so say we have a small inn and the police come, we have to give them our sheet. We have cameras, in our facilities. And so what happens is we have them sign that sheet. We don't say, if somebody threatens somebody's life, we're going to call right away and ask them to leave. If not, we try to give them a reasonable time frame, say for non-payment. Okay. And so what it comes down to is that you have two differences, and we have everything. We have inns, we have apartments, and that progression does come from coming off the street in and then them progressing into a new apartment. But we also have dailies and weeklies and monthlies by companies, by visiting nurses is a huge one. Construction firms are a big one. If it becomes a situation where it's going to cost a lot of money and we're going to have to go through up to 4 months time frame and legal costs, then the requirements go higher. And so that kind of keeps people who fall below those minimums, say the credit score or the felonies, misdemeanors, things like that, it will go to a point where they won't qualify to be able to get in. And there's a huge need in Bangor and in Maine in general.
Thank you.
You're welcome.
Very much.
Committee members, are there any other questions for Ms. Morrison? I'm not seeing any. Thank you very much, Ms. Morrison.
You're welcome.
Today.
Thank you. Have a great day.
And now we turn to Paul Rancourt. Mr. Rancourt, thank you for joining the panel, and you can go ahead and unmute and activate your camera and begin when you're ready. We are not able to hear you.
Thank you, Senator. Thank you, Representative.
Welcome.
I've been in business since 1979. I own properties in Lewiston and Auburn. I own 76 rooms. It's my responsibility.
Can you please, I'm sorry to interrupt you, but can you just please let us know your name and your town of residence?
Yep, Paul Rancourt. I live in Sabatis, Maine, and I own the properties in Lewiston and Auburn. And It's my responsibility to try to keep safe housing for the tenants, for the lodgers. I mean, I have a lodger who trashed his room and threw his girlfriend out the glass window, then threw her down the stairs. I arrived to try to help his girlfriend, and then he punched me in the face and broke my glasses. I had another lodger who set his room on fire and then left the building. And then I had another lodger that so-called brings his friends who do illegal drugs in the bathroom. They lock the bathroom doors for the night and they shoot up. Actual lodges do not have that access to use the only bathroom. The drug traffic disturbs other lodges and makes them fearful. I am able to give people a chance with the current laws because they can be removed if they endanger others. Last Saturday on the 20th, a homeless woman asked me for a room. She had been staying in empty buildings. So she had no money, but gets a monthly check. So I allowed her to move in immediately with the understanding that she must pay on the 3rd or she will have to leave. I cannot afford to provide free housing, but I can afford to provide chances. Every lodger is unique. Under certain circumstances, I have allowed balances to build up as high as a few $1,000s. Some have cancer. Some pay very well, but have lost their jobs, and etc. So I cannot allow a few to endanger the lives of other lodges. Because the law exists, I am able to provide people a chance who have no references and limited funds. I cannot afford a motel, or they can't afford a shelter to the restrictions of drinking and etc. We provide service to the community, affordable and safe housing. We need to keep the current law. Thank you.
Thank you very much, Mr. Rancourt. Let's see if any committee members have questions for you. Committee members, does anybody have a question for Mr. Rancourt? I am not seeing any questions for you. Thank you so much for attending today and presenting your testimony.
Okay. Thank you very much.
At this point, I'm turning to the folks who are in the attendee space and asking if there's anyone remaining who wishes to testify in favor of this legislation. Please raise your electronic hand. And I'm not seeing any, so now we'll move on to those who wish to testify in opposition. And again, please raise your electronic hand and keep it raised until after your testimony, until after you've been brought into the panel. So those wishing to speak in opposition. Okay, we have a couple of folks. And so the first person wishing to speak in opposition is Thomas. And Thomas, you'll have to introduce yourself because I'm not sure that I know how to pronounce your last name, but I will move you into the panel.
Am I there?
You are here. We can see you and hear you. And
Okay.
You may proceed with your testimony, starting with your name and your town of residence.
Yep, and don't worry about having trouble with that name. It's Czechoslovakian and everyone has trouble with it. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Thomas Potasek. I live in Portland, work in homeless services, and have experienced homelessness myself. I'm here today to ask you to not support LD 681. In 2012, when I was an advocate with Homeless Voices for Justice, we worked extensively on this issue. At that time, the YMCA of Portland wanted to be exempt from upholding the basic legal rights of tenants, namely the right to notice of eviction. At that time, HVJ asked some residents of the YMCA what it would mean for them if they were forced to leave immediately rather than have the protection of being able to go through the legal eviction process. A few things that we heard all those years ago still stand out in my mind today. One resident said, "I stayed there for 7 months before I got my apartment. It would have really hurt me if I had to leave immediately. That would have put me out on the street and dwindled my resources very quickly." While another expressed, "I cannot accept the idea that the Y could kick me or anyone else in the building out on a moment's notice. I cannot accept that. After living here for 3 years, if I got myself in trouble, I could be evicted from my home without having time to find another place to live. I cannot accept the fact that I would have no legal rights as a tenant." What seems clear to me in those quotes, as well as in my work as a case manager, is this fact. Rooming houses are a critical source of affordable housing and a vital resource for people as they work to get back on their feet, as they work to get their life back, or perhaps build one for the very first time. It is not out of the ordinary for someone to live in a rooming house for years while doing this. An extreme lack of affordable housing often makes moving on difficult and serves to further cement rooming houses as permanent housing. What rooming and lodging houses offer is housing with weekly rent payments, an option that is crucial to many Mainers of limited economic means. The fact that these residents struggle economically should not mean that they are denied the basic civil rights offered to all other tenants of rental housing. As I mentioned before, some people live in this housing for years. Some of them break the rules just as tenants of any other rental housing may cause problems or break terms of their lease. But just as other renters have a basic civil right to due process before being thrown out of their homes, so should these renters have that right. Alleged criminal activities should be dealt with and should include police involvement, if necessary, in the same way that any other landlord deals with such issues. If LD 681 passes, it would be a step in the wrong direction for addressing homelessness here in Maine. As the men I talked to in 2012 expressed.
Thank you very much. Your time is up, Mr. And I'm sorry, I'm going to mispronounce your name again, but I'm going to give it a shot. Patachek?
That's good enough.
You're very kind. We have a 3-minute limit and you've gone over. So at this point, we're going to ask committee members if anyone has a question for you. Committee members up. I see Representative Moriarty has a question. You may proceed.
Thank you, Madam Chair. Mr. Patachek, there was a reference back at the beginning of this hearing to a 183-day limit. Are you familiar with that?
I am not.
Okay, then I won't go any further. Thank you.
Other questions? I'm not seeing any. Thank you very much for joining us this afternoon and for presenting your testimony.
Thank you.
And next we'll have Lisa Silva, who has joined our panel. And Ms. Silva, you can go ahead and proceed.
Thank you, Senator Carney. Senator Carney, Representative Hartnett, and members of the Joint Standing Committee on Judiciary. My name is Lisa Silva, and I'm the Program Manager for the Health Inspection Program in the Division of Environmental and Community Health. Also, we're known as HIP, so I'm going to use HIP abbreviation throughout this. I'm here today to provide testimony on behalf of the Maine Center for Disease Control and Prevention, and will be speaking in opposition to LD 681. The following is offered for your consideration. The Maine Center for Disease Control and Prevention, Maine CDC, HIP, licenses and inspects lodging places in the tourism, hospitality business, such as hotels, motels, B&Bs, and inns for short-term stays only under the authority of 22 MRS Chapter 562. HIP does not have the authority to license rooming houses, permanent residences, boarding homes, or tenancies at will, or rental properties with tenant and landlord relationships. However, the HIP has issued licenses for a number of lodging places that provide lodging for weeks or months for extended stay guests. The department has submitted a bill this session, LD 1069, an act to provide program solvency, clarity, consistency, and flexibility in routine public health licensing activities to clarify and update the statutory definition of lodging place to include those accommodations for entertainment, hospitality, recreation, and tourism industries only, and to specify that extended stays of 183 days or longer are considered long-term stays that do not meet the definition of a lodging place for licensing purposes and thus would not need to be licensed and regulated by HIP. Only the portion of the lodging place rented by a guest for less than 183 days will be subject to HIP licensing rules and regulations, but the same lodging place could also accommodate guests for long-term stays without jeopardizing the HIP issued license. LD 1069 is identical to LD 2063 that was introduced to the 129th Maine legislature and voted ought to pass as amended before adjournment during the pandemic. As currently written, LD 681 removes protections for long-term stay guests. The language added as 30A MRS section 3803 subsection 3 will create confusion and misunderstanding by stating that having a license issued by a licensing board under 30A MRSA is considered conclusive proof for the purposes of removal procedures. This causes potential conflict with the licensing and removal procedures for those places that have rooms offering both long-term stays, i.e. subject to licensing by HIP, and not subject to license by HIP, and nightly stays that are subject to licensing by HIP. In summary, the Maine CDC opposes this bill as it attempts to extend the removal procedure authority for guests of HIP licensed rooms to those guests staying in non-HIP licensed rooms or long-term stays. We additionally note that Maine CDC has submitted a department bill, LD 1069, which proposes a new statutory definition of lodging place to provide protection under the Maine Revised Statute Title 14 for long-term stays based on 183 days or longer.
Thank you. You finished right on the money.
Sorry.
I appreciate you being here today, and I see that Representative Moriarty has a question for you.
Okay.
Okay, Madam Chair. So, Ms. Silva, you mentioned just twice the 183-day mark. I don't fully understand that. Can you explain that for us?
Sure. So it's been a long struggle for the health inspection program to identify what short-term stays are and long-term stays are. We really struggled with that. And last session, we worked with our stakeholders, Maine Hospitality Maine, and also the Maine Campground Owners Association. And we came to a compromise on 183 days as that relates to the Maine, it's the taxation law, Title 36, which defines what an individual is. And, not an individual, a resident of Maine, 183 days is the domicile. So that's where we got that figure, just to be consistent. And we were good with, because there are some hotels that during the off season, they still want to make money. And so they bring in folks that, may want to stay there for a couple of months, just to, get someplace under their feet to rest, to, have a home. But when the on season comes back, then they are operating like a tourist, hospitality, recreational lodging place.
Well, if I could follow up then, if someone stays in a lodging house for 183 days or more, do they become a tenant within the meaning of Title 14?
So yes, that's why we're opposing this bill, because the bill that we currently have in 1069, the department bill is drafting language for the lodging place definition that we compromised on with Hospitality Maine and Maine Campground Owners Association. And so anybody that would stay over 183 days would not meet our licensing definition. They would now be considered a permanent resident or rooming house with a tenant landlord.
Okay, but you're missing my critical point. If you've lived in a rooming house for more than 183 days, are you entitled to the protections of a forcible entry and detainer statute?
I can't speak to that. I don't know the municipal rules of Title 14. That's not my statute.
Well, they aren't,
Oversee.
they're statewide, they're not municipal, so. you're
Well, but I
entitled
mean, I don't know those statutes, so I don't oversee that piece of it. But if that's what Title 14 says, then that's what, I mean, I guess they would have to fall under the forcible, entry eviction process.
Okay, well, I guess we're still going to need some clarification on that. Thank you.
Senator Kine?
Thank you. Yes, just to clarify, so the 183 days, is that a department bill that's being proposed this session, or is it current law?
No, it's a department bill that's being proposed.
Okay, so this bill doesn't go against current law. It's going against a proposal.
Correct.
Understood. Thank you.
Yep, sure.
Committee members, are there any additional questions? Not seeing any. Thank you very much, Ms. Silva. And next we have Erica Veazey. And Ms. Veazey, you can go ahead and activate your camera and audio and proceed. Welcome to the Judiciary Committee.
Thank you. My name is Erica Veazey. I'm an attorney at Pine Tree Legal Assistance. Pine Tree Legal is a nonprofit organization that provides legal representation to low-income Maine residents in civil legal matters. We practice across the entire state, and we do a great deal of work in the area of housing and landlord-tenant law. Pine Tree Legal Assistance opposes this bill because it removes due process protections for people living at inns, boarding houses, and other similar housing situations. It puts residents at risk of being removed from their homes and separated from their personal property immediately, without notice and without any protection under the law. Many people living in these types of residences described in this bill are long-term occupants who've resided in the same unit for months or even years. Inns, boarding houses, and similar residences provide a much needed opportunity for housing for vulnerable low-income Maine residents. In the traditional private market, to rent an apartment, you may have to come up with a first month's, last month's rent and a security. And for some people, coming up with that lump sum of money is an impossibility. And a boarding home typically charges by the week and may not require a security deposit. So it provides an affordable option for low-income folks who would struggle to come up with that large sum of money. Those types of people might include people living on a fixed income, like people with Social Security retirement benefits or living on Social Security disability benefits, people fleeing unsafe living situations, like people fleeing domestic violence, people who've had a reduction in their income because of a job loss or a divorce or some other life-changing circumstance. Pine Tree regularly works with people who live in the kind of housing that's described in this bill. And in many of those cases, it involves situations where an owner has either locked someone out of their room or threatened to have them removed. And that often occurs without any notice to the tenant. It can leave them instantaneously homeless, separated from their possessions without financial resources to find other housing. A survey of the cases that Pine Tree handled in this area in 2020, I found that 50% of our cases involving this kind of living situation were for tenants who had resided at the residence for 6 years or more. We regularly work with tenants who have lived in their units for 2 years, 4 years, 5 years even. And many of the people that live in these types of residences are there for months or years at a stretch. Subjecting those folks to an immediate ejectment at the sole discretion of the owner strips them of any due process protections. And it assumes that the owner would not attempt to remove someone unless they had good cause to do so. But in a sampling of the cases that I looked at that we dealt with last year, here's just 2 examples for you. We had a client who called living in a rooming house who reported a bed bug infestation. And the owner said if they tried to complain about this again, they'd be removed. Another client had a medical emergency and had to call an ambulance to the property, and they were hospitalized. The owner said this was a disturbance, and as soon as they were released from the hospital, told them they had to leave. Allowing owners of inns, lodging houses, boarding homes, and similar residents to eject renters without notice simply by virtue of having an innkeeper's license will leave many vulnerable low-income Maine residents homeless. And it will likely frighten others into not asserting their rights or making complaints or taking actions to protect themselves.
Thank you, Ms. Veazey. Committee members, are there any questions for Ms. Veazey? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Ms. Azizi, I'm frankly getting spun around a little bit in circles here. I understood one of our earlier witnesses, Mitch Roberge, to say that under Title 30A, there could be currently immediate removal for a tenant of a lodging room for causing a variety of problems. And you seem to be suggesting that this proposed bill would take away certain existing rights. So I guess I'm asking is, what does current law, in your view, provide to residents of rooming homes by way of legal protections when it comes to attempts to terminate that relationship?
What I can tell you about the current law is that our Maine Supreme Judicial Court has held that simply calling yourself an inn or a motel, or simply having an innkeeper's license, does not automatically mean that you have a hotel, motel, or an innkeeper relationship with the person living there. And what our law court has said in a number of cases is that if someone is renting a room over a period of time under such circumstances that they have full control over the room, and that they don't receive the ordinary services that a hotel or a motel might provide, so cleaning services, linen services, guest registers, things of that nature, then it is not a hotel or innkeeper relationship, even if the owner calls himself an innkeeper, or even if they possess an innkeeper's license. And so that's how our Maine Supreme Judicial Court has interpreted that statute.
Okay, if I could follow up then, is there such a thing currently as a guest and lodging facility relationship?
Well, there's certainly the way that the statute exists now. There is a statute that says an innkeeper can eject somebody from a property who is causing a disturbance if there is truly an innkeeper relationship there with the person that's residing in that room.
Okay, what's that statute?
I think,
well, if it's not handy, that's all right.
I believe you're looking at Title 30A, Section 3837.
Okay.
It says ejectment of a disruptive or destructive person or damage to property. Again, which only you would have the right to do if an innkeeper relationship exists between, the person living there and the owner.
All right, and does the so-called 183-day limit convert a lodging relationship into a tenant relationship?
Our Supreme Judicial Court has not said, here is the number of days and then a tenancy has been created. And so it's not as simple. The factors that, for example, Pine Tree Legal would be looking at when they're talking with somebody who's calling with one of these issues is the length of time certainly is important. Obviously, if I've stayed one night at the Marriott, that's very different than if I've spent 5 years renting the same place in a house. But our Supreme Judicial Court has not said, here is the number of days, and if you pass that, that means you're a tenant, and if you're less than that, you are not a tenant.
Okay, thank you.
Representative Harnett.
Thank you, Madam Chair, and thank you, Ms. Veazey. You listed a statistic that I was not quick enough to write down, and it referred to people that you've represented that live in rooming houses or things of this nature, that 80% of your clients had lived there for 6 or more years. Did I get that right?
What I said, or at least that I hope that I said, I intended to say, was that when I looked at our data from 2020 and looked at those cases where somebody had identified a boarding house, rooming house in type situation, 50% of those folks had lived there 6 months or longer.
6 months or longer, okay. And is it, we keep talking about this 183-day number. That's a licensing figure, isn't it? A licensing determination, but not related to Title 14 or?
Correct. It's not something that's in Title 14. I also have not read the bill that Ms. Silva has spoken about. And so I wouldn't feel comfortable commenting on that. But that figure, that 183-day figure, as you've said, has to do with a license and doesn't have to do with our landlord-tenant statutes.
Thank you.
Thank you very much. Committee members, any other questions for Ms. Veazey? And not seeing any, thank you very much for providing this helpful information today.
Thank you for the opportunity.
And we'll next hear from Frank D'Alessandro. And Mr. D'Alessandro, you can activate your camera and your audio and proceed when you're ready.
Thank you. Good afternoon. My name is Frank D'Alessandro. I work, Senator Carney, Representative Harnett, and members of the Joint Standing Committee. I'm the Litigation and Policy Director of Maine Equal Justice, and we're a civil legal services organization. We work with and for people with low income seeking solutions to poverty through policy, education, and legal representation. We oppose LD 681 because this bill proposes to remove the protections provided by landlord-tenant laws which govern evictions based on the tenant's income or the type of housing that they live in. And so I would just reiterate what Attorney Veazey said about the status of the law right now. Whether or not a person is subject to immediate injectment or has the protection of landlord-tenant law depends on the relationship and those factors that Ms. Veazey articulated. So there is, as many people have said, a huge need for affordable housing in the state of Maine. But that need should not be met by creation of a two-tier system where lower income people, the most vulnerable people, have the least amount of rights when they're housed. There is, I want to quote to you from one hotel worker in Waterville, and she described how hard it is to hear people calling the hotel searching for shelter in crisis. And what she said is listening to people who are desperately looking for housing call into the hotel is like listening to the apocalypse on the radio. Their whole lives are shattered and there's nothing I can do. You can't pay rent when you aren't making money. People haven't gotten the help with rent in time and now they're homeless. The housing crisis is so much bigger now and renters need help. This bill, in our view, takes a step in the wrong direction by creating this two-tier system. And like Attorney Veazey testified earlier, many people who reside in these home rooming houses, and I think as the providers also testify, can live there for months, if not years. And under this proposal, they would never get the protections of a tenant, no matter what. And this is contrary not only to basic issues of due process and fairness, but it's contrary to the goals set forth by homeless housing providers. According to HUD, a person is not permanently housed in the eyes of HUD unless they have the protections available to a tenant. And in addition, and crucially, this is the wrong solution at precisely the wrong time. As a result of the recently enacted American Rescue Plan, Maine is scheduled to receive approximately $12 million that can be used for the acquisition and development of non-congregate shelter that can be converted to permanent affordable housing. This money should not be used to fund the creation of units in which no tenancies are created. Even before the pandemic, Maine's rental housing market had been among the least affordable in the nation, and it's only gotten worse. Keeping Mainers in their homes, whether or not it's a house that they own, whether or not it's an apartment, or whether or not it's a rooming house, is critical. And we need to make sure people remain housed. Also, this bill will make even worse the racial inequality that has been highlighted by Maine's housing crisis. Housing access is a racial equity issue. In Maine, as in the rest of the country, people of color are disproportionately harmed due to the lack of affordable housing. Significantly, according to a study conducted by the Maine State Housing Authority in 2019, 26% of Maine's homeless population is Black or African American, even though they make up only 1% of Maine's population. When these people are lucky enough to find housing, whether or not be it a rooming house or an apartment, they deserve the same protection as all other Maine renters. And so we strongly urge you to vote or not to pass on this bill.
Thank you very much, Mr. D'Alessandro. Committee members, do you have any questions for Mr. D'Alessandro? Go ahead, Senator Keim.
Thank you. Thank you for being here, Mr. D'Alessandro. I just wanted your perspective on, I mean, you mentioned that affordable housing is needed, and as we're listening to testimony in favor of this bill, you know, many people came forward to suggest basically that taking on the extra risk of not being able to remove people easily if it's a, you know, if there's an issue, that this then would increase their costs, because obviously you can't take on risk of having someone having a place unrented or having someone not paying the rent without it impacting the bottom line. So I wonder if you could just speak to that as well, like the balance between having low income housing and then expecting that there's that the landlord or innkeeper takes on all of the risk, no matter who's staying with them.
Well, first of all, I point out that to answer that question, and it's good to talk to you again, Senator. One thing is that some of the circumstances that were described by the testimony indicated criminal activity, right? In fact, the cases they brought up were pretty extreme criminal activity. In those cases, a landlord or an owner of a rooming house can contact the police to have the person removed or arrested if appropriate. Also, there are provisions in Maine law, Title 14, for the protection of rental property or tenants, which provide to landlords and people who provide lodging the ability to proceed in a summary fashion to protect the property or tenants. And that's 14 MRS 6030-A. And that's similar to the cease harassment process that is pretty summary in nature. And that's also available. I think it is, the lack of affordable housing is a serious issue. I think that, you know, right now, Maine State Housing Authority is rolling out a program which will help people pay rent. But the solution, in our view, to the housing crisis can't be a two-tier system where the most vulnerable tenants are given the least amount of protection. One of the other things that came up was about I think what was referred to was some tenants in rooming houses who might have mental health challenges. I mean, the solution to that is to provide the necessary services. It's not to create a situation in which people don't have, are summarily ejected, no matter how long they live in a rental unit.
Thank you.
Committee members, are there any other questions? Looking around, I don't see any hands up, so thank you very much, Mr. D'Alessandro.
Thank you.
And then I'm looking at the attendee list and asking if there's anybody else who wished to speak in opposition to this legislation. Please raise your hand. We have Mr. Dougal is joining us. And Mr. Dougal, you may activate your camera and your video and proceed when you're ready. Your camera and your audio, excuse me.
Carney, I actually am neither for nor against. I guess I jumped the gun a little bit, so I'm happy to go back in the waiting room.
Why don't you just deactivate your camera and we'll see. I don't think there's anybody else here to testify in opposition. And so now we'll take anybody who's neither for nor against this measure. That's LD 681. Please raise your electronic hand and leave it raised until I call on you. And at this point, Mr. Dougal, you can proceed.
Thank you, Senator Carney, Representative Harnett. My name is Greg Dougal, and I represent Hospitality Maine. We have about 1,000 members, split pretty evenly between lodging and restaurant. I have no prepared testimony, nor do I have anything written. I just wanted to make sure that I was here, and I put my name in just in case there would be something that I could add, which of course is what the NFNA category is all about, adding information that people haven't heard. So one thing I would like to say to Senator Libby and to the committee is we had no control over the stakeholders group that was created by the Health Inspections Program. There's no way that we could have included other people. It was their stakeholders process, and we did participate in that. It is confusing. There are two sets of statutes. There's the health inspection statutes in 22, and of course the municipality statutes in 30 or 30A. As to Representative Moriarty's request, 3837 pretty much tells you how that you can eject a guest, and then just 3838 actually tells you for what reasons. And so Ms. Morrison was referring to her list of rules as one of those items in 3838. You'll see it actually says that violates the rules of a lodging house. And so there are several other items there, but I think it's good information for you folks. A little bit of history. The gentleman who spoke first, I'm sorry, I forgot his name, the lawyer, just basically said that this law has just been here and it hasn't. That is not close to the truth. If you look at the law 3801, which is what we're talking about, there's two sentences crossed out, the innkeeper sentence and the guest sentence. Those two were added in 2013. Actually, Representative Archie Verreau, God bless his soul, did this on behalf of a constituent and actually put this bill in because people were being sued, or lodging properties are being sued when they evicted somebody after a 2 or 3 day period. I mean, it got to the point where it was lengthy, and then it got shorter, then it was a couple weeks, then it was a week, and then it started to go below a week. So the discussion was had at the time, and the committee decided on this to be the outcome, is that we would have innkeepers not be required to follow that. They would follow just the eviction law, which is in 30A. And so a number of days, was something that was discussed at the time, not specifically 183 and nothing to do with health inspections, but for this particular statute. And they decided that they would go with these two lines. I am not aware of any Supreme Judicial cases that have been resolved on this since this law was passed. All of what was said before is true for the time prior to this law, but I do not believe that this law has ever been challenged in any way, shape, or form like that. I'm sure the folks at Pine Tree Legal will make me pay if I'm speaking out of turn, but I don't believe that I am. And I believe that's all I have, Senator Carney. I'm happy to answer any questions.
Thank you very much. Committee members, does anyone have questions for Mr. Dougal? And I'm not seeing any. Thank you for appearing and providing testimony neither for nor against.
Thank you.
At this point, I'm looking at those in the attendee space. Is there anyone who wishes to testify in any respect with regard to LD 681, which is an act clarifying the removal process of individuals from facilities not governed by Title 14? If so, please raise your hand. Not seeing any raised hands. So at this point, the hearing on LD 681 is closed, and we will take a little break since committee members have been working hard since for over 2 hours. And we do also might have an update about availability of our next bill sponsor. Yeah, so we'll take, let's take, is a 5-minute break adequate, or would committee members like 10 minutes? 5 minutes, okay. Senator Keim, you are the decider. 5-minute break will resume at 3:15, everyone. Thank you.
Okay, if committee members can hear me, it is now 3:15, which is the end of our 5-minute break that was requested. So if you could show me that you meant it when you said 5 minutes, and activate your camera so we can begin again. And Senator Kime, who did decide on the 5-minute rule, is back at 5 minutes. Thank you very much. I'll give just a minute or two, but we still have a lot of work to do this afternoon, so I do want to get started pretty quickly. Okay, our next bill that we will be having a public hearing on is LD 660. We'll continue to use the same process that we have with all of our other public hearings, moving people back and forth from the attendee room to the panelist room. I will hear first from the bill's sponsor, any co-sponsors that want to testify, other legislators, and those from people in support, those in opposition, and those neither for nor against. As is always the case, the bill's sponsor will have an unlimited amount of time to introduce the bill, but all other people offering testimony will be limited to 3 minutes, and I will do my best to let you know when that 3 minutes is about to end. The next bill on our docket is LD 660, and I will open the public hearing and invite the bill sponsor, Representative Francis Head, to introduce the bill. Representative Head, as soon as you are ready to go, if you could unmute your microphone and turn on your video and just begin your testimony when you're comfortable.
My name is Francis Head. I represent District 117, and I live in Bethel. And this is a request by several constituents.
Okay, well, welcome to the Judiciary Committee, and we're interested in hearing your thoughts on the bill.
Are you ready for me?
Yep, absolutely, ma'am. Yep.
This has to do with elderly housing that is subsidized by federal or state or both. It is not Section 8. It just is. We have 3 buildings in my town of Bethel. One is Sudbury Village, one is Bethel House, and I'm not sure the other name, but during the cold power outages this winter, there was no place for these people to go. They're all on electric heat, and they called me the first thing in the morning of the day that the power went out. They started calling me. 15 of them called me before 4 o'clock in the afternoon, and they were cold and they didn't know what to do, and they said to me, do something. And I tried to explain to them it takes a committee to make a bill pass. And they understood they were cold, but they didn't understand process. I am putting this bill in to make sure that there is a backup unit in all these buildings that are occupied by people disabled and 65. I know my bill needs some work. I do know that, and I'm open to suggestions, amendments, or anything that we can do to see that landlords or somebody has a suggestion that will work for backup heat. I'm not talking about cooling in the summer. I'm talking about heat when the power goes out. And these people are desperate for us to. One lady had, she called them chilblains or something like that in her legs. They didn't have frostbite, but they had very, very cold temperatures in each of those apartments. And we need to do something. And so I did submit the bill, and I am open to any suggestions for help for these people that a committee can advise, amend, whatever you want to do. I'm willing to modify my bill to something that works, anything that works for these people. So that's about all I have to say. I'll answer questions about what happened or why I decided that it was time to put these bills in, because we are noticing a lot more outages lately than we have in the past. And these people do suffer. Before, they had Bethel Inn, and they went to Bethel Inn. They took them to Bethel Inn. Bethel Inn was occupied by line workers this time, and there was no place to go. We have a Legion Hall, but they didn't have any power and no backup unit. So that's just my town. And I am positive that there are more than that. I tried to talk to one of the owners, and she said, I don't have the money. And I'm sure that may be true, but there must be something we as a committee, we as representatives can do for these people.
Thank you very much, Representative Head, for bringing that bill forward on behalf of your constituents and neighbors. We appreciate you coming to the Judiciary Committee today. Are there questions by committee members for Representative Head? The first hand I see up is Representative Babbage.
Thank you, Mr. Chairman, and thank you, Representative Head. Good to see you again, and glad that you. Glad to have you bring this forward. I'm particularly glad. I wanted to ask you if I didn't catch if the facilities that you spoke of, they're for senior citizens. Are any of them assisted living or with any supervisory kind of capacity? I'm thinking about people that may be in rehab or anything like that.
Not that I'm aware of right here in Bethel, but I'm certain throughout the state there is. Yes. The people that are here in Bethel, it's mostly over 65, some under that are disabled, and no, nobody with a particular disability. They do have access to medical care if needed, if they're homebound by Androscoggin Home Health and other facility people like that, but nothing that a special unit provided for them or not.
Well, thank you. I'd like to say that we would have been co-sponsors on this bill had we had a normal non-COVID experience, because I had a constituent also come to me and talk about being incapacitated and then having lost power without a backup in a similar facility. And in that situation, they remained stationary for, I don't know, 12, 14, 16 hours, whatever it was. And obviously with all the bodily functions and all of that, I mean, it was an unhappy experience and unnecessary if in fact they had appropriate backup power for that situation. So I'm sympathetic to you bringing this forward, and thank you very much for doing so.
Thank you for listening to my constituents and myself. I believe that they have some right to be warm. And one lady had frostbite in her bottom of her foot. She was covered and the power was out for 3 days. And that's a long time to be cold. I mean, she bundled up and everything, and it was very frightening for them, and they didn't have any options. And that to me is, we need to take care of each other.
Thank you, Representative Head, and thank you for your question, Representative Babbage. If you could put your electronic hand down, that would be wonderful. I see another question from the committee from Representative Hagan.
Thank you, Mr. Chair, and it's great to see you, Representative Head.
You as well.
Do you know how many units are in each of these 3 facilities?
I can get you that. I know that one of them has at least.
We're not hearing you right now, Representative. Representative Head, we're having a hard time hearing you.
You are.
Now that's
okay. I'm closer to my thing. I had eye surgery yesterday. That's why the sunglasses. And so I wasn't allowed to even be on today, but I said, well, I need to because this is very important. So he said, don't spend all day. So I'm trying to be brief. I'm trying to be, but I can get those numbers for you quite easily from the tenants all know what they are. There's one that's 30 and there's one that's over by the Route 2. And that's a smaller one, but they all have at least 20.
Oh, can I do a follow-up?
absolutely, Representative Hagan, go ahead.
Thank you very much. Are there programs in the state of Maine that you may be aware of that would provide backup generators and things like that for places like this?
Not that I'm aware of at this point. Of course, we haven't asked with a strong enough voice yet, but we need to. They're very, I need to tell you this, they're very reluctant to come and testify, because if they get on a list of people that testify, I tried to get them to join Zoom, but they said no because of repercussions. And that's real. That's real to them. They're afraid if they complain, they will be asked to, evicted or asked to leave. So that's another whole program with people coming forward with this, but they'll come and want me to do it. So here I am. And I feel very bad for them that they feel threatened if they complain about anything substantial like the backup. And I'm not saying that we need to have a big gas generator, a propane generator or anything like that. I don't care what they have for a backup. I don't care what they do, but they need to do something. The landlords need to take responsibility for the weather that we can't predict and that these people need. Yeah, they just do.
Thank you, Representative Head. Does that conclude your questioning, Representative Hagan?
It does. Thank you very much.
Are there questions from other committee members for the bill sponsor? Seeing none, thank you very much for presenting the bill today. You're free to remain as a panelist if you want for the rest of the hearing. I don't know what the doctor's orders are on.
I'll just sit back and listen.
Okay, thank you very much. And I am looking at my speaker list, and I am not finding anybody listed as speaking in favor of LD 660. But I'm now in the attendee room, and I would ask that if there's anyone who is interested in testifying in support of LD 660 to please raise your electronic hand. And seeing none, I will go to, I have two people that have indicated they want to testify in opposition. And I would ask that the first person I would have let in would be Alyssa Dean Littlefield. Okay, Ms. Littlefield, if you could begin your testimony when you're comfortable. Welcome to the Judiciary Committee. It looks like your mic is unmuted and your camera is on, so go ahead.
Thank you, Representative Harnett and Senator Carey and all members of the Judiciary Committee. I'm Alyssa Dean Littlefield. I'm a resident of Topsom, and I'm also a member of the Maine Real Estate Managers Association Legislative Committee. I'm here today in opposition of LD 660. Our organization is a nonprofit which represents over 80 professional property management companies providing affordable and subsidized housing throughout the state. As property managers, we have an obligation to our tenants to provide housing that is decent, safe, sanitary, and in good repair. This is not only an obligation from HUD, rural development, and other state and local subsidy providers, but a mission of each of our MARIMA members. This extends to conditions of units and buildings during power outages and other natural disasters. When these emergency events occur, our property managers have policies and procedures to protect our tenants and the homes that they live in. This includes working directly with service technicians and power companies to restore their service as soon as possible, and working with our residents to make arrangements for safe accommodations. This could include providing temporary heating sources within the units, or for finding provisions outside of the property, including temporary housing in hotels or emergency shelters through resources such as the Red Cross, or referring them to warming shelters or other services provided by municipalities. Our members are responsible for some of the largest housing units in the state. We also accept housing choice vouchers. And while these vouchers and subsidies provide rental certainty, they do not guarantee profit. Often these buildings operate at the margins. So the cost of providing backup power to cover the minimum life and safety functions to every building with even one senior over the age of 65 on rental subsidy could cause a strain on these buildings. It could also cause landlords to not accept housing choice vouchers. So without energy grants or assistance to the state, it's fairly cost prohibitive for property owners and managers to install backup generators in all buildings in case of an emergency. Instead, we should continue to work with individual households to meet their specific needs during an emergency and connect them with their community resources, warming shelters, the Red Cross, other places that they can go. Marina agrees with the sentiment of this bill, but because it would not be financially possible for owners to purchase backup systems and could potentially discourage landlords from renting to tenants with vouchers, it's implausible, unfortunately, for us to support it. So I thank you for your time, and also I'm happy to answer any questions you might have.
Thank you very much, Ms. Littlefield, Dean Littlefield. Are there questions from committee members? Seeing none, I thank you very much for taking the time out to testify and provide us with information today. It's greatly appreciated. I also appreciate you mentioning where you reside, because I was supposed to remind everyone to do that.
Thank you.
Before they testify, so let this be my reminder to everybody else. The next person that I have set to testify in opposition is Todd Rothstein from Avesta Housing. If Mr. Rothstein could be moved over to panelists, that would be wonderful. Mr. Rothstein, when I see that your mic is unmuted and your camera is on, so welcome to the Judiciary Committee, and begin your testimony when you feel comfortable by introducing yourself and providing your residence.
Thank you. My name is Todd Rothstein, and I live in Sanford, Maine. I work for Avesta Housing, which is a nonprofit development and property management organization who's serving Maine residents for nearly 50 years. I'm the Director of Construction Services and have been involved for nearly all renovation and new construction projects over the last 8 years. I want to thank you, Representative Harnett, and also Representative Heed, for bringing this topic up and allowing me the opportunity today to discuss this. I haven't had a chance to provide my testimony in writing, and I will do so gladly if you request. Although this proposal is mission-driven, as this bill is written, LD 660 is an extreme response to an issue which is not proportional to the risk. Avesta manages 100 properties and over 300 buildings, and we may have 2 to 3 outages within a given year. Most are short durations and most are in rural settings. Although each one is important that we manage, each one also is addressed by our property management and maintenance teams with protocols and procedures. My concern today is about creating an overarching mandate that is financially burdensome to all of our existing properties and also future properties because of the way the bill is written. It will significantly cost more or erode limited resources for existing buildings. see new projects, and we just talked about this last bill in Lewiston, all about affordable housing. Today, projects are stretched by costs of materials, labor, new regulations, and pushed up against the main housing cost caps, where we are dangerously close for not even being able to continue to meet the demands, which, by the way, Maine Housing says nearly 20,000 new affordable housing projects are required to meet current demand, let alone future. So what do I mean? For an example, we just completed a 40-unit senior housing project in Portland, $6.8 million. If we needed to use a generator to, as it's written, provide backup electricity for the entire building, that would have added an additional $280,000 worth of cost and would have shut the project down even from starting. This week, we just worked from, which takes months to get to a cost cap of a project in South Portland. It's a 45-unit family housing project. It would have cost another $350,000. Avesta has 3,000 apartments at an average of $7,500 per unit for new construction and $15,000 for retrofitting existing buildings. We're looking at nearly $33 million to address this bill, which is unattainable.
Thank you, Mr. Rothstein. I'll need you to wrap it up because we have a 3-minute timeline on.
Fair enough. You want me to wrap it up, or am I wrapped up?
I think you just wrapped it up. Thank you very much. Most folks are not so accommodating. I would now open it up to questions from the committee for Mr. Rothstein. And I'm not seeing any. I
see some hands.
There are two, Representative Hagan, followed by Representative Babbage.
Thank you, Mr. Chair. I was interested in hearing the end of that 33 million, where you came up with those numbers, and
yes,
just a little bit more on that, if you don't mind.
I can break it down. Yes. So, for instance, let's see, the senior housing project, $6.8 million. Electrical costs are typically 6% of the total budget. That's about $500,000 for electrical work. If you divide that 3 ways between the wiring, the equipment, and the fixtures, it's about $130,000 if I needed to rewire every apartment back to an electrical panel. Then a generator large enough to provide electricity for that entire building is about $130,000, which, by the way, it's either propane, natural gas, or diesel. Those are our choices. And then there's site work. So the total, if you divide it by, there's $280,000 divided by 40 units is $7,500 a unit. And that's for a building that has no drywall, has not been built yet. If I have to go back there after it's built, you're going to double that cost. So that's one building. Then we do have a lot of buildings like Representative Heed mentions, make garden style properties, single story in Wyndham, wherever, where we have looked at the cost of retrofitting a building of 5 apartments or 4 apartments. And the unit itself would cost, the generator itself would be about $20,000 because you need about 5,000 kilowatts. Then $2,500 per apartment, which all equals about $7,500 for the smaller units. So what I did, this is quick math because I just learned about this bill yesterday. We have 3,000 apartments, 1,500 apartments for small single families, low-rise apartments. At $7,500 a piece is $11 million. The number just adds up. We also have another 1,500 apartments that are high-rise. And I have to retrofit them, that cost is another $15,000 per unit. That's $22 million. We have 3,000 apartments to retrofit every building. And the reason I say this Representative, is because the way the bill is written, I cannot distinguish between a person living in my apartment for 5, 10, 20 years and becomes 65. If this is a law, I'm going to have to provide them with their power. I can't distinguish from one apartment to the next. The entire building has to support that. And so we do have a lot of work, and Representative Heed offered a lot of work that would be required to review this. And so what I say is this is a fairly complicated situation to discuss.
Thank you. Does that
Thank
answer your
you.
question, Representative Hagan?
Yep. Very much. Thank you.
Thank you.
Thank you. Representative Babbage.
Yes, thank you very much, Mr. Chair. Is it Rothstein? I'm
Yes, sir.
Yeah,
Rothstein. Nice going.
Thank you. Yes, thank you for your testimony. I'm not actually shocked that you're concerned about this bill.
Yeah.
But I do want to ask you, and I understand exactly what you're saying. Let's take the $6.8 million project in
Yes.
Portland, 40 units. In that particular project, were a number of those units, and I don't know if this is a formula that's normal or not, set aside for disabled apartments?
Well, yes. Well, there are. We specifically make some apartments fully accessible for ADA compliance. And then we commit to even greater numbers than that, if that's what you mean.
Yeah, I wondered if there, I mean, is it 10%, or do you have a formula to determine how many units out of a 40 unit building, for instance, might be ADA compliant?
Well, the typical ADA compliance for HUD is 5%, but we typically exceed that because we offer greater opportunities for residents in need.
I'm thinking out loud with you here, but I wondered if, I'm trying to think of the situation where somebody would be confined, for instance, to a power chair or something of that sort, where the considerations of losing power for an extended period of time would be much greater than the normal person. I'm trying to figure, it could be still a significant cost, but the cost of providing power backup for ADA compliant units would require a smaller generator. Is that right? But still all the wiring that you're concerned about.
Theoretically, that you could say that, yes, you could just reduce the number of apartments to do this for, but we have 99-year lease agreements with HUD, and no one in this room is going to be here in 9 decades to know where that person is going to live. And this building has to be there. So it's an all for none, it's kind of, well, it is that. It's either we're all in or not, because I can't say you can't rent unit number 201 because it's set aside for this particular person. Everyone has the right to that place. And I'm just talking for one company. Every landlord in the state of Maine would now have to have specific empty apartments set aside for that one particular person. Is a daunting responsibility or ask of this committee. So we do have a long way to go to address this.
I hear that, but I'm not understanding your point. I'm not suggesting restrictions on who gets the apartment or that would change, but I'm just throwing out there the fact that that apartment might be equipped with a backup capacity.
It is possible. Yes. It is possible. Absolutely.
Thank you, Mr. Rothstein, and I appreciate your testimony. We don't have written testimony from you, is that right?
No, sir. No, sir, but I can do that.
Thank you. Thank you, Mr. Chairman.
Thank you, Representative Babbage. And if you could lower your hand, that would be wonderful. Senator Keim.
Sorry, there we go. Thank you for being here, Mr. Rothstein. Your perspective is really helpful to us. I had a couple of questions, and one I think you kind of answered already, because I was wondering, just given your broad experience, if you saw this issue very often in other places. Or, I mean, I'm wondering if it's a bit of an outlier depending on location.
That is a fantastic question, because in the development stage, and that may take a year before a building even starts getting built, our development team will review the location that we're prospecting, and we will look at whether it's rural or urban, because the likelihood of outages between the two are great. We will also look at what amenities are in the area, because some have warming stations, some don't, like it was brought up today. And also we have received, 3 to 5 year histories from the local supplier utility area to see, is it more likely in this area versus another that an outage will occur, how long the duration of the outage is, how frequent the outage is, and then we will respond, by the way, to whether that particular building needs a generator or not, and whether it's just for a community room, like Representative Badgers was maybe even also considering, where not the entire building, but a particular place, or whether a building just needs a switch gear, a piece of equipment that we could bring a temporary generator to. And so all of those factors are discussed on our end before we even build a building. Does that answer your question or no?
Well, it answers how you're evaluating the projects that you're in charge of, but I was wondering if you had sort of a more global overview of what's happening in Maine. But I think your answer is still helpful. I guess my second question is, would you, again, just because you have more experience in this area, would you have any suggestions sort of on a case-by-case basis or this specific issue? I mean, obviously the local amenities were unavailable during this last storm, and during this last storm, my district was the hardest hit in the state. I personally was without power for 2.5 days. So it was unusual what happened. There was, it was quite incredible, the amount of wind. But still, I just wonder if you had any other suggestions that we might pursue. These are also my constituents in Bethel. So so just to know if you had any other suggestions that we might think about as our remedies.
Yeah, thank you very much. So depending on how these buildings are built, we typically provide community rooms, community spaces. And even if they have electric heat, like heat pumps or other electric resistance heat, we provide a refrigerator in there. So what we would do in some locations is we would ensure that if not the town has a warming station, but that property has one place where someone in need could either bring their medicine to that refrigerator in need, could charge a cell phone, or if they needed to, can come to that space for basically for a warming station and safety. And that's how we've done buildings that are already in place, where we can't afford to retrofit the entire property, but we can provide some assistance. And so I don't know how some of your buildings are created. By the way, an all-electric building does provide challenges, because then if it was a gas, let's say they were on gas boilers, you could just make sure the power was to that one boiler to heat the whole apartment complex. But there is a challenge, what I heard, for electric heat in an entire building.
Right, thank you.
Small station. All right, thank you.
And if I could just make a comment for the work session, I would like to have some information about what's available through emergency management. I know some of my towns do have that type of thing to put into action, bringing generators if necessary, or certainly providing a warm shelter. So if we could just have that information for the work session, that would be helpful. Thanks.
We can work to get that information to you. Thank you, Senator Kyman. Thank you, Mr. Rothstein. Representative Babbage, do you have another question?
Yes, I do. Thank you very much. Before Mr. Rothstein got away from us, I just wanted to, well, I wanted to ask a question, but I also wanted to state that, you know, I've had some interactions with Avesta and with constituents that are in Avesta housing. I'm very high on the product and their experience. So I thought I'd mention that. But I did want to ask, just to follow, in Avesta housing right now, is it normal for a generator to be provided for a community room or an ADA compliant room, or is it? I mean, I understand the cost factors you're talking about, but I just wanted to know how often are generators part of the formula?
It's not normal. However, the size of the buildings, if they're 5 stories high, which we're building more and more, South Portland, so on, then they're required, but only for life safety, an elevator, a certain lighting, and so on, not for a resident convenience, or in this case, obviously heating is not a convenience, it's a necessity, I get that. But the generators are not typically required in the low rise or the garden style construction. However, again, depending on the building, we are looking at the rural places. We're looking at how do we find ways to at least supplement heat in those areas. We have not addressed plug load appliances for everyone, but at least how can we manage people to be able to stay in place? The other thing that people need is whether the water or septic systems. Sometimes we have pumps for wells, and we have our own septic systems. We want to ensure that those are all manageable during a power outage, or somebody could at least stay in place. And then how we build the buildings today are better than what we did in the 70s or 80s or 90s. They're more airtight, more energy efficient, lose less heat quickly. So we're trying in many, many different ways to allow people to endure some of these setbacks.
Okay, thank you for that. I was aware of the height requirement that would require a generator. Was that 5 stories an example, or is that the minimum?
That's the minimum.
Wow.
5 stories or above, then the elevator needs to be on a generator.
Thank you very much.
Yes, sir. Thank you.
Thank you, Representative Babbage. Thank you, Mr. Rothstein. Representative Babbage, if you could lower, thank you.
I want you to ask other people that also, Mr. Chairman.
Well, I tried assistance, sir.
My cursor was there, but I just couldn't get at it.
Representative Evangelos.
Thank you, Mr. Chair. That's because Representative Babbage leaves his hand up every time, Mr. Chair. But anyways, I'll let you take that up with him. Hi, Mr. Rothstein. I'm just getting educated. These questions aren't directed at your operations necessarily, but assuming a building is in a rural area and doesn't have public water or sewer, and the power is out for 2 or 3 days. So if there's no power, there's no pumps, which means there's no water. And I mean, what are the people supposed to do,
Well, in those cases, for instance, in 2017, 2019, 2020, we built 3 buildings in Hampton Falls, New Hampshire, which is a rural place. I know it's not Maine, but we considered the power outage possibilities in that area. There was a well and there are pumps because of a septic system. We committed to generators in those buildings. So we did not commit to certain amenities for every apartment, but we just knew that people would be able to stay in place for the duration of a particular outage, because we did do that test study and saw that the most an outage had been in the last 20 years was 5 hours.
Really?
We said, all right.
Yeah. I mean, every time the wind blows in my town, we lose power. I mean, it's just terrible what's going on. And I think, our utilities, CMP's having a really rough time.
Yes.
And I'm not blaming the linemen. They're on the front lines of it, but about 10 or 15 years ago, our power company reduced staff with layoffs, and they went to something called the regional compact. And so what happens is when we get these 2 or 3 day power outages, we have to wait for these trucks from New Jersey and Pennsylvania to arrive. And it's 24 hours to 48 hours before they even get cracking. We had one 2 or 3 years ago where we were out 7 days. It was bad. Your food goes bad, everything. We bought a little generator and we burn wood, so I'm not complaining about my case, but I do worry about the elderly in these situations, and with the storm intensities, coming on, I appreciate Representative Head, is concerned for these people. It's a well legitimized case. You sound like a responsible fellow, but not all people in your business are. The alternative of wrapping people up with blankets and hoping for the best with our power company's record, it's not working, and we'll see what the outcome is in the work session. But thank you for your commitment to taking care of people.
Thank you very much. I appreciate it.
Thank you, Mr. Rothstein. Thank you, Representative Evangelos. Are there other questions from committee members? Seeing none, thank you very much for all of your time this afternoon, Mr. Rothstein. I'm going to go over to the attendee room we've just heard from 2 folks testifying in opposition to the bill. Is there anybody in the attendee room who wishes to testify against LD 660? Seeing none, I will turn to those testifying neither for nor against. And I note on my list that former colleague and friend, Eric Jorgensen, is testifying on behalf of the Maine State Housing Authority. Mr. Jorgensen, whenever you are ready, welcome to the Judiciary Committee, and we're looking forward to hearing your words.
Thank you very much. It's great to be here. Representative Harnett, nice to see all of you. I'm very excited to see my old seatmate, Representative Evangelos, and my current senator, Senator Sanborn. So it's great. But my name is Eric Jorgensen. I'm Director of Government Relations at the Maine State Housing Authority, although you might know me in other contexts as well. Maine Housing's been helping Maine people own, rent, and repair and heat their homes since 1969. We're an independent state authority, not a state government entity, but we're created to address the problems of unsafe, unsuitable, overcrowded, and unaffordable housing. We do this by issuing bonds which finance single-family mortgages for first-time home buyers and for affordable multifamily housing, and that's why I'm here today. I'm speaking today neither for nor against LD 660, an act regarding protection from power outages for tenants 65 years of age or older in subsidized housing. And we don't own or manage subsidized housing, but we do help build it. And as the state's largest funder of it, we have a direct interest in assuring that these units are safe and affordable. And I think Representative Head, her concept is really a valuable one, and I think it would result in an increase in safety for tenants. However, I think that Mr. Rothstein has really done a nice job of outlining some of the concerns. We would suggest that if the committee wants to proceed with this bill, to consider adopting something like a tiered approach, one that really recognizes the diversity of affordable elderly housing in Maine. So members of the Maine Housing's Construction and Asset Management divisions looked at this bill and suggested some potential costs and things. And they said that they're, like we've heard, that these costs are going to vary widely depending on the type of housing being outfitted with generators. They proposed considering new projects, existing facilities, and small projects differently. And for new projects, the opportunity to plan for and incorporate generating capacity is the simplest and most cost-effective way to do it. The wiring can be designed appropriately. The cost of equipment can be rolled into the overall financing of the project. Life safety codes already do specify, as we've heard, that buildings of a certain height need to have a backup generator. And as many new buildings already have those things worked into their plans. And to provide a sense of cost, looking at 3 buildings currently being constructed in Greater Portland, you see the cost of backup generators ranging from a low that we were able to find of $31,241 in one of them, up to about over $100,000 in a 2-building rehab. But for existing projects, the cost to retrofit and add a generator tends to be a lot higher. And the master variable is always building type. 24-unit garden-style apartment complex where the generator is keeping the lights and furnace on is a super different proposition than a 150-unit mid-rise with elevators, pumps, and all the things you need to run along with lights and furnace. And I think buildings, as we've heard, buildings with electric heat present a much larger set of considerations. Is that the end of the time?
It is. If you could wrap up, that would be
Sure.
That would be helpful, Eric.
So I just say that, I would like to talk about, the final thing I just want to say is that with really small subsidized elderly apartments, which are duplexes or triplexes that contain people that are in Section 8 vouchers, which are technically subsidized housing, those cases I think would be a landlord deal breaker. The small landlords already are really reluctant to rent to Section 8. We have a real crisis in housing affordability. And I think given the shortage of apartments, that's something to really think about as well. I'm happy to answer questions. I've got the whole thing sort of laid out more coherently in my written testimony, which you should have. Thank
We
you.
appreciate it. And we do have the testimony. It's very nice to see you again. I am going to ask if there are questions from committee members. Representative Evangelos.
Thank you, Mr. Chair. If you'll indulge me for a second. How's it going, Eric? You're looking good.
Thank you. It's going great. Thanks.
I'm glad you've landed on your feet, and we were good friends, and I miss you a lot. So it's good to see you, pal.
Nice to see you too. Thank you.
Thank you, Representative Evangelos. Representative Babbage.
Thank you, Mr. Chairman. Yes, former colleague didn't say hello to me, so I'll be a little tougher on him.
I never sat next to you, Mr. Representative Babbage.
Mr. Jorgensen, thank you for the testimony. It's helpful. And the $31,000 generator cost for one of those buildings, that was on the cheap end. How many units was that? You got any idea?
I don't know. We don't have a lot of that information on the retrofitting ones. Those are just something that our office knew about and had that information. I mean, I think the big question is something that Mr. Rothstein mentioned, and I think it's this idea of, are you just going to hook up the boiler so you can get heat, maybe some emergency lighting, or are you going to go the full thing and get, run the TVs and run the plugs and everything in everybody's apartment? And so I think thinking about what kind of generator or generation need you're going to have, or what kind of load you're going to have, is really the huge factor. So you can probably do as he suggested, you can probably do a much more economical installation if you're just going to run a furnace and some circulators.
Right. And I'm also cognizant of defining senior housing, or a senior for that matter, 55, 65, 72. Those of us that consider ourselves able-bodied, but I think. Let's see, was there something else I wanted to talk to you about in your testimony? I think not. I guess I'm very understanding of the closeness, of the financial realities of getting projects going and getting private contractors to agree to the specifications and so forth. So I know there's not a lot of wiggle room financially to get this going and make it, which is providing a need. But I do understand too that certain seniors who who are incapable of, and I'm talking about assisted living and all that. I don't know if Maine Housing has done assisted living specifically. Maybe you could help me with that. But I wondered if the requirements are different for assisted living housing than it would be for just general senior housing.
I don't know. I could speculate on it, but I'm not going to because I don't know. But I could find that out for the work session if you want.
Thanks so much. Thank you, Mr. Chairman. Good to see you again.
Nice to see you, Chris.
Thank you very much, Representative Babbage. Are there other questions, Senator Carney?
I don't have a question. I just also wanted to extend a warm welcome to Eric. It's nice to see you.
It's really good to be here. I see so many friends here. It's a wonderful, it's great to be able to travel around and see different committees virtually. And wonderful.
Thank you. Are there other questions from committee members? Representative Evangelos and Representative Babbage.
Babbage still has his hand up.
I understand. I'm trying to be kinder and gentler.
Touche. Yeah.
Just wanted to let everyone know Representative Jorgensen spent 4 years next to me, but then he moved. I guess he had had enough of me.
There's so many things that I could say right now, but none of them seem appropriate on YouTube.
Thank you, Mr. Chair.
Are there other questions for Mr. Jorgensen? Seeing none, thank you very much for your time today. We appreciate you being here and sharing.
Can I just finish by saying that, when I took this bill around to our different departments here who work on construction, they were very, very, they were like, this is really a good idea, but they weren't clear on how you do it economically. And so I think, there was this really interesting tension that came along. They were like, yeah, no one should ever get, frostbite in your apartment. I mean, Representative Head was talking about that and it was horrifying. That shouldn't happen. But hopefully there's a way of finding some way of, a middle ground here that might be workable. So thank you.
Thank you, Eric. And that is all that I have on my list of people that had signed up. And I'm going to go through the attendee room one more time to see if there's anybody else who wants to be heard on LD 660. And seeing none, I will just check with the clerk. Ms. Panetta, am I missing anything?
You are not, Mr. Chair.
Thank you. And with that, then I will, I thank everybody for their time and I will close the public hearing on LD 660. Thank you. We will now turn our attention to the second to last item on today's agenda, which is LD 679. And I will begin by, I see that we have the bill sponsor to present the bill and also a co-sponsor. So I'll begin with the bill's sponsor, Senator Keim. Welcome.
Thank you. I guess I missed the order. I thought I was still one before me. Good afternoon, everyone. Senator Carney, Representative Harnett, and esteemed colleagues of the Judiciary Committee. Thank you for allowing me to introduce LD 679, an act to establish a statewide electronic warrant system. As you all know, I am Lisa Keim. I live in Dixfield, and I'm proud to represent Senate District 18, which is the beautiful Western Maine Mountain region. This legislation stems from a report issued by the e-warrant working group in January of 2019. I have attached this report to my testimony. The working group determined that Maine should fund and implement a single, secure, encrypted, statewide online portal for the transmission, review, issuance, and/or denial of arrest and search warrants. The system should be internet-based with a direct virtual private network that encrypts the documents from the time sent to the time received. The working group further noted that The major advantage to such a system would be that requests for warrants will no longer be delayed because of or tied to geography. Many instances of officers having to travel long distances to courthouses or a jurist's home to present a paper warrant were discussed. An electronic system allows for real-time review from anywhere in the state. This will lead to faster, more efficient, and timely review of requests for warrants. The current process for obtaining a warrant is as follows. The warrant is drafted by the investigating officer, sometimes on the scene. The draft warrant is emailed to the DA or ADA for approval. Once approved, the officer returns to his or her department or barracks to print the warrant. Then an available judge must be located to physically sign, approve, and/or amend the warrant. Oftentimes, all the while, other law enforcement units are on the scene in standby mode. Access to justice has been one of my top priorities since becoming a member of this committee in 2017. An electronic warrant will help streamline one aspect of the judicial process. The pandemic has highlighted how important it is to be able to work from anywhere. Additionally, has greatly reduced the ability of our courts to function. Creating an electronic system will ensure that obtaining a warrant becomes less of a hurdle. I thank you for your time and consideration, and would also say that we've heard this bill several times in the Judiciary Committee, and it gets passed and then not funded. So it's perennial, but hopefully this is the year that we can do something about it.
Thank you very much, Senator Keim. Are there questions from committee members for your colleague? This is your shot. Senator Carney.
Thank you. First, I wanted to thank you, Senator Keim, for including your name and your hometown. I'm constantly forgetting that, and I appreciate that you got it, that you nailed it. I wanted to ask you a question about the impact of this legislation, because you talked about how it streamlines things and avoids delay, but does it also improve accuracy? I don't know if there's a problem with things getting lost or with errors occurring in the multiple steps that you laid out for the current process.
Well, I think that would be better answered probably from the courts or law enforcement, but from my experience and, which is just hearing about this bill, there isn't really, it does get emailed. There isn't a problem with accuracy. It's really just the delay that happens as you must go physically get a signature. So if there was going to be a problem with inaccuracies, I think it would happen, during the drafting of the warrant and it getting emailed to the ADA, but at the point of it actually getting signed, I would assume at that point that the document is pretty settled.
Thank you.
Thank you. Does that conclude your questioning, Senator Carney?
It does. It wasn't a complicated question. I just wanted to know if there were errors that would also be avoided. Thanks.
Thank you very much. Are there other questions for Senator Keim? Seeing none, again, thank you for introducing this bill, and you're welcome to stay for the rest of our meeting, Senator Keim. I would next.
Thank you so much.
You're very welcome. Maybe in for a while. I would like to now bring forward Senator Stacey Guerin, a co-sponsor of LD 679. Senator Guerin. As soon as you are unmuted and have activated your camera, feel free to proceed, and welcome to the Judiciary Committee.
Well, it is such a pleasure to be back at the Judiciary Committee, my committee of many years, and my greetings go out to Peggy and to Soupy, the best of the best, those two are. And sorry I can't bring you treats today, but when we're meeting in person again, believe me, when I come to Judiciary, I will be bringing treats for Soupy to handle and pass out for you. So thank you for having me today, Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. And thank you for allowing me to speak in favor of LD 679, an act to establish a statewide electronic warrant system. I am Senator Stacey Guerin from Glenburn. Currently, several hours to issue a warrant, especially in parts of the state where the nearest judge is a long drive away. An electric warrant system would speed up the current process and make it more convenient for justice and law enforcement officers as well. Additionally, it would allow for corrections to a warrant to be made immediately in the event there is a mistake or the judge would like a change, as Senator Carney had been mentioning. And from my time on the Judiciary Committee, when we had heard this bill in the past, there was testimony that there had been mistakes and inaccuracies that needed to be corrected, and they would have to go back to the judge a second time. Finally, there have been occasions where a warrant has been lost by the clerk of the courts. Mistakes happen, but an electronic warrant system would help reduce those mistakes. In many cases, it is of the essence when securing a warrant. It is important that our law enforcement officers have a system that does not require them to spend hours out of their shift obtaining a signature from a justice. I think we can all agree their time is better spent serving and protecting the public. It is time Maine adopted electronic warrant system and funded it. Doing so streamline the judicial process and allow for justice to do their job from anywhere. I think the pandemic has shown all of us how important that is. For your time.
Thank you very much, Senator Guerin. We appreciate you being here today to talk about your bill. Are there questions from committee members for Senator Guerin? Seeing none, again, I thank you very much for your time and for joining us this afternoon.
My pleasure. Thank you.
Thank you. I will now turn to, could ask the committee clerk, I don't see any in the waiting room. Are there other legislators who are here to testify on this LD?
There are none, Mr. Chair.
Thank you. I will now turn to those who've indicated they would be testifying in favor, and I will call them in the order that I have them. The first will be Andrew Robinson. Mr. Robinson, as soon as you're ready to go, welcome to the Judiciary Committee. And I will let everyone testifying from here on out know that we have a 3-minute limit on testimony. When you see me hold this up, it means you have about 10 seconds left. And that's designed to wrap up. So, Mr. Robinson.
Thank you. I will be brief. And from a lawyer, that means something. Good afternoon, Senator Carney and Representative Harnett and honorable members of the Judiciary Committee. My name is Andrew Robinson. I am a resident of Farmington, and I am the District Attorney for District 3. I'm here on behalf of the Maine Prosecutors Association to express our support for LD 679. We believe the goal of having a fully electronic warrant system would be beneficial to law enforcement agencies and is consistent with the general trend of modernizing our criminal justice system. We know the court has already taken measures to allow for the electronic warrant process under Rules 4 and 41C of the Maine Rules of Criminal Procedure. We believe this legislation will move us further towards a completely electronic system in keeping with the technology available to us today. And we thank you for allowing us to be heard in support of the legislation.
Thank you. That was under 50 seconds. You will be receiving a small gift in the mail by the end of the week. Very much appreciated. Are there questions for Mr. Robinson from members of the committee? Seeing none, thank you very much for taking the time out of your day to speak with us today, and we will keep you abreast of when work sessions are scheduled, etc.
Thank you. Take care.
Thank you. The next person on my list is John Pelletier on behalf of the Criminal Law Advisory Commission. It looks like I may have confused the clerk and taken people off a different list than she had up. So I will turn it over to Sheriff Troy Morton, who appears as a panelist now. Welcome, Sheriff Morton. If you could just unmute yourself and turn on your camera and begin your testimony whenever you feel comfortable.
Thank you, Representative. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Troy Morton. I gotta say this, I don't have the great radio voice that Representative Babbage has. I certainly want that. I think he's got a great radio voice. I am the Sheriff of Penobscot County and President of the Maine Sheriff's Association. Like last session, the Maine Sheriffs met to discuss this bill, and our position is to support LD 679. The public safety is negatively affected when arrest warrants information is not available to law enforcement, judges, prosecutors, and other criminal justice practitioners. An electric warrant system facilitates the sharing of information among all law enforcement concerning active warrants in the jurisdictions throughout the state. Kentucky rolled out the first model of this kind as a pilot project in 2005 and implemented it statewide in 2010. They saw service rates rise from as low as 10% under the traditional system to roughly 50% immediately after implementation. And now they're holding steady at approximately 80%. Some of the benefits to electronic warrant system include law enforcement officers can take quick action when they have probable cause. It reduces the possibility that the suspect will be warned before the warrant is actually executed. Automated processes can be used on any web-enabled mobile device. This also reduces overtime for law enforcement officers and off-duty interruptions of our judicial officers. It also allows more time to apprehend and convict criminals and less time processing paperwork. The Maine Sheriffs strongly urge you ought to pass on LD 679. I'm happy to answer any questions and even share a recent event where this would have been incredibly helpful if you're interested.
Thank you very much, Sheriff Morton. And it's always good to hear from you and get your input on legislation. I will now open it up for questioning from committee members. I will begin with my co-chair, Senator Carney.
Thank you. Sheriff Morton, I'm just curious, you mentioned that there are overtime expenses that would not have to be incurred if this legislation were implemented. Do you have any assessment of the cost savings?
I don't have an exact estimate. I think that's really based on what we can see happening as a practitioner of this. So there are often times as an incident, I live in, as you may know, Penobscot County, some parts of it extremely rural. When there's an event, we had an event yesterday in the northern part of my county. In that event, should I needed a warrant, I would have had to call out additional folks down here in the Bangor area that would have come in to actually write that warrant, because we're not going to travel from a scene up north down south to write the warrant. So I'm actually going to call out additional staff. That also, it obviously interrupts judges at different times of the days, and not to discuss the impact on them, but it's tremendous. But certainly there is cost, and I'm sure that's not just solely on the sheriff's offices. That happens with municipalities in the state as well.
Yeah, it would be nice to have an idea of those, just because I know Senator Keim said in introducing the bill that there's a concern about getting it funded. And if we can show the cost savings, that might be helpful in some ways. Thank you.
Thank you, Senator Carney. Representative Hagan.
Thank you, Mr. Chair. I would be interested in hearing more, and I'd like to hear your story.
So, and us as its representative, I just snuck it in there. So, yesterday there was an incident in northern Penobscot County in a rural area where there was the potential for the need for a warrant to be processed. And having the ability to obtain that warrant from that location, being able to use digital photographs that go to the affidavit, being able to send them electronically through the system to our judicial officers and process through that, what it could have, in this case, we didn't end up needing a warrant, but could have certainly shortened the period of time that we needed, put public safety at less risk, and potentially resolved a situation much quicker than than waiting the long periods of time. That's been an ongoing issue for many, many years. You know, I think often as I've sat from about 9 o'clock this morning, like most of you folks, on waiting to testify, there are tremendous benefits to what's happened now virtually, right? And we are seeing technology be an advantage in many applications. Here's one. And certainly moving to this direction with our warrants just makes sense.
Thank you very much.
Thank you, Representative Hagan. Representative Babich.
Yes, thank you very much, Mr. Chair. Thank you for the comment, Sheriff Morton. I want everybody to know that flattery does work with me. I want to ask you about the ease and efficiency that the electronic warrant would provide. Do you think that would impact the number of warrants requested?
Put it on mute there just for a second. We have fire trucks rolling by. That's downtown Bangor.
I'll lower my hand while we're talking here.
So your question again, sir, I had fire trucks driving by. I apologize.
Oh, I'm sorry. Yeah, I'm still on. I wanted to ask if you thought the ease and efficiency of the electronic system would impact the number of warrants requested.
But potentially, I know that it will certainly make the process smoother, and that's part of the issue. I think I heard one of the questions earlier to Senator Stacey Guerin about would it reduce errors, and I have to be honest with it. You know, a lot of writing and noting, going back and forth between judges and a prosecutor and a police officer. You know, usually in the middle of the night, right? That's when these are always the problem, not during the day when the courts are open. Could there be errors? When we're typing things and going through email, much cleaner, much more efficient, less chance, I believe, less chance for errors. So that may be an indirect answer to your question, but less chance for errors. That's the most important thing that we get here when we're trying to provide descriptions of individuals or descriptions of homes or businesses or wherever the warrant may be. It is critical that we have those timely and accurate.
Thank you, Sheriff. Thank you, Mr. Chair.
Thank you, Representative Babich. Representative Thorne.
Thank you, Mr. Chair. Sheriff Morton, hello.
Good afternoon, sir. Good to see you.
Good. I didn't know if you caught the memo that I had joined the Judiciary Committee as of Friday. So hello. And for all the other colleagues on Judiciary Committee, you may have good sheriffs in your regions, but you're talking to the finest one in the state right here.
That flattery works for me too, sir.
Earlier, Senator Kime mentioned that she had passed this, but it didn't get by appropriations. Is there anything that would have changed from the last time to this time on your end as far as reducing costs or making it more feasible in the state level?
Representative, I would have to refer back to Senator Kime, but I want to thank Senator Kime for bringing this forward again, because it's a tremendous bill. The cost on our end is going to be smaller. So I think the impact was potentially to the judiciary and whether there was a system that allowed it to do it. As I understand, and Senator Kime, please help me if I'm wrong here, one of the concerns was that this may go on to the Metro switch, and we found out that's not the case, that doesn't have to happen, but it would go through the judiciary system. So I don't see on the law enforcement end, I think this is a cost reduction, so I'm not sure how it's going to generate cost. I'm guessing that much of that potentially comes from the judicial side of building a system or having a system in place that works for them.
Thank you.
Thank you, Representative Thorne. Thank you, Sheriff Morton. Are there additional questions for Sheriff Morton? Seeing none, Representative Thorne, if I could have you lower your electronic hand, that would be wonderful. Thank you very much.
Senator Babbage.
Everybody has a role model. I will, seeing no more questions for Sheriff Morton, I want to thank you again for taking the time out to talk to us about this bill today. And it's my understanding, I'm going to take one quick look in the waiting room or the attendee room. that we have nobody else who is here to testify on this bill, either for or against, which leads us to our final category of neither for nor against. And I would welcome Julia Finn. Ms. Finn, whenever you're ready, you're unmuted and on camera. Welcome to the Judiciary Committee.
Thank you, Representative Harnett, Senator Carney, and esteemed members of the Judiciary Committee. My name is Julie Finn, and I represent the Judicial Branch. I reside and work in Portland, Maine, and I'm here to present some additional information on this bill. Just by way of background, as Senator Keim already alluded to, there was a similar bill in the 128th legislature, which is, I think, kind of where this idea first was started. At that time, the judicial branch supplied fiscal information for the necessary technology, software, and upgrades. And at that time, because the judicial branch had already contracted with Tyler Technologies for our e-filing system, we inquired about the potential costs of adding an e-warrants platform to our existing contract. At the time, Tyler did not have a product readily available for purchase. Thus, the cost of development of the product was part of our fiscal statement, making it very high indeed. Instead, the Judiciary Committee asked the judicial branch to form a stakeholders group and look into an electronic warrant system for Maine. That group, as Senator Keim made reference to, was formed in 2018. The working group was chaired by Superior Court Justice Dan Billings and included members from the judicial branch, law enforcement, prosecutors and defense attorneys, and other interested persons. They met 4 times, reviewed a considerable amount of information, and issued their report in January of 2019. I believe Senator Keim said it was attached to her testimony. I think I asked Peggy to circulate it as well, so you may have multiple copies. I think it's a very comprehensive and thorough report, and I would urge you to review that at some point when you get a chance. That group recommended that Maine fund and implement a single, secure, encrypted statewide online portal for the submission, review, issuance, and/or denial of arrest and search warrants. The group also made other recommendations that included funding and properly equipping both law enforcement and judicial officers with the technology and computer hardware necessary to initiate an effective e-warrant system. One factor that has changed since the last time this committee discussed an e-warrants bill is that Tyler has developed a product that is available for purchase, so we would not bear the costs of development. The costs, however, remain high. The annual cost of licensing for that system is $175,000 to $225,000, assuming that 1,500 officers would need access. There are other products available as well, which we could also look into. The cost of internal programming and purchasing the necessary equipment and technology for judges, justices, and possibly justices of the peace to have in their homes would also have to be determined. Any effort to specifically account for the cost to implement the system would have to be undertaken jointly with the Department of Public Safety. Because warrants are initiated by and executed by law enforcement, it would be critical to team up in order to determine costs and feasibility. Even the determination of costs would be very time consuming. It would involve examining different products and conducting demonstrations of them, as well as determining technical system requirements for both branches of government. It would also require an analysis of the compatibility of the different proposed products with the wide variety of computer systems in use by Maine law enforcement and the judicial branch. There's no question that a fully operational e-warrant system would be beneficial for Maine people. Maine courts issue about 2,000 search warrants and 1,500 arrest warrants on affidavits per year. With an electronic warrant system, it would no longer be necessary for officers to travel long distances to courthouses or a judge's home to present a paper warrant. An electronic warrant system allows for real-time review from anywhere in the state and would lead to faster, more efficient, and timely review of requests for warrants. However, the costs, both in terms of money and time, are significant. Thank you very much for your time.
Thank you very much, Ms. Finn, for presenting your testimony today. Are there questions from committee members for Ms. Finn? Seeing none, I again thank you. Representative Babich, you're using your human hand now, just playing with me. Go ahead, sir.
All right, I'm discombobulated. Thank you very much, Mr. Chairman. Ms. Finn, I wondered if there was any discussion or I asked Sheriff Morton a question, and I wondered about the burden on the judiciary, if that would change with regard to ease and efficient e-warrant system. Is there any concern about the number of warrants? No, I didn't know if it would increase, but and if it did, whether that would be good or bad, depending on warrants that need to be asked for, perhaps not because of difficulty, and then other warrants may be being asked for that are questionable. So, but I wondered on the side of the judges if there was a concern about burden.
That is not a concern that I've heard. You know, the warrants, of course, initiate with law enforcement, so I can't really say if there would be more of them as a result of this system. If judges receive more requests for a warrant, it would involve a bit more time, but that is not something that I've heard concern about here. I should also probably mention, I may have a little more information for you at a work session. I have spoken to some of the folks at Department of Public Safety, and our IT departments are planning to have a conversation at some point to talk about how this might happen. And I'm hoping to have more of that information for you later on.
Thank you.
Thank you, Representative Babich, and there's no need to lower your electronic hand. Representative Hagan.
Thank you again, Mr. Chair. I received a phone call in the middle of your testimony. It's nice to see you, Ms. Finn. You may have said it and I just didn't hear it. I knew that there was going to be a fiscal note here, and you were talking about some of the high costs. Did the judicial branch see that even though this does have a fairly decent price tag, that the value of the new system would outweigh the cost? Would this be something that we really should do for the people of Maine?
Absolutely. I mean, I think the branch fully agrees with the report that was issued by the working group, and that group recommended doing this. That group really looked at all the important issues and considered every angle, and their recommendation was to have this type of system initiated. I think the burden, as others have noted, has been the cost in terms of dollars.
Thank you.
Thank you, Representative Hagan. Are there other questions for Ms. Finn from members of the committee? Seeing none, again, thank you very much for taking time out of your day to present your testimony. Very much appreciated. Taking one last look in the attendee room, and everybody who is there appears to be here for our next bill. Am I missing anything, Committee Clerk Soupy?
No, you are not. Sorry.
Thank you. Then on that note, I will close the hearing on LD 679 and thank everyone who came in to talk to us about that today. I will now turn to our final public hearing of the day, which is LD 562. And again, we will use the regular procedure of moving people in as panelists. I will take testimony from the bill's sponsor, co-sponsors, other legislators, then those testifying in favor, those in opposition, and those testifying neither for nor against. And I have just received word that the sponsor of the bill is not here yet. I will. We take a 5-minute break to 4:45, but please don't feel the need to have to go away. Just shut your camera and mic off while we track down the bill's sponsor so we can proceed with the public hearing. I will see you in 5 minutes.
Welcome, Representative Talbot Ross. It's so nice to see you.
Nice to see you as well, Senator. Though you've had a long day, so.
We've done a lot of good work today.
Yep, indeed we have. And looks like we have a critical, let me see, 1, 2, 3, 4, 5, 6. We certainly have enough people to begin the hearing. So we are on our final public hearing of the day, which will be a public hearing on LD 562. And as I stated briefly before we took a short adjournment, I will first hear from the bill's sponsor, who will have an unlimited amount of time to speak. And then I will begin hearing from persons testifying in favor of the bill, any who might be opposed to the bill, and any who are neither for nor against. They will have a time limit of 3 minutes. I will hold up a clock when there's about 15 seconds left, and that's your sign to wrap up. It's not your sign to ignore me and look down at your notes like you don't see me. And with that, I would ask that all those testifying after the bill sponsor, please introduce yourself and your place of residence. So with that, I would open the public hearing on LD 562, and it's my pleasure to welcome the bill's sponsor, Representative Rachel Talbot Ross, to introduce the bill to the Judiciary Committee. Welcome, Representative.
Thank you so very much, Chair Harnett. It's a pleasure to see you all once again. My name is Rachel Talbot Ross. I represent House District 40, which comprises the Portland neighborhoods of Parkside, Bayside, East Bayside, Oakdale, and the University of Southern Maine campus. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary, I'm pleased to come before you to present LD 562, an act to enhance tribal state collaboration in the enforcement of child support. This bill is straightforward. It asks that federally recognized tribes in Maine with child support programs be given access to existing child support enforcement tools used by the state. Currently, the Penobscot Nation is the only tribe with a child support program in Maine. However, an effort is underway to develop an intertribal child support consortium. This program would allow all Maine tribes to carry the responsibility of enforcing and collecting child support for the children in their communities. There are currently 60 tribal child support programs in the United States, more than the number of state programs. But despite the success of these programs, some tribes still have limited access to the full array of enforcement tools mandated under federal child support enforcement laws. This leaves tribal children disadvantaged and prevents them from getting the support that they are entitled to receive. To ensure the children are provided for, Maine has previously authorized tribal child support agencies to suspend a parent's Maine driver's license for non-support. While the tribes have that authority, the Penobscot Nation has only exercised it once, and that was only when the parent refused to provide any support for his child. The challenge faced by the Penobscot Nation is that non-native, non-custodial parents believe that they are beyond the reach of the tribal child support agency. Those parents do not pay child support. They do not come to court, and the child suffers or goes on state aid. This dynamic with non-native parents severely curtails the tribe's ability to ensure children are taken care of. The problem does not exist with native non-custodial parents. The tribe has the authority to and has held native parents in contempt of court until they pay past support. LD 562 would allow federally recognized tribes in Maine to access 2 additional enforcement tools listed in the federal mandate and which are currently available to the state. the ability to suspend professional licenses, and the ability to access lottery winnings or debtor parents who are in the areas arrears on their child support payments. So two ways currently. Any license suspension would, just as the suspension of driver's licenses are now, be subject to review by the appropriate board or department, and then further review in state courts, just the same as state child enforcement actions. The Chief Justice of the Penobscot Tribal Court, Chief Justice Mainhart, who was going to testify today and provide all of the details, legal details for this bill. Unfortunately, he is no longer available, but he was going to be here. You will have his written testimony for any questions that you might have. The tribe's child support attorney and the program coordinator for the Penobscot Nation's Child Support Enforcement Agency are all going to testify later after me, not later this afternoon, but right after me. And so I will defer to them to provide more information on the technical aspects of the bill. But I thank you for your consideration. Some of you who are returning to the Judiciary Committee will remember this bill from last year, and it did not go forward because of the early adjournment, but some of you are very familiar with this bill, and I hope that we can count on you for support. I'm happy to answer any questions that you may have. Thank you.
Thank you very much, Representative Talbot Ross, and thank you for reintroducing this important piece of legislation. Are there questions for the bill's sponsor from members of the committee? Representative Moriarty. You're muted, Stephen.
Yeah, that's been muted for a while. Sorry. Thank you, Mr. Chair. Good afternoon, Representative Talbot Ross.
Hello.
I just wanted to review with you the new enforcement tools that the bill adds to the mix. I think you described them as the ability to suspend a professional license, and you referenced lottery winnings. Can you just point me to the professional license language?
If you're looking in the bill,
Yeah.
section under it's a pretty long bill, so hold on a minute.
Yeah, I know. I'm sorry. It
Okay.
certainly is.
So it's notice, I mean, the notice to licensing boards there. That's where it's at, under section
number?
1 with the notice to the licensing boards. They may revoke the license, refuse to issue under section 1E.
Okay. All right. And then intent of that portion.
I could just add that the information about the lottery is toward the end of the bill.
Yes, section 2. Mhm.
Right.
Are you,
The question was, I'm sorry, I may have gotten lost. What the point was about the reference in section 14 to watercraft, snowmobile, and ATV vehicle registrations.
I didn't hear a question, I'm sorry.
Oh, am I being heard?
I can
Yes.
hear you now, but I didn't hear a question as it related to 14.
Well, the question is, what is the point about the reference to watercraft, snowmobile, and ATV vehicle registration information?
I believe it's in order to take whatever kind of, that is included in the ways in which the licensing can be affected is through that vehicle registration information, similar to a driver's license.
So you're saying that the tribe could deny these licenses if there were child support debts?
That's correct, and the state can do so now. So none of this language puts the tribal court, the Penobscot Tribal Court, on par with the state, concurrent jurisdiction on this. So it doesn't add anything that is not currently enforceable for the state for non-payment by anyone in Maine right now for non-payment. This just puts the tribes on par with those regulations.
Okay, all right.
Yeah.
Mr. Chair, with your indulgence, I have one more question.
Go ahead, Representative.
At the very end, the reference is made to lump sum settlements in the workers' comp system. The summary says that there will be a set-off for lump sum settlements. But in the final section, which is 2360-C, I don't see that it has any language that says there will be an offset, unlike the language above for lottery winnings.
So we can check with the revisor's office on where that language exists, but I can't answer that question for you right now, but I can take a look at it and have it ready for you for the work session.
Okay.
The way that I read it, it does make it clear, but I certainly can provide more information for you.
Okay, good. Thanks very much.
Sure.
Thank you, Representative Moriarty. Next on my list was Representative Thorne.
Yes, thank you, Mr. Chair. Representative Talbot Ross, just as a point of clarity for me, at the beginning, the title, the name of the bill is an act to enhance tribal state collaboration in the enforcement of child support. And in the summary, it states the authorities of the Penobscot Nation. Just as a point of clarity for me, I was under the assumption that the Penobscot Nations, the Passamaquoddy, Micmac, and the Maliseets made up the Wabanaki tribe of Maine. Am I wrong in that understanding, or is this just only addressing Penobscot Nation as a tribe and not any of the other tribes I mentioned?
So you're correct in naming the Wabanaki nations, the 4 tribes that make up the Wabanaki. But because the Penobscot Nation is the only tribe with a child support program, this bill refers to that particular court.
All right. May I ask a follow-up question, Mr. Speaker? Mr. Chair, sorry.
Yes, sir.
Representative Talbot Ross, am I to believe that in the event that the other, I don't know if sub-tribal come up with their own, that they would need a separate bill from the Penobscot Nation bill, this one that you're presenting? So this only applies to the Penobscot Nation, not to the Passamaquoddy or the Maliseet or the Micmacs or any of the others?
Well, thank you for the question, Representative. At this time, the Penobscot Nation is the only one with the ability to enact this bill. So at this point in time, it would apply to the Penobscot Nation only. That is correct.
Thank you. That answers my question.
Thank you very much, Representative Thorne. Representative Newell.
Thank you, Mr. Chair. Good afternoon, Representative Talbot Ross.
I have a couple questions, but if I could just ask this question, I was kind of reviewing the testimony from the 129th in regards to the possibility of 11 federal, 11 methods for collection, as it would come from federal laws. But you just previously mentioned that the license suspensions and the lump sum set-offs, those are concurrent with state. Are those the only two methods that the state are currently utilizing at this time?
Thank you, Representative. Good to see you as well. I'm going to ask to defer that question to Sherry Mitchell, who will be testifying momentarily, so she can answer that question for you. I do not know. Thank you, Representative.
Thank you, Mr. Chair. Can I follow up?
Yes, go ahead, Representative.
Representative Talbot Ross, could you just kind of elaborate a little bit more on what you meant by enhancing collaboration between the state of Maine and tribes in the area of child support cases?
Sure. Thank you for the question. So even if this bill passes, the state still ultimately has the authority on these cases. And it's because once a decision has been made to repeal a license or take any action against the debtor, that debtor can appeal the case. If it's in tribal court, it would be to the tribes. If it's in state court, it would be to the state. They, as an individual, they can appeal the decision. But if it were a decision made within the tribal court and they lose the appeal, they can still further appeal the decision to the state court. So ultimately, the state has still got the authority over these cases, even though we would see the enhancement of the tribal state collaboration if this bill were to go through. But ultimately, it's the state that could still decide the outcomes of these particular cases. So we're enhancing the collaboration, but the state still has the ultimate authority because of the appeal process.
Thank you, Representative. Do you have additional questions, or are you all set for now?
I will hold off for now. I do have additional questions. Thank you.
Okay, thank you. Representative Hagan.
Thank you, Mr. Chair. It's nice to see you, Representative.
Yes.
Great to see you again. I just have a couple of questions that I need clarification on, probably pretty easy for you. We are in Maine and the tribal members are Maine citizens. So doesn't Maine law protect all of the tribal members equally? Or am I missing something here?
Well, thank you, Representative. Yes, Maine law does protect all Mainers equally. This bill actually is talking about those non-native, non-custodial parents who are not fulfilling their obligations to their children who have membership within a tribal nation. So they're really talking about two different things here. We're talking about children who have a parent or parents who are not fulfilling their obligations to their livelihoods. And there is no mechanism that the tribes have currently, the Penobscot Nation, to ensure that that non-native, non-custodial parent fulfills that obligation. So the Penobscot Nation is asking for concurrent jurisdiction in that matter to ensure that children are taken care of. And I must say again that this bill is not asking for any special treatment. It's not going above and beyond what the state currently requires for all Maine citizens. It is merely respecting the tribal child support agency in their role and trusting that the tribal court is able to fulfill any kind of adjudication for these matters, and then allowing for the appeal process, should it be necessary, to start with the tribes and end with the state. So this is a bill that respects the tribal child support agency and the tribal courts to be able to take care of children who have membership within the Penobscot Nation, which is different than does state law protect all Mainers. They're very different things, but I would agree with you. Yes, state law does protect all Mainers.
Okay, and I knew that I had missed something, and I did with the non-tribal members. So thank you very much. I appreciate that.
Absolutely.
That was a very good answer.
Thank you, Representative.
Thank you, Representative Hagan and Representative Talbot Ross. Representative Babbage.
Thank you very much, Mr. Chairman, and welcome again, Representative Talbot Ross. I miss my seatmate, but I guess I have no seatmates right now. So
yeah.
We the Violence Against Women Act that we did last year, which we're all very proud of, exposed the different the impact that could have. With regard to, I wondered if you could help us with the state of collaboration right now, at the status quo with regarding child support payments and so forth. How would this change the status quo?
So I'm going to defer to Attorney Mitchell to answer that question, to speak directly on behalf of the tribes. I would just respectfully add my own personal understanding, which is the higher percent, there is a higher percentage of non-native, non-custodial parents than native custodial, non-custodial parents that are not fulfilling their obligations, their fiduciary obligations to take care of their children. The percentage of non-native, non-custodial parents is higher than native parents. And that we need a mechanism, we meaning the state of Maine, this is in all of our best interest. This is not special interest. This is in all of our best interest to allow for the tribal child support agency to do their work and to allow for the tribal court to do its work. And so that's my own personal take. That's why I'm a proud sponsor of this bill, and I'm hoping that the committee agrees with me.
I appreciate you bringing the bill forward. My question was along the lines of, is it a matter that the state is not being pursued, or is it a matter of non-collaboration on the state's part, or both? That's kind of. So thank you, but thank you for bringing this forward. Appreciate it.
Absolutely, Representative.
Thank you, Representative Babbage. Representative Newell. You're muted, Representative.
Thank you, Mr. Chair. I think my question is related to whether or not there are amounts that have been determined as outstanding.
Thank you, Representative. If the Chief Judge was with us today, I'm sure that he would be able to give you that amount. But I know that Molly Dana, who is the program coordinator for the Tribal Child Support Agency, should be able to provide that answer to you. And I know she's planning to testify this afternoon.
Thank you.
Thank you, Representative Newell and Representative Talbot Ross. Are there additional questions from committee members for the bill's sponsor, Representative Libby?
Thank you very much, Mr. Chair, and thank you for being here today, Representative Talbot Ross. Excuse me, this is going to be a very elementary question. I'm trying to wrap my head around. It is a long bill, but it seems to boil down pretty simply, though, if I'm understanding it correctly. So is my understanding correct that the only real change to the law is that this allows tribal jurisdiction over a non-tribal, non-custodial parent, but that the same fees and penalties and all of that apply? It's just a change in jurisdiction. Is that correct, or am I missing something?
No, it allows, thank you for the question, Representative. It does put the Penobscot Nation on parallel to the state, DHHS and the state court systems in order to adjudicate non-native, non-custodial parents. Because as I stated in my testimony, there really is not a problem in adjudicating Native parents who end up in this situation.
Thank you very much. That helped answer my question.
Thank you, Representative. Are there additional questions for Representative Talbot Ross? Seeing none, always good to see you. Thank you for bringing this bill forward, and you are welcome to stay as a panelist as we finish the hearing on your bill.
Thank you very much. Thank you all for your attention and your time today. Appreciate it.
And with that, I am going to follow the lead of my very sharp committee clerk and call on the people as she slides them over to the panelist category. And the first person that we will be hearing from in favor of LD 562 is Ambassador Molly and Dana. Welcome, Ambassador, and as soon as you're comfortable, you can begin your testimony, and we look forward to hearing from you.
Great, thank you, Mr. Chair. Good afternoon, Representative Harnett and Senator Carney and members of the committee. My name is Molly and Dana. I serve as the Tribal Ambassador for the Penobscot Nation. You will also hear from Molly Dana today, and we are two different people. It's rare that we're on the same Zoom, so it's kind of cool. I can be very quick. We do have experts coming up behind me. This is the second hearing today. I've kind of gotten to warm up everyone for the real heavy hitters coming through. And I'm very happy to do so. And I would like to express gratitude to Representative Talbot Ross for bringing this bill forward. Again, I was excited to see it in the last go around the legislature. I feel like we had some good discussions around it. So I'm equally enthusiastic now. I think that the theme with a lot of the work we are doing right now in the tribal state relationship is all about healing, equity, fairness, and rebuilding trust and clarity. And this bill, I think, really seeks to do that in a way that puts in place some really meaningful collaboration and makes some really simple and straightforward and good changes to our current system. I don't think there's too much more to elaborate on. We've been over kind of the mechanics. There really are only a couple of key changes, and it is really about equality, and it's not giving the Penobscot Nation anything extra. So I think that about does it for me. I just wanted to make sure that I was live and in person to share my support today. And I think this is a really great effort to improve the lives of a lot of families that really need it. You know, I've lived on the Penobscot Nation my whole life, and I've certainly seen some real life examples where there is a gap here in enforcement and families and children do suffer. So thank you so much. I'm happy to take any questions, but I'll remind you that we do have some real great experts on this coming up after me. Thank you. Great to see you all.
Thank you, Ambassador Dana. Are there any questions from committee members for the ambassador? Seeing none, thank you very much for taking the time to share your thoughts with us today. We very much appreciate it.
Thank you.
Going to the next person testifying in favor, and I'm wondering if this is Molly Dana, because then I won't mess up her first name that I have typed in front of me, which is Arundella Dana.
Yes.
If you could turn your video on and begin your testimony. Welcome to the Judiciary Committee.
Okay.
So go ahead when you feel comfortable.
Okay. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Arundella Dana. I have worked for the Penobscot Nation for the last 13 years. And while everybody was talking, I was like, I could answer those questions. What I wanted to state first that would probably help people is that there were not tribal child support programs. We're the only one in Maine. So we're just kind of, it's brand new, even though my program has been around since 2008 was when we received comprehensive status. And that means we're opening our doors and we're handling cases. So with that, the main state law, so the tribal law was trying to just get on the even playing field. So this really isn't asking for anything addition. It is exactly what Rachel Talbot Ross mentioned. It's putting the tribes on an even, just an even field with what the state can already do. So again, it's not asking for anything additional. It's just asking that we be included in the processes that the state already is doing. And it's not that way right now because we have not had tribal child support programs, and still we're the only one in the state and in the region. So so that's why, like, we can do policy on our end, but then when we go to carry it out, it has to it has to have laws behind it for the state to be able to honor what the tribe is doing. So does that help a little bit with what people were wondering? Yeah. So also, like I said, I worked for the tribe for 13 years. The tribe is also just trying to get things in line so that we're able to do as much independently as possible. We know we can ask the state for help, and under the under UIFSA and the, for full faith and credit and all of that stuff, that's the state does have, the state would assist us, and we do have a great relationship with the office out of Bangor and the regional program manager there, which I'm very thankful for. But it's just trying to get the tribe to, it's our sovereign right to handle the issues that we handle tribal issues. So this is just putting us on the, like I said, it's we also assist the state of Maine with cases. We assist any other tribal program as well. If they ask us for assistance, we actually, our federal regulations do require us to assist. So we follow the federal regulation 45 CFR 309 for our guidance on how we run our program. And we also follow Maine Title 19A for the calculations of our child support. So it's so we're doing the same thing. We wanted to make it that way so that people can't, kind of shop around for the best deal on child support. So we do follow the Maine Title 19A guidelines on that as well. Yep. And I'm all done.
Thank you very much, Ms. Dana. And thank you for, you answered some questions, so I felt badly keeping you on the 3-minute clock. Are there questions from committee members for Ms. Dana? Representative Newell.
Thank you, Mr. Chair. Good afternoon, Ms. Dana.
Hello.
I just wanted to kind of go back to the previous question that Representative Talbot Ross deferred, and that was the one that I asked about past due support amounts. Have you an idea of what those outstanding amounts are?
We honestly, we do not, but we can definitely add that. So we did have to do that for the license suspension because we needed some sort of indicator of when we would kick that into action. So if I'm able to, I'm sorry if I'm misspeaking, but if we're able to, we can determine an amount.
Thank you.
Yes, you're welcome.
Any other questions, Representative Newell, or are you all set? Or Senator Carney.
Thank you for appearing before us this afternoon, and also your explanation was really clear. I just wanted to ask you one question to make sure that I understood it right. It seemed as though you were saying that when the tribal court calculates child support, they use the same calculations as the state does in Title 19A?
Yes.
That's great. So I can see exactly how you're working to kind of fit the systems together so that they can work in a really coordinated way.
Yes, exactly. And that is the goal. That's the ultimate goal. Yes.
Great. Thank you.
You're welcome.
Thank you, Senator Carney. Are there additional questions for Ms. Dana from committee members? Seeing none, thank you very much for taking time out of your day to explain some of the parts of the bill we were having difficulty grappling with. We really appreciate your time and expertise.
All right, thank you.
Thank you. And the next, and I believe final person that I have on my list of folks testifying in favor of LD 562. This is sort of old colleague day for me, is another former colleague by the Sherry Mitchell. Ms. Mitchell, welcome to the Judiciary Committee. As soon as you're slid over, go ahead and unmute your mic and turn on your video and begin your testimony when you're comfortable. You're still on mute, but your video seems to be on.
I was booted out of the room, Tom. Did you just call on me?
I did, and I did not boot you. You were shifted over to this room.
Yeah, I was lost at somewhere in the ethers for a few moments.
It does happen. Nice to see you, Sherry. Welcome to the Judiciary Committee, and as soon as you feel comfortable, please begin your testimony.
Thank you. Senator Carney, Representative Harnett, and esteemed members of the Committee on the Judiciary, I would like to thank you for hearing my testimony this afternoon and for recognize the long day that you've had. I'd like to also acknowledge Representative Newell and Representative Talbot Ross and say hello to them as well. My name is Sherry Mitchell. I'm the attorney for the Penobscot Nation Child Support Agency, and I'm also a citizen of the Penobscot Nation. And I am here to provide testimony in support of LD 562, an act to enhance tribal state collaboration in the enforcement of child support. Rather than going over, you have my written testimony. There are things that have not been addressed in my written testimony that I would like to address during my time. I also am happy to answer questions, including clarification on the status of the tribes for Representative Thorne and some of the other questions that came up. Primarily, I would like to address just some points of clarification. My understanding is that the Attorney General's office has put forward some concerns regarding jurisdiction of the tribe in relation to this matter. And I think that's a common point of confusion because people often just look to the Settlement Act and they say, oh, these things that are listed out are the only things that are included in the jurisdictional picture for tribal communities, tribal nations, and that's not true. The Supreme Court has ruled on this in regard to civil jurisdiction. And as a general rule, tribes cannot exercise criminal or civil jurisdiction over non-members. There are very clearly articulated areas where tribes can do so. And there are 3 exceptions to this rule for civil jurisdiction. The first one is tribes may exercise jurisdiction over non-members who enter consensual relationships with the tribe or its members. And I think in this case where there are children resulting, we can make an assumption, which may not always be correct, that it was a consensual relationship that was entered into by the non-custodial parent. The second is that tribes may exercise jurisdiction over non-members within a reservation when the non-member's conduct threatens or has some direct effect on the political integrity, economic security, or the health and welfare of the tribe. Certainly the welfare of our children is a concern for tribes, and this falls very clearly within those first 2 exceptions for civil jurisdiction. The third one is a congressional grant of jurisdiction, and that those exceptions, the first 2 specifically, are enunciated in the case of Montana versus United States, which is a Supreme Court decision. So I wanted to clarify that point because I know that that's something that has a question that's been coming up. Also, I wanted to talk about the mechanisms that are available to the state. There's a number of clearly delineated tools that are available to the state under 19A. The state has access to every single one of them. The tribes only have access to the ones that we've outlined thus far. And so the state has a considerable number of additional mechanisms that it can employ, such as putting liens on people's properties, amongst a number of other things. So the tribe is still not getting the full panoply of mechanisms that are available for collection. And also, I would just like to add that the passage of this really takes an incredible burden off the state, because the state's caseload is pretty excessive. There's an extreme overburden on the state's child support enforcement agencies. And so it's really important to understand that this is beneficial not only for the Penobscot Nation, but it's incredibly beneficial for the state of Maine. And I believe that my time is up. Thank you.
Thank you very much, Ms. Mitchell. We greatly appreciate your being here today and your availability for questions. So I will now open it up to committee members. Are there any questions for Ms. Mitchell? Representative Newell and then Senator Carney. Representative Newell.
Thank you, Mr. Chair. Good afternoon, Nidap.
Good afternoon.
Dengak.
Mitch, Gilda.
Omejide, Chiwiliwan. I think my question would be to you. When I asked this question to Representative Talbot Ross, in the methods that are available, I think in your testimony that I reviewed from the 129th, there were what I counted 11 methods. However, you just kind of spoke about that. If we're talking, alignment or parity with, the methods and tools available by the state, was there consideration, with this bill to implement all other methods that the state are currently utilizing?
Well, I can't speak to whether or not that was considered during the drafting of this bill because I wasn't a party to the draft. And so I don't know what discussions were had in the process of making the determination about what would be included in this bill. What I do know is that the mechanisms that are being requested are those that we feel would be most effective in helping us to meet our goals, and are, quite frankly, within our capacity to be able to manage. We don't want to be managing some of these other mechanisms that require a pretty sophisticated legal apparatus to maneuver. And so what's being proposed are mechanisms that would be effective for us, would help to lift the burden from the state, and would be a relatively easy lift for all of us at this point in time. As Molly or Awandila says, has said that the Tribal Child Support Agency is not new. It's been around for 13 years. However, moving for greater inclusion into the process of enforcement in alignment with the state is fairly new. And so, we're not interested in taking on more than we can handle at this point in time as we move more directly into that stage of enforcement. We don't want to overload our courts. We don't want to overload the staff at this point in time.
Thank you. Williwan.
You're welcome.
Thank you, Representative Newell. Senator Carney.
Thank you very much, Chair. Ms. Mitchell, it's nice to see you this afternoon. I have a kind of a simple question. You had referred to some comments about the civil jurisdiction from the Attorney General's office, and I just checked and I didn't see them on the website. And I was and I could totally be forgetting at the end of this busy day whether I've even received them yet. But where did you see those civil jurisdiction comments? And
they
could you
came
pass
up,
them on to us?
Yeah, thank you, Senator Carney. Those came up during the last discussion that we had the last time that we all came together in the last session to discuss this. Those jurisdictional questions were quite prevalent. And my understanding is that there's been some discussion going on related to jurisdictional questions. And so I figured that I would just offer the information in advance in case those came up again while I had the opportunity.
Yeah, thank you for mentioning it. I appreciate that.
Thank you, Senator Carney. Representative Hagan.
Thank you, Mr. Chair. I have understandings from a year and 2 years ago that the tribal district court is a Maine district court that follows all of the Maine laws in statute. And you're saying that, or I'm hearing that you're saying, and I could stand corrected, of course, and that's why I'm asking this question. It's more of a clarifying thing for me, that tribes cannot exercise against non-native citizens. We did the VAWA bill last year where they can do that, and it was made known to me during that process that the district court with the Passamaquoddy and the Penobscot tribes are completely perfect district courts who observe all the laws of Maine. So in my mind, I'm thinking, if the district court on for the Penobscot has difficulty, I don't understand how they would have difficulty in doing any prosecution of any citizen of Maine, because that's what we all are, as citizens of Maine. And certainly if it doesn't go to say the Penobscot District Court, it goes immediately to the Bangor District Court, is my understanding. And all citizens of Maine enjoy all of the laws and rules that are in statute for all of us on all of these very important things, extremely important. So I don't understand. I guess I asked it earlier and I thought I understood it, but I fail to understand how this bill does anything to help the tribal members where they all enjoy I think you had mentioned there were 11 items that the state of Maine can do, but only one for the tribal district court. And we spent a whole lot of time learning about tribal law and district court and all of that kind of thing. So if I'm making any sense to you, in my mind, my brain is just tied right up in knots. And if you could somehow get me straight.
Thank you for your question, Representative Hagan. Well, the tribal court is not a district court in the state of Maine. It's the Penobscot Nation's sovereign tribal court. We have full faith and credit with the state of Maine courts, just as any foreign court would. So that area needs clarification. Also, I guess if you've had education on tribal law and tribal courts, I'm not sure where the confusion is coming from. The mechanisms for being able to access tools that are commonly used by every other child support department in the state, being able to be accessed by the Penobscot Nation, is something that just is common sense in regard to being able to exercise not only our sovereign rights, but also to fulfill the responsibilities of the office that are outlined under federal regulation. Currently, the lack of allowance within the state of Maine for being able to access mechanisms for enforcement makes it difficult for the Penobscot Nation Child Support Agency to meet its requirements under federal law, because we don't have the enforcement mechanisms required to be able to enforce the cases that we have within our caseload. And so the only way for us to do that would be to give up our sovereign right to be able to engage in the management of our own government systems, right? Self-determination, self-government. We are a self-governing entity recognized by both the United States government and the state of Maine as sovereigns. And so it is our sovereign right to be able to self-govern. Part of that government is running a child support agency for our citizens. And some of those citizens are children whose parents are non-native and non-custodial parents who are not paying their child support. And that's why we're here today to discuss that.
So can I do a follow-up?
Yes, Representative.
Yeah? Okay. So I guess I'm understanding that we're all under federal law and state law. And the tribe wants to be able to prosecute non-tribal members in tribal district court. And is that the bill? And because I know that as citizens of Maine and the United States, tribal members, all Maine citizens, have all of the rights under the statutes of law in the state of Maine and federal government. So is this bill designed to go with the big bill that's coming down the road that was, knocked out by COVID? What's the, I guess I don't understand. Is this just a thing to separate the tribes completely from the state of Maine and go completely under federal Indian law, as stated last year by the big bill? Is this something that goes with that? Because everybody enjoys, as Maine citizens and citizens of the United States of America, we're all under federal and state law. So is this just a breakaway so that the sovereign rights become an independent and free nation? So now you can try non-tribal members under this as well as maybe others down the road.
Representative Hagan, I'm happy to answer your questions, but I feel like there's a real lack of understanding about what we're talking about here.
That's why I'm asking.
We're not prosecuting anybody because this is not about bringing criminal non-payment of child support cases. These are civil matters. We're already hearing these civil matters. We're already hearing these civil matters for non-tribal, non-custodial parents. All we're doing is we're adding enforcement mechanisms that allow us to be able to follow up on the enforcement actions that we are already handling within our tribal court. And so this is not
I'm not a lawyer.
Yeah, this is not a prosecutorial issue. And also, I just want to reiterate that we are not district courts of Maine. The tribal courts are the distinct tribal courts of sovereign nations. And we have a relationship with the state of Maine, what's recognized under the law as a foreign court, have a full faith and credit relationship with the state of Maine. So that lack of understanding, I think, is hindering you from being able to grasp how this all comes together.
And hence my questions, and you are a lawyer in great standing, and I'm a teacher that doesn't do this kind of thing.
Yeah,
so
it's complicated.
For me, it's critical to get my brain wrapped around the correct way. Yeah. I hope I don't hurt anybody's feelings or anything in my questioning, but I have to understand this thing so that I can make the right determination, obviously.
Absolutely.
And clearly, through my past experience and of learning about things that I didn't know anything about, and now this one here, as related to my memory of what was more than a year ago with the shutdown of COVID, just trying to understand. So yeah, no question, I do not have the best understanding, but this is why I'm asking you. You're the lead attorney, and you're going to have a lot of answers that I didn't have. So
yeah, I mean, I think it's really important to recognize that this is not an extension of jurisdiction over matters. This is an extension of enforcement mechanisms that are required in order to be able to follow through. They give teeth to enforcement actions that were already issued. And so all this does is it gives us an opportunity to actually enforce the orders that are already being issued by our court. So it's not an extension of jurisdiction, and it's certainly not a prosecutorial issue. We're not prosecuting people.
Well, I thank you for everything, and I'm sure I'll have more stuff, and I appreciate all your help. Thank you.
Thank you, Representative Hagan. And might I remind the committee members, I know it's very late in the day, the laws and rights of our First Nations is a very big topic. It's not what we're talking about today. We're talking about a child support bill, child support enforcement, about authorities that already exist. I would next turn to Representative Moriarty.
Thank you, Mr. Chair, and good evening, Attorney Mitchell. It's almost actually time to say good evening, I suppose. A couple of very quick historical questions. Is this the same bill that was before the 129th?
I think that question would probably be better asked of Representative Talbot Ross. And I will defer to her on the answer to that question.
All right, follow up. Do you know what the fate of the earlier bill was? Was it approved by committee, or did it simply die in the process when we adjourned?
Again, I will defer to Representative Talbot Ross. This is her bill, and I would like for her to be able to answer those questions.
Okay, thanks.
Representative Talbot Ross, did you want to address that?
Certainly, thank you for the question. The bill died along with 454 other bills, 453 other bills because of the early adjournment based on the pandemic.
Representative Moriarty, you had a follow-up?
Well, my first question was whether this is the identical bill or not.
Yes, this is the bill that was authored in part by the Attorney General's office and the Chief Justice for the Penobscot Tribal Court and others. But this is the version, this version of the bill is where we left off last session, if that's the question.
And did it receive a committee vote prior to adjournment?
It did.
And that vote was?
I don't know what the exact vote was, but I'm sure we can find out for you, Representative. It did pass out of the Judiciary Committee.
Voted ought to pass then?
We could probably get the exact information for you from your legislative analyst.
Okay, that's good. Thank you.
Thank you, Representative Moriarty and Representative Talbot Ross. Turning back to questions for Ms. Mitchell, Senator Carney.
Well, I'm embarrassed to say I don't have a question. I've just been following the dialogue and wanted everyone to remember that we will have a work session and we'll actually have access to a lot of these resources at the work session that might be able to clarify misunderstandings. And just wanted to put that out there as a reminder.
Thank you, Senator. Are there additional questions for Ms. Mitchell from committee members? Seeing none, it was very nice to see you again. Thank you very much for your time and expertise, and I suspect we will see you at the work session in the near future.
Representative Arnett.
Yes. Yes, Soupy?
Hi.
Hello?
I'm here.
I thought you were asking me something. I'm sorry.
No.
Oh, thank you very much, Ms. Mitchell. Soupy, am I correct that there are no other people in the waiting room to testify on LD 562?
You are correct, Mr. Chair.
Thank you. And with that, having received testimony from all those present today, I will now close the public hearing on LD 562. I want to thank all of the committee members, committee staff, and all of the folks that came before us today. This has been a long but productive day. I thank you all for your time and attention. And we will be gathering tomorrow morning at 10 o'clock for a series of work sessions. I see Representative Thorne.
Yes, I just wanted to make sure There was earlier indication that I may be in the committee room tomorrow, but I will not. I'll be Zooming from my home office.
Okay, thank you, sir.
Thank you.
And again, we were on at 10 o'clock tomorrow. The committee Democrats, we will be caucusing at our regular time of 9 a.m. We'll get a link out to you in the morning. So with that, unless there are other comments or questions, I would entertain a motion to adjourn. And we have
So move.
second, and we are all done for the day. Again, thank you all very much. Peggy, you're good?
Nope, I'm still working on a couple of the bill analyses for tomorrow's work session. I've emailed the ones I've finished, and they're also posted in that handy dandy electronic LD file, if you remember how to get there. And there a couple more things have come in. There's been a memo from the Maine Hospital Association, and everything that comes in, I'm throwing it into that system. And if you need me to, I will also email those directly to you. So if you know how to use that system, you don't have to look at those documents that are attached to the email.
Okay, thank you very much, Peggy. Greatly appreciated. And with that, I wish everybody a nice evening. See you all tomorrow morning.
Bye, everybody.
Hey, good night now.
Right.